Actually, may I be permitted to mention a matter for correction?
Yes, please. As to be mentioned within bracket correction.
To be mentioned, লিখে দেবো?
Yes, yes. Write down to be mentioned within bracket correction. Yes, follow.
What that means, item number 1.
I'm for the respondent number 25.
In such view of the matter, the appeal succeeds. Accordingly, FMAT such and such is allowed on contest, thereby setting aside the impugned order dated December 22nd, 2021, passed by Civil Judge Junior Division, Senior Division. Can 1 and 2 of 2024 also stand disposed of accordingly? No arrest to cost. Yes. Thereby setting aside.
Not to change the nature
And that automatically goes. The appeal has been disposed of. Yes.
Item number
May I for the rest?
This has come at my instance, but kindly see the order dated 22 August 2024. Right?
Yes, 22nd August. Yes.
Para 3, Lord.
Para 22nd August.
Last order.
Yes, has taken steps of being records have not yet come.
And paragraph 8.
Not paid.
No.
You are the respondent.
I am petition appellant.
So you
Why-
are to pay.
Why appellant?
Or respondent to pay. Yes, Mr. Mukherjee, why not?
This will be paying today. In the
Today?
course of the day.
We'll record that.
Lordship kindly records.
And what about the records?
No,
Yes.
Till date,
My
no
lord,
record has
the
been.
appeal had been filed in 13th February 2020.
Yes.
But we
Steps have
could
not been taken.
We could not prepare the paper book as such. Lord, kindly see the paragraph 3. The order dated reveals that way back such and such there was a direction for bringing the lower court records and for preparation of paper books. Pursuant thereto, the learned counsel for the appellant has deposited the special messenger cost. And we find that the department has taken steps for bringing the trial court records, but the same does not appear to have been received till date.
Well, we'll direct the department to furnish another report and we'll record that Mr. Mukherjee's client will be paying the money today.
In the course of the day.
Thank you.
Course of the day, I'll hand over the check.
Learned counsel appearing for the appellant submits that with the order dated August 22, 2024, the appellant the respondent had been directed to pay an amount of rupees 1 lakh to the appellant, which has till date not been paid. Push up next para. On query of court, learned counsel for the respondent submits that the said amount shall be paid by the respondent to the appellant through the latter apostrophe counsel during the course of the day. Push up next para. It is also pointed out that despite special messenger costs having been deposited, the trial court records have not yet arrived. Push up. The office shall furnish a report on January 6, 2025 as to whether the trial court records have arrived. Push up the matter be placed in the list on the said date under the heading to be mentioned for passing further orders.
Great. My lord, what has happened? My learned friend, after my learned friend's appeal has been filed, but before, without the knowledge, I have remarried. No, not after.
So we'll consider that.
Because now,
Pay the money first, then we'll consider the rest.
now it will be only question of.
item number 3.
After the respondent.
Why appearing as to be mentioned? Can you tell us?
At my instance,
Yes, why?
applicant has
We were not served mentioning notice on.
Let us hear why. Yes.
Lordship, we have filed an application, an affidavit in opposition against his can file application for the withdrawal of the bequeathal amount, your lordship. I am led by my counsel, your
Have you
lordship.
mentioned that application for inclusion in the list?
Your lordship, my learned friend had mentioned it.
So let us hear them, please.
Lordship, we
Let
have-
us hear them, please. Yes.
If the appeal was filed with the applicant of the being agreed by the order.
Why have you mentioned it?
Because the appeal has been instructed.
Why?
It's an appeal referred against the decree of eviction. During the pendency of the appeal, they have already vacated the place and handed over the premises to the landlord.
To you?
Sure.
No, they may continue, they choose to continue the appeal and then ask for restitution if they win the appeal under 144.
Location has been taken out that they has been also placed there, wish to withdraw the same, but as the formal application.
We'll consider that. What is your application number?
Where it is there.
What is your application number?
That's the opposition to I can.
Their can file application, your lordship. And
So
also-
your application has to be taken out, has to be heard. You want a withdrawal of the amount.
That's that main degree.
So you don't want to press that, application, then no difficulty. You have mentioned this for recording that this appeal has become infructuous. Do you still want to proceed with the appeal? Then very well, we'll take up your.
Then the matter is harder.
Learned counsel for the respondent number 1 submits that the appeal has been rendered infructuous. Push up, the appeal was preferred against an eviction decree, and in the meantime, position has been taken in pursuance of the decree. Push up next para. However, learned counsel for the appellant submits on the query of court that the appellant wants to proceed with the appeal. Push up, in fact, since a remedy under section 144 of the Code of Civil Procedure is available to the appellant in the event the appeal succeeds, we are of the opinion that it is premature to say that the appeal has been rendered infructuous, particularly since the appellant wants to proceed with the appeal. Push up, learned counsel for the appellant submits that an application at the behest of the respondent number 1 is still pending. Can 5.
Yes, your lordship.
Bearing can number 5 of 2024, pushed up. Accordingly, can 5 of 2024 be placed in the list, placed in the monthly list of January 2025 under the appropriate heading. That application will appear in the monthly list of January. Monthly list. You did not mention the application also.
No, I mentioned at that time.
Yes, next.
Item number 4.
Why to be mentioned? Yes, Mr. Mukherjee, why?
First me,
Yes.
the order of appeal on instant range was passed. Directly asked to. And we next day,
Right.
because did not turn up, we wrote a letter to the learned register on 24th September.
That's
But nothing, because by this time, without injunction, we are raising construction rapidly. So we want to get the hard expeditiously, accordingly, to directed.
Let us just once check it.
First me, the order was.
It transpires that the trial court records have not yet arrived, as pointed out by learned counsel appearing for the appellant. Full stop. Next para, the office shall file a fresh report as to whether the records have arrived till date. Full stop. For such purpose, the matter be placed in the list under the heading to be mentioned on January 7, 2025. Mr. Mukherjee, if on that date we find that the records have not come, we'll seek a report from the, just remind us, we'll seek a report from the district judge.
Item number 5.
And for the petitioner respondent,
Who is appearing?
this document, the respondent.
Since the learned advocates for one of the parties is a relative of one of us, within bracket Bhattacharya J, let the matter stand released from our list on personal ground with liberty to the parties to seek an assignment before a different division bench.
Item number 3.
My lord, I am for the appellant, my lord.
Yes, please. Why was it mentioned? As to be mentioned?
My lord, correction leave may be granted to change the classification and deposit fees can be deposited to your
Acha,
lordship.
just let us check up. Give us half a second. The appeal has been filed.
Yep.
You have also filed without a certified copy of the impugned order.
Yes, your
What
lord.
about that?
I have certified, but the decree copy is not there. I got that late. That's why I need your lordship leave to file the certified copy right now to your lordship. Then
So you want to file a certified copy of the decree now?
yes, your lordship.
You are ready with that?
Yes, I am.
Can we direct you to file it during the course of the day? Or
Yes,
by tomorrow? By tomorrow, we are giving you try to do it during the course of the day. So
yeah.
2 or 3 things. One is that you have to deposit that. Second is classification. You have to change the caption of the preamble of the appeal.
Yes, your lordship.
2, and thirdly, name of learned trial judge has not been mentioned. What about that?
I have that, your lordship. I can change.
So we'll give you leave to do all of this by tomorrow, but try to do it during the course of the day.
I will, your lordship. I have all the thing with me right now. I can.
Very well. Then we'll direct you to do it during the course of the day.
Deeply obliged, your lordship, and record may be called for those, so I can send the copies to that effective.
Very well. We'll ask you to put in the requisites also by tomorrow then.
Yes.
And special messenger costs also you want?
How much will be that? I have to.
Which district?
Bordhaman, your lordship.
Will be some. If you want, we can direct you to do this, put in the special messenger costs by, say, January 10th.
Deeply obliged, your lordship.
So do that. Do that. Yes. We'll permit you. Yes, very well. There are 3 defects in the appeal, which learned counsel for the appellant submits that he is in a position to cure. Full stop. Accordingly, the appellant is directed to file the certified copy of the decree impugned in the appeal, comma, change the classification of the appeal in the memorandum of appeal by categorizing it as FAT and also amend the preamble of the memorandum of appeal by incorporating the name of the learned trial judge. Such amendment shall be carried out during the course of the day. Next para. The office is directed to classify the appeal, reclassify the appeal accordingly within January 10, 2025. Next para. The trial court records be called for by special messenger at the cost of the appellants, comma, which shall be deposited within January 10, 2025. Next para. The learned advocate for the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the matter for inclusion as and when the appeal is ready for hearing. Thank you.
Deeply obliged, your lordship.
But Mr. Adho, please ensure that these are done.
Yes, your lordship. Today it will be done definitely.
Thank you so much.
Deeply obliged, your lordship. I'm Kaukidi.
Mr. S. Adho. Mr. S. Adho.
Yes, sir.
Very well. Need not give it. Yes.
Deeply obliged, your
Thank you.
Question number 7.
Mr. Mithu, just remind us why is it appealing?
My lord, there was a direction that
yes,
the possession of the roof shall be restricted to certain time. Therefore, on that instructions, my lord, the matter was deferred and placed for orders today. My lord has written the order. There was a order for injunction which has been challenged before your lordships by my client. My client has been facing trouble in view of the.
You are the mother. You are the mother.
I am the mother. And my lord, I am residing at the top floor room, which is.
Oh, rightly. They were to take instruction as to the hours.
Hours.
Yes, Mr. Chakravarti, what is your instruction?
So here your lordship will find that, in fact, mother is, my lord, used as a shield, my lord. The appellant number 3 is married, my lord, sister. She is residing in the matrimonial home but her address has been shown at the suit premises. My lord, admittedly, my lord, it is a joint property and we are residing in a very small
Mr.
area.
Chakravarti, we kept it only for ascertaining you to
Yes,
ascertain what
yes.
are the convenient hours. If you don't give any convenient hours, we'll pass orders according to our.
My lord, before that, my lord, your lordship
We
kindly.
shall not reopen the hearing. It was heard at length on the last date.
My lord,
No further hearing.
my lord, whether there is a legal flaw in the matter.
Mr.
in the order.
Chakravarti, we have considered that
My lord,
legal flaw or not, the mother is residing in the roof. You have a right to access to the roof,
my lord,
but
here-
due to the friction between you two, will restrict your hours of accessing the roof.
my lord,
If
they
you
have-
don't give any convenient hours, Mr. Chakravarti, we'll pass our
my
order
lord, your
because we
lordship-
shall not
my lord,
reopen the
my
hearing
lord,
afresh.
Definitely, your lordship, whatever you.
This was
My lord,
put
kindly
today
see,
only
my
for
lord,
this purpose.
in this case, my lord, there is a background, my lord. The appellant.
Whatever may be the background, there is
violent-
friction.
my lord, violated the order. My lord, that's why their
We will-
deed has been cancelled.
We'll
They
hear
papered an
that.
appeal. My lord, we have no antecedent.
We will hear that at the time of merits of the appeal, but we have passed our order. We would have passed the order finally, but it was our grace that we granted you 1 day's time to take instruction as to what would be your convenient hours. If you don't have any convenient hours, Mr. Chakravarti, we'll pass our order. We had passed our order on the last occasion, only to give you a chance to take instruction from your client if your client had some convenient hours when he wants to access. If you don't have any convenient hours, we have no issues. We'll pass our order right now. What are your convenient hours? Either give the hours or let us pass the order.
My lord,
We said that 2 hours in the first half of the day and 1 hour in the afternoon. What are the hours?
This is partition suit, my lord.
All right.
Your lordship is under the impression matter is going to end because my peremptory board.
Let us forget our impression. What
My
is
lord,
your
kindly,
impression?
Partition suit preliminary degree, thereafter final degree, first appeal, second appeal. This, my lord, restriction will prevail throughout my course unless it is finished, my lord. So, my lord, this is the apprehension that shortly matter will be finished and the entire thing.
What is the appeal against?
My lord, this appeal is against the injunction.
Mr. Chakravarti, you prepare informal paper books. We'll keep it on a particular on 13th of January. We'll keep the appeal for hearing.
All right, let it be.
But what you have no convenient hours then. Let us pass order. Issue. Despite repeated queries, learned counsel for the respondent seeks to reopen the hearing of the injunction matter and does not give us any convenient hours of access to the roof for the respondent. First up, a bare perusal of our order dated December 19, 2024 shows that this court had already formed an opinion that in view of the friction between the parties, since the appellant mother is residing, appellant number 1 mother is residing on the roof, and on the other hand, the respondent, being a co-owner, also has rights of access to the roof, we had granted time to the learned advocate for the respondent to ascertain as to what would be the convenient hours during which access can be given to the respondent. Push up next para. We had also clarified in our order that the said hours would be restricted to approximately 2 hours in the first half of the day and 1 hour in the afternoon. Pushed up, since the respondent does not give any convenient hours, we dispose of Can 1 of 2024 by restraining the respondent from accessing the roof of the suit building apart from between 10 a.m. to 12 noon in the morning and between 4 to 5 p.m. in the afternoon. Pushed up, such arrangement shall continue till disposal of the appeal. Pushed up, since learned counsel for the respondent, upon query of court, submits that the respondent is ready to prepare the paper books in order to expedite the appeal, we direct the respondent to prepare and file the requisite number of informal paper books without comparing with the records by within January. What date tell us? January 8th? January 8, 2025, and serve advance copies.
1 week more.
Then the appeal goes thereafter. Very well. By January 8, January 15, 2025, pushed up. Advance copies thereof shall be served on the learned advocate for the appellants. Pushed up, the appeal shall be placed for hearing on January 20, 2025. Pushed up, in view of the limited nature of the impugned order, comma, the trial court records need not be called for, push up the appeal be deemed to stand otherwise ready for hearing. Just come back on that date, we'll decide the appeal.
Number 8.
8, yes.
This is my application, but I am for the respondents. Milord, the partition suit was declared in preliminary form, Milord, and 1/3 share of this appellant and Milord of the respondent 2/3 shares were declared, Milord.
Right.
Milord, the appellant admitted our share. He said that property was purchased in the name of 3 brothers, and my lord, the suit was not property was not partitioned, Milord. Only contention is that, Milord, he is in exclusive possession for 12 years. But in the cross-examination, he said that he has no document to show, Milord, that he has any document.
early here.
Mr.
Look-
Jaiswal, is this challenge appeal against preliminary degree or?
Preliminary decree, Lordship. And
So,
Milord,
where is the scope of any challenge, Mr. Bhattacharya? Resolve the issue. If you agree to the shares, we'll dispose of the appeal. Go back there and have it. We'll give you liberty to take this point before the partition commissioner, because the established proposition of law is that existing possession should be honored as far as possible. So we can do that and dispose of the appeal. Why keep these matters pending, Mr. Bhattacharya?
Logically, with application for early hearing, let it come lot after vacation. I think.
Early hearing means, I mean, we can
The
dispose of
application is.
we can dispose of the application as well as the appeal, recording that you have no difficulty with the shares.
No, Lord, that I have to
Take instruction. Come back tomorrow.
all right. Bolpur,
Take instruction.
Bolpur.
Phone, mobile phone.
Yeah.
Bolpur, mobile phone, Calcutta,
Tomorrow.
one place.
That's even after vacation.
Mr. Bhattacharya, just
1
take
week after
instruction.
vacation, I will. Your lordship.
So then if you pass any order on this, that would involve your
Lordship,
putting it-
make it application and appeal after vacation, 1 week after vacation.
very well, very well. This application has been filed for expeditious hearing of the appeal. Full stop. While taking up the matter, learned counsel for the respondents submits that although the appeal has been preferred by the appellant against a preliminary decree of partition, the appellant primarily does not have any qualms regarding the respective shares of the parties as declared by the trial court, that is 1/3 for the appellant and 2/3 for the respondents. Full stop. The bone of contention is that the appellant claims to be in exclusive possession of a major portion of the building, which according to the appellant is required to be honored.
Not entire property
Acha,
in my
major
possession.
portion.
Entire property in my possession.
Entire
Entire property in my
major portion na kore entire
property in my possession.
don't repeat, let me finish the sentence. যেখানে মেজর পোর্শন বলছি সেখানে এন্টায়ার প্রপার্টি যে কোনখানটা ছাড়লাম একটু এন্টায়ার পোর্শন না এন্টায়ার সুট প্রপার্টি আর্ট অফ দি বিল্ডিং কোড এন্টায়ার প্রপার্টি তারপর কি বলেছি হুইচটা কেটে হ্যাঁ এন্টায়ার সুট প্রপার্টি ফুল স্টপ নেক্সট প্যারা the only bone of contention before this court is না ওটাই বললাম আচ্ছা আচ্ছা ওখানে ফুল স্টপ দাও নেক্সট প্যারা accordingly it is submitted that the said appeal can be disposed of on such limited issue. Full stop. On the query of court, learned counsel for the appellant submits that he is required to take instructions as to whether there is any dispute regarding the shares declared by the trial court in the preliminary degree. Full stop. We are of the opinion that in the event the appellant agrees to the shares of the parties declared by the trial court in the preliminary decree, but has other issues regarding possession being honored, the same, leave may be granted to the appellant to agitate such point at the time when the allocations of the parties are made in the final decree proceedings, and dispose of the appeal with such limited rider. Full stop. Next para. On the prayer of the learned counsel for the appellant, to take instruction on such count, time is granted to the learned counsel for the appellant till January 7, 2024. Full stop. Let the application be listed on the said date for passing further orders. Mr. Bhattacharya, if there is no dispute regarding the shares, then we'll make provision in our judgment that this point will be open, it will be considered by the commissioner, and in accordance with law, whatever. Then no records, nothing will be recorded. Yes.
I think to appear on behalf of the appellant, my lord.
Appellants, yes.
Subject to a lordship kind sanction, my lord, can it be taken on 6th? Because, my lord, I have been engaged, but I have not seen the records till now. Well, this is the
6th of January.
6th of January.
We'll keep it on 7th of January.
As your lordship.
6 is maybe the common list day. On the prayer of the appellants, comma, let the matter stand adjourned till January 7, 2025.
My lord, subject to lord, may I get for 1 minute, my lord, the records, my lord, to see the. Because
Yes,
I
yes.
do not know even what is the matter about.
Very well. এই রেকর্ডটা একটু দেখিয়ে দেবেন। A bit, their hands are a bit less tight.
No,
Come back and
I shall.
এই যখন আসবে একটু
Number 10.
we find from the previous orders that the appellant has remained unrepresented on several consecutive occasions. Full stop. Accordingly, FMA 2062 at application এটি আসছে না can 1 of 2018 within bracket old can 5343 of 2018 is dismissed for default without any orders to cost. Record defective.
Very innocuous prayer mirror. But actually, during the COVID period, this appeal was filed against the judgment of the learned district judge, Darjeeling. So, mirror, it is within the jurisdiction of mirror this Jalpaiguri bench. Mirror, this appeal is pending since 2001 before this court, in this court. So, mirror, we are asking, praying, humbly praying, let this matter be heard by this bench. Kindly pass the usual order for calling for the record.
No, this has to now go before the Jalpaiguri bench. We don't have any control over that. But
That's your lordships can.
we don't have any control. We'll send the files, we'll direct the files to immediately be sent to the circuit bench at Jalpaiguri. It appears that the matter arises out of district Darjeeling and as such, comma, as per the current determination, comma, the circuit bench of this court at Jalpaiguri has determination to take up the matter. Accordingly, let the records be sent expeditiously to the circuit bench at Jalpaiguri with liberty to the parties to mention before the appropriate bench in the said circuit for the purpose of inclusion in the list.
Yes, my lord. I have both responded. My lord, I have mentioned the matter on 16, and I verbally informed the advocate that I have mentioned. And the last order has not been complied with, means any copy of the continuation of delay has not been served.
Mr. Rai, can you do this? Can you give a notice in writing? We'll keep it on the reopening day so that they cannot say that at least they were not given notice.
Today I shall serve, my lord, but subject to that even in the court information is there in their mobile that our team is there.
The moment we dismiss it for default, tomorrow another application for recall will be filed and you will be in jeopardy. We can do that also. It will not help you.
Certainly, Supratim Dhar is my learned friend. Is that
Supratim Dhar is your learned friend? Does not matter to us. Then maybe your enemy also. And he is not Supratim Dhar.
His junior has come.
So is he a friend also, or he is not a friend? Yes. What about the application? They have mentioned it. You are not moving your matter.
Kindly extend the time to file the
file
Section 5 application. Earlier it was filed, my lord. There was some inadvertent mistake for which the application has to be withdrawn, my lord. My lord, time may be extended so that in the meantime, the proper steps can be.
No, we cannot set any time. You asked for time, we have given you fortnight's time. It's your pleasure whenever you file the Section 5 application. When the matter is called on for hearing, learned counsel for the appellant seeks some further time to file an application for condonation of delay. Full stop. It is submitted that previously it was filed, but due to certain defects was withdrawn. Full stop. Be that as it may, it is upon the appellant as to when to take out an application for condonation of delay, since till till such an application is filed and allowed and the delay condoned, the appeals are non-est in the eye of law. Full stop. Next para. Accordingly, we do not find any necessity for this court to fix any time for filing such application. Full stop. The applications for condonation of delay, if filed, shall be subject to adjudication by the court. Full stop. Let the matter go out of the list with liberty to the appellant to mention for inclusion in the list as and when and if any applications for applications for condonation of delay of the appeals are filed.
Yes, my lord, only request, my lord, that 6 years is pending the execution. The money decree has not payment, my lord, kindly see.
Execute it. Who prevents you? We have observed that it's non-est in the eye of
They
law.
are taking, I have made application can 1, for that reason I have annexed. They are making application, appeal is pending till the appeal is disposed of.
Sir, we think we are sufficiently
No,
clear in our order.
I am nothing but.
You have to say something because you are ready.
Only one, that my lord, date may be fixed. Other
Date for what?
They are not.
Can we fix a date for filing an application for condonation of delay?
Matter will appear.
What will appear? The appeal is non-est in the eye of law without any application for condonation of delay. What shall we fix? There is no appeal in the eye of law. We have observed precisely that in our order. Next.
I requested my learned.
Yes, Mr. Dar, we have heard them at the next matter.
My lord, one problem he is saying, my lord. He has told me
next matter.
that advocate on record should be changed. His problem.
19 who is appearing? Yes, 19 who is for the appeal? You? Mr. Which Banerjee? No passover. Move the matter. Either move the matter or get it dismissed for default. What is the application for? You have to at least know what is the application for. You are moving can 1.
Can 3.
What is the judgment against which you have preferred the appeal?
Give me short password, my lord. I am not well acquainted with the fact.
No question of short password. You must know what appeal you have. What is the judgment you have challenged? Money suit. Anyway, problem on the prayer of the appellant, the matter is adjourned for the day. Next. Please give your name.
I'm appearing for the appellant.
Substitution after setting aside. Where is that application? It's appearing before us.
This I'll file an affidavit to him.
What is the delay?
Delay, and there is that is not pleaded, plus there's suppression. They say that we did not know. I'll be able to show there is another suit between the same parties. They knew that these persons had died, and it got abated.
Very well. Learned counsel for the respondents. Which respondents? All
2 and 3.
Respondent numbers 2 and 3 seeks leave to file an opposition against the present application. Full stop. Accordingly, the respondents are directed to file their affidavits in opposition to what is the can number? Can 1?
Can 2.
To can 2 of 2024. Within what time? Tell us. 10th January?
Yes.
Within January 10, 2025, full stop, reply if any shall be filed by January 17, 2025. The application shall be listed for hearing on January 20, 2025. The affidavit of service filed today be kept on record. You have served all. We have directed all the respondents to file their opposition. Since Mr. Banerjee is appearing, their name will be written. Great. Yes. Yes, Mr. Mina. What is the application for?
One is section 5, another is order 41, rule 27, another is stay.
Section 5 has to be served then.
There was a caveat, but we could not able to serve upon the learned advocate for the caveator,
Why?
Mr. Pali, but it was directly served upon the parties, my lord.
Why did you not serve on the advocate?
But he was not available, my lord. It was my lord, kindly permit me to serve again and come back. There was a direct.
Huh? 2 days delay. 2 days delay.
2 days delay, my lord. I have not picked up the file, my lord. There's a 2 days delay, my lord. As
Received.
but it was received, my lord. But the bench is it is written that bench is before Madhuresh Prasad, Justice Madhuresh Prasad, my lord.
No, but every time the bench changes, you cannot give another note. 2 days delay. You have not even checked up what is the delay, Samina. That we are more aggrieved with that. You have written in your application 2 days.
2 days delay, my lord. But
when was the decree passed? Let us check up.
21st of July.
When did you file the appeal? Do you know?
Appeal was filed, my lord.
রিপোর্ট আছে স্ট্যাম্প রিপোর্টের রিপোর্টে দেখি কি বলেছে the long delay of 2 days.
But
if it's miscalculation, will impose cost on it.
what is
Let us see the reason. This will be interesting. কি বলেছে reason? The delays. Affidavit of service filed today be kept on record. Can 2 of 2023 is an application for condonation of the minuscule delay of 2 days in preferring the appeal. Full stop. Upon a perusal of the averments made in the application, we are satisfied that sufficient cause for such delay has been explained. Full stop. Accordingly, can 2 of 2023 is allowed, thereby condoning the delay in preferring FAT 329 of 2023. Full stop. The appellant shall serve copies of Can 1 of 2023 and Can 3 of 2024 on the respondent, indicating that the said applications shall be listed for hearing on January 13, 2025, when the appellant shall file another affidavit of service. First of the affidavit of service filed today be kept.
Since there is a caveat, the learned advocate is for the caveator is not available, my lord. That is why, my lord, service.
আচ্ছা যেখানে বললাম shall serve copies on the respondents, comma, directly and stroke or to the learned advocate who had lodged a caveat for the respondent in this court. And or tie both. If you can find the address of the advocate, you can don't find him, then you can also send it postally to him, as well as the respondent, or his chamber address, whatever. Take a chance his clerk or his family members may by mistake check. Please. Yes.
I'm for the petition, Malad.
22, what is the matter?
Malad, may I file my affidavit of service, Malad?
Yes, please. Yeah.
Can 1 is for condemnation delay of 41 days, Malad.
What is the reason?
Reason, Malad, the file has to travel to the department for obtaining legal opinion for filing of appeal, and Malad thereafter certified copies. So that is the reason.
They have received.
Yes, they have received. But Malad,
what is the other application for?
Stay, Malad. The amount has already been.
1 minute. This appeal has not been admitted. FMT. Oh, then we can condone the. We don't even have power to condone the delay. This is city code.
No, Malad. Employees compensation.
No, the jurisdiction is Calcutta jurisdiction.
Yes, yes.
Oh, employees we have. Very. Let us condone the delay first. Affidavit of service filed today be kept on record. Stop. Since sufficient reasons have been given in the application for condonation of delay, comma, Can 1 of 2024 is allowed, thereby condoning the delay in preferring FMT within bracket WC bracket closed number 12 of 2024. Push up next para. What are the points involved in the appeal?
Well, only point, Malad, in the Employees Compensation Act, there is a schedule based on which the injury, the nature of injury, and
Take the microphone,
Malad,
yes.
sorry, the
Injury?
injury, Malad, the nature of injury and the percentage to be calculated for loss of income. There is a schedule for that. Malad, the basic point of challenge is, Malad, there is a report of the medical practitioner who has given the nature of injury, but the learned commission has not considered that the percent of loss of income that has been imposed is not within that nature of injuries, Malad.
So admittedly, what would we do?
I'm sorry, man.
The calculation is wrong, you're saying.
No, the imposition of percentage of loss of injury.
So if that imposition was not there, there would be nothing payable.
No, they will be, that will be.
So what is the admitted? That is
Malad,
what
that has to be calculated in the percentage, Malad.
you have to have your version of that.
Yes, but Malad, until and
Very well, then we'll admit the appeal, but we'll direct you to serve a copy of the stay application. It must be a stay.
I've already served. Malad, the stay and can one.
No, but then we'll direct them to put in, because these are, what does the claimant do? Must be someone.
Yes, Malad, I can understand, man. But Malad, the difficulty.
We won't stay without being sure of your ground.
Malad, difficulty is, Malad, we have already deposited the sum before the commissioner as a
You have
prerequisite.
deposited.
Yes. So Malad, let it be kept with the commissioner so that.
No, we'll direct you to file a supplementary affidavit. We'll make it clear in our order what is your admitted due that you have to disclose before the court. Because it will be subject to that only. It cannot be unconditional. They cannot withdraw anything.
But in the meantime, some protection that they.
They will give you a limited time for that.
Okay.
Acha, next para. In view of the question as to imposition of proper compensation having been raised in the present appeal, and since the present appeal involves questions both of fact and law, the appeal will be heard on the grounds taken in the memorandum of appeal. Full stop. FMAT WC 12 of 2024 is accordingly admitted. Full stop. Next para. Can what is that stay?
Can 2.
Can 2 of 2024 is now taken up for hearing. Full stop. By virtue of the present application, stay of operation of the impugned judgment and order has been sought. Full stop. Learned counsel for the appellant submits that the entire amount has been deposited with
the employees compensation court.
With the employees compensation court or tribunal.
Commission.
The employees compensation commission. Full stop. It is submitted that in the event the entire amount is withdrawn in the meantime, the appeal will be rendered infructuous. Full stop. Next para. However, the court is of the opinion that the appellant should clarify as to what, according to it, is the admitted amount of compensation payable in the event the appellant succeeds in the appeal. Full stop. For such purpose, the appellant is directed to file a supplementary affidavit disclosing the admitted dues with appropriate breakup to back up the same within January 10, 2025. Full stop. There shall be an unconditional stay of operation of the impugned judgment and order till January 17, 2025 or until further order, whichever is earlier. Full stop. The application shall next be listed on January 13, 2025. Full stop. An advance copy of the supplementary affidavit shall be served on the respondents by the appellant in the meantime, and a further affidavit of service shall be filed on the next returnable day.
Okay.
Thank you.
Item number 23.
What is section 5 in steel?
Section 5 in?
Section 5.
Yes.
The delay of 1 year more than.
1 year. What is the ground?
The ground for the.
Not yet served, Mr. Bhattacharya.
Not yet
First
served.
time. Serve and come.
Court partition, no summons was served upon defendant number 9.
Achha. Apparently good ground, but you serve copy and come.
Yes, yes, yes.
Serve copies of. This is against preliminary degree.
Yes.
Serve copies of both applications and memo.
Yes.
What is the can of?
Can 1 is section 5 application.
Very well.
And can 2 stay.
Can 1 of 2024 is an application for condonation of delay in preferring the appeal. Full stop. In order to expedite the matter, the appellant shall serve copies of Can 1 of 2024 along with Can 2 of 2024 as well as a copy of the memorandum of appeal on the plaintiff respondent as well as on the respondent numbers 2 to 9, indicating that the applications shall be listed for hearing on January 13, 2025, when an affidavit of service to that effect shall be filed by the appellant. All appellants, because it's a partition suit. Serve copies and come back and we'll take it up on 30.
My lord, my application, my.
Yes, please.
My lord, can one is become infractuous, my lord.
What is can one?
For stay of operation of the impugned judgment, my lord.
Judgment was eviction.
My lord, for dismissal of grant of probate. Dismissal of.
Dismissal of grant of probate?
Grant of probate, my lord. My lord, I have
It was a probate proceeding.
probate proceeding.
Probate proceeding, probate has been granted, which you have challenged.
My application has been dismissed, my lord. Probate was not granted.
The probate proceeding was not decided finally.
Decided finally and dismissed my application, my lord.
Dismiss your application for non-grant of probate,
Non-grant.
and thereafter the court proceeded to grant the probate.
No, not granted.
The court below has refused to grant probate in the OS upon contested hearing.
You asked for probate.
Yes, my lord. Yes.
She's saying that you made an application for non-grant of probate.
No, my lord.
Probate, it has been dismissed upon contentious hearing.
Against that you have come up.
That
Stay of operation does not mean anything.
My lord. This became infractuous, my lord. Can too, my lord, I have filed for injunction.
And it is for injunction.
Yes, my lord.
Mother and daughter. Daughter is a
You-
problem.
Cinematic combination.
My lord.
If can too, let us find out first. And yes, very. Possession, Mr. Ghosh, we are not sure.
Yes.
So we'll grant injunction regarding third party interest and all.
No, we are in possession because she
How do you know that?
stated that she is residing in the matrimonial home. She is a professor and she doesn't reside here.
Do we find any reflection of that from the impugned judgment, Mr. Ghosh? Anywhere possession discussed, even tangentially?
Yes, Lord, that is she has applied.
Show us that portion that you are in possession. Because without referring to the present possession, we are not inclined to grant status quo. We are deprecating trial courts doing that regularly, so we don't want to do that right now unless it's essential. There's nothing on record to show possession.
My lord, internal page 2, my lord.
Internal page 2.
Middle portion, yes, my lord. May I read, my lord?
Please.
Middle portion, my lord.
Yes, do.
The further case of the defendant is that the wife of the deceased testator died long ago, and after marriage of the defendant, the deceased used to live alone. And as there was none to look after him, the plaintiff was appointed by the deceased Sukhendu Kumar Bhattacharjee to look after him for his nursing. The defendant has stated that the deceased was sick and ailing person, and the plaintiff might have obtained the signature, obtained signature of the deceased on some papers and document without the knowledge and deceased and the defendant. And in March 2005, the deceased Sukhendu Kumar Bhattacharjee was very sick and he was completely bedridden, and therefore question of execution of the registration of the alleged will does not arise. It is stated further that the attesting witness of the alleged propounder purported will are unknown to the defendant, and they are planted, and with collusion of attesting witness of the alleged will, the plaintiff anyhow managed to procure the alleged will dated at such and such. Accordingly, the defendant, the present March, the deceased was sick, my lord, and that is why, my lord, she was appointed as Aya, my lord. And thereafter, marriage was solemnized.
How does this prove your position?
Well, the respondent in his deposition, my lord, stated that after her marriage, my lord, this plaintiff, my lord, was with his father, my lord. In his deposition, in her deposition, my lord, she has.
Who are you? You are the wife of the late of the testator.
Second wife.
Second wife.
My lord. And when she was only 5 years old.
Very well. It appears from the they contested, naturally contested from this address. Address is different. Your address is the Suit property, the subject matter of the will. Very good. Learned counsel, Mr. Ghosh, you are appearing in this matter. Learned senior counsel for the appellant submits that can 1 of 2024 has been rendered infructuous and is not pressed. Full stop. Accordingly, can 1 of 2024 is dismissed as not pressed. So can 2 of 2024 is an application for injunction filed in connection with the present appeal, comma, which has been preferred against refusal by the probate court to grant probate of a will. Full stop. Next para. Being prima facie satisfied that the plaintiff has made out that the appellant has made out a case for the appeal to be heard on merits, comma, the respondent is restrained by an order of injunction from selling, transferring, alienating, encumbering, and or creating any third-party interest in respect of the suit property, and stroke or from disturbing the possession of the plaintiff, possession of the appellant in respect of the subject property. Full stop. Next part, it is made clear that the restraint order regarding possession is being passed tentatively in view of it being apparent that the respondent is a married daughter of the testatrix, whereas the present petitioner stroke appellant is the widow of the testator, is the widow of the testator, and that the respondent contested the suit and has been arrayed as a party here from an address which is different from that which is the subject matter of the will. Full stop. Next para, such injunction order shall operate till disposal of the present application. Full stop. The appellant shall serve a copy of the application bearing can 2 of 2024 on the respondent, indicating that the same shall be listed for hearing on January 20, 2025, when an affidavit of service to that effect shall be filed by the appellant. Full stop. Affidavit in opposition, if any, shall be filed by January 10, 2025. Reply, if any, shall be filed on the next returnable date. Mr. Ghosh, please serve this side of the vacation so that they can file their opposition. Thank you very much.
Item number 25. Regarding item number 25, I'm praying if the matter can be fixed after vacation because I'm led by Mr. Pratim Roy, Your Lordship. See if the matter can be fixed after vacation, Your Lordship.
Where this is the application is for what?
For my client, the appellant is suffering injunction, Your Lordship. So
You
therefore,
are the respondent here.
I am the appellant, defendant.
Oh, the appeal was admitted. This appeal is against injunction.
Injunction, Lordship.
So the appeal has been directed to be, the appeal is ready for hearing.
Appeal is ready for hearing. The delay has been condoned, Your
What is the
Lordship.
can for? Stay of operation.
Stay of the operation.
Operation of injunction, which we won't grant. So let us fix the can along with the appeal. You prepare your
Lordship,
paper
together.
books.
Lordship, the appeal and applications can be heard together. Your
So you have to prepare paper books then. We'll pass those directions right now. The nature of the present application bearing IA number can 1 of 2024 is such, comma, being one for stay of operation of an injunction order which was passed by the trial court, comma, that in the event the application is allowed or any ad interim order passed at this stage, comma, it will tantamount to granting the main relief sought in the appeal itself prior to hearing the same. For sub next para, accordingly, we fix the appeal, fix the application to be heard along with the appeal itself. First up, the appeal and the application shall be listed on January 22, 2025. First up, in the meantime, comma, the appellants shall serve. You have served copies of.
Served, but nobody is appearing, Your Lordship. May I permit you to file the affidavit of service, Your Lordship?
In the meantime, affidavit of service filed today be kept on record, which indicates that despite service, the respondents are not appearing today. Push up next para. The appellants shall serve a further notice to the respondents indicating the next returnable date and a gist of this order, which shall be treated to be notice of appeal itself. Push up next para. The appellants shall, the learned advocate for the appellants shall prepare and file the requisite number of informal paper books without comparing with the records within January 10, 2025, and shall serve copies of the same as well on the respondents, and a further affidavit of service shall be filed on the returnable date to that effect. Next para, in view of the limited nature of the appeal, comma, the trial court records need not be called for at this juncture. Full stop. Other formalities except service of notice of the appeal by the appellant on the respondents is hereby dispensed with.
Lordship, the respondent may I be permitted to serve only upon the plaintiff respondents, your lordship, because there are other pro forma respondents also. The plaintiff respondents, your lordship, they are
Up to 11.
up to this is plaintiff respondents.
You have not described them as plaintiffs.
Lordship, on the earlier occasion, my lord, Honorable Justice Harish Tandon also has been pleased to direct the.
So we agree with that, but you have to, in the memorandum, you have described them as plaintiffs. Let us see.
Respondents.
Why don't you mention in the memorandum just what they were in the code below? You just mention appellant. This is the department should not accept this. I mean, you should write defendant appellant and plaintiff respondent. আচ্ছা যেখানে যেখানে রেসপন্ডেন্টস এর উপর সার্ভিস বলেছি না সেখানে প্লেন্টিভস রেসপন্ডেন্টস নাম্বারস 1 to 11 যেখানে যেখানে রেফারেন্স আছে আর একটা লাইন অ্যাড করে দিন সার্ভিস অফ নোটিস অন দি প্রোফর্মা রেসপন্ডেন্টস নাম্বার 12 to 30 is hereby dispensed.
Great. Number 26.
Yes, sir.
Opposing, Lord. This is my application, Lord, in connection with the matrimonial suit wherein, Lord, I am challenging the decree. My learned friend, Lord, in the opposition has contended that there is no scope or the interim order that I am praying for, Lord, restraining him from remarrying because he has already, Lord, remarried under, Lord, the Arya Samaj rights. Now, Lord, if your Lordship kindly takes up his opposition and come to page 72. Lord, before that, Lord, I'll
opposition গুলো দিতে হবে
দিদি একটু opposition
গুলো কোথায় আছে দেখে অ্যাপ্লিকেশনটা পাচ্ছি অপোজিশন না ডিপ্লোজে লাগে ওখানে দু কপি নেই তো দেখে নিন এখানে আছে অ্যাপ্লিকেশনের কপি
But the decree was passed on 22nd March 2024.
2024? Yes.
Now, Lord, the appeal was filed on 30th April 2024. This was, Lord, a proceeding before the family courts. Wherein, Lord, the Family Court Act, Lord, says that the appeal is within 30 days. The parties, Lord, sought for a dissolution under the Hindu Marriage Act, which provides for an appeal for 90 days. Now, Lord, it is claimed that they got married, Lord, according to the Arya Samaj, Lord, at Arya Samaj Mandir, Vivaho Bandhan Trust, Lord, at page 72 of, Lord, the opposition. And, Lord, in support of that, Lord, our Revenue Department, Government of Institute of Delhi, Lord, certificate is being, Lord, produced. The marriage date, according to them, is, Lord, the 3rd of July 2024.
3rd July 24?
Yes, Lord, your Lordship has been duly registered on 3rd July 2024.
Is there anything to show that they had notice of appeal?
Lord, yes. Your Lordship will kindly come to page 12 of the stay application. Because their advocate on record, Lord, gave us a Lord reply. Sorry, in the reply. I'm sorry, in the reply. Page 12 in our reply.
Give us 1 minute, sir.
Page 12 of my reply.
Yes.
Now, Lord, this was addressed to my advocate on record dated 2nd of May 2024 with my lord the FAT number. My lord, I am appearing for my above mentioned client. You are requested to give me a copy of the above mentioned application as I filed a caveat on behalf of my client. So, my lord, I am squarely covered because they are notified. And secondly, my lord, I am challenging, my lord, the purported, my lord, the certificate of Arjo Samaj marriage that, my lord, they are trying to produce before your lordship. Because my lord, I can satisfy your lordship with judgments, my lord, that merely bringing a certificate. But even if I assume that under section 2, my lord, the Arjo Samajists are, my lord, considered to be, my lord, a sect of Hinduism. But their marriage are to be registered, my lord, under the Hindu Marriage Act, which requires a compulsory registration, my lord, as of now, under the rules. This is a certificate of marriage under compulsory marriage order. At the top, not fourth line from the top.
No, page 72.
Page 72. Certificate of marriage,
Marriage,
fourth
after
line.
compulsory marriage order.
Compulsory marriage order.
Yes.
Certificate number such and such. Then, my lord, the name of the parties having been solemnized at Arjo Samaj Mandir Bibaho Bandhan Trust. Such and such school.
But if
On
it's a Hindu marriage,
second of
sorry, Mr. Mukherjee, if it's a Hindu marriage, then the rights are
have to be performed, Lord, according to the Hindu marriage. Lord, that is the judgment of this honor.
all right. Yes.
But I'll satisfy
Yes,
your
but that is
lordship.
the marriage, not the registration.
Nowadays, Lord, first of all, Lord, to prove, Lord, there is a marriage, Lord, Arjo Samaj marriage is, Lord, they have to also show that there has been, Lord, the Shoptapur. Because the form of a Hindu marriage has
Is
been
there any judgment to that
ritualistic
effect?
form. Yes, Lord, I will. Lord, I did not bring that judgment. But I can cite
I
it,
don't
Lord.
know about this. Regarding Arjo Samaj marriage, I have no knowledge.
Lord, there are certain other judgments, but Lord, so far as AIR, Lord, 2000 Calcutta 109, boita ekটু আনা তো, para 42 and 43.
AIR 2000?
AIR 2000,
yes,
Calcutta, page 109, paragraph 42, 43. So judgment of this honorable court. And Lord, there is a Lord, what is Arjo Samaj?
Yes.
That is defined in a 5-judge bench of a Supreme Court judgment in 1971, volume 2 SCC, 269. What is Arjo Samaj? How it is different from Lord the main Lord the Hinduism, Lord the sect?
But
These
which
are-
judgment? The previous one,
Lord, the
2000
previous
says
one will be Lord as of for the purpose of stay I am relying upon.
that says that Shoptapati is required.
Lord, that says the rituals of Lord the valid Hindu marriage are required. I've come within the purview of Hinduism, no doubt. I am a sect of a Hinduism. But to make a marriage valid,
You are also an Arjo Samajist.
Lord, my client is not an Arjo Samajist. It
He
is
is.
not the husband and the person he claims to have married.
No, he is from the Arjo Samaj. That's an admitted position.
That is not an admitted position, Lord, because he married me, Lord, under the Hindu Marriage Act.
Achha. So he has subjected himself to the jurisdiction of Hindu marriage, Hindu law.
With my client.
With your client.
And also invoked Lord, the Hindu Marriage Act to get a divorce.
Yes, right.
And Lord, now, Lord, to prevent my Lord stay, he is saying that he got married with Lord this lady under the Arjo Samaj Lord Mandir.
So you mean to say that this first of all with knowledge they have married?
Yes.
He has married?
The section 15 comes into play.
There is no proper proof of conclusive proof of marriage at least.
And there is Lord, the marriage that they claim is not a marriage in the eye of law. It's a doubtful marriage. So, my Lord, I am entitled to an order of injunction so that he doesn't formalize this marriage, or my Lord, he doesn't contract a proper marriage with somebody.
First
43. But 42, and I'll just
42
check.
starts with.
But I'll just check.
This is we have the SCC online copy.
That is the paragraph might not tally.
Yes. What does it start with? If you say that,
But
we can-
I'm just trying to but last 2-3 paragraphs.
Yes, this is that. We find paragraph 43. Thus, from the above decision, it is quite clear that unless a Hindu marriage is celebrated with proper ceremonies,
Yes.
the marriage cannot be declared
Yes.
to have fallen. That's about a Hindu marriage.
No, Lord, this is emanating from Lord the Arya Samaj.
Very good.
তলার দিকটাতে Para 13, your lordship will find. Para 13, Lord, that about Arya Samaj marriage.
What is the previous paragraph? What does it start with? That paragraph?
After the family court was established, both the aforesaid suits were transferred to the family court, heard together. II was a marriage between Rajesh Kumar Bante, Joyita Bante, solemnized at Arya Mandir.
Very well. And then para 43. Yes, treated as Hindu marriage.
Lordship.
So unless they prove Shaptapadi and the other rituals.
Two things. Lord, here, Lord, what they say, Lord, by producing the certificate, the certificate only records that there was, Lord, some of a ritualistic marriage on 2nd of July. The certificate is dated, Lord, 3rd of July.
But it's, yes, but it says that on 2nd July, according to the custom practice of the parties.
Yes, that is not based upon the declaration. No supportive document is there before your lordship.
Prima facie proof.
My lord?
I mean, prima facie proof, because a registration certificate, even of a Hindu marriage, unless rebutted, is prima facie
This is
proof.
not even a certificate under the Hindu marriage. Lord, those are statutory certificates.
Yes.
Otherwise, I would not have argued on that. Not even, Lord, a certificate, Lord, under the Hindu marriage act.
What is this?
Secondly, my lord, your lordship will see, my lord, the parties, my lord, at least my learned friend's client, my lord, he resides, my lord, in Calcutta, Middleton Street. This is not registered in West Bengal. What's it? Registration? Yeah, girl stays in Delhi.
Registered in Delhi.
Registered in Delhi. The Revenue Department, Government of NCT Delhi, Officer Certificate of Marriage, certificate number such and such. And Lord, this is a certificate. We do not know under which act. Lord, the Arya Samaj Act doesn't have a Lord, independent certificate to be issued.
Yes, the marriage must have taken place in Delhi. I mean, the place is Delhi.
Yes.
Shahdara, Delhi. It was in Delhi.
Lordship.
But it was done at the office of marriage registrar, Shahdara.
Lordship. No, my point is, Lord, this is not a certificate under, Lord, the Hindu marriage registration rules. So, if not, the Arya Samajists are considered to be part of a sect of Hindu and they are covered under the Hindu Marriage Act. Even if they get married, Lord, it has to be first under the rituals of Hindu marriage. Secondly, Lord, the marriage should be registered under the Hindu marriage registration rule.
This certificate states that according to custom and practice.
But this is not a certificate. Statutory
Other point
certificate.
remains that this is not a certificate under the Hindu Marriage Act.
Therefore,
and
this
rules.
certificate is
But
not
if
a
this
proof of
was, then it would create a primary presumption, prima facie presumption, because it states that custom and practice, that is the certificate given.
Therefore, Lord, I am disputing the correctness of the certificate and, Lord, the probative value of the certificate to say that this certificate is not a proof of marriage.
Very well. And also during marriage.
Also, Lord, and there was a notice.
With a notice.
With a notice. The notice was much previous to the date of marriage. Even if I go by their certificate.
We need to serve notice on the copy on them.
When the matter first appeared,
date. We need
But
the
because Mr. Mukherjee, if the caveat, they lodged a caveat, if that expired, then two things would
But
happen.
but subject to correction.
Because did you
Lord, yeah.
file the appeal within the limitation period?
Yes. 30th of April, Lord, the appeal was filed. 30th April.
30th of April, but according to the Family Courts Act, I mean, it's 30 days.
But Lord, we got it after some time.
So that calculation,
period,
yes.
yes. And Lord, the date of degree is 22nd March.
But
as
they
I
are
said.
required to wait for the appeal period, right?
They are required to wait under section 15 because Lord, they are seeking dissolution under the Hindu Marriage Act.
Yes.
So Lord,
They
it
have
is
to
the
re-
90 days.
Acha.
I'm covered both ways in a sense. Lord, that they had notice of appeal, and to which Lord, on the judgment of the
What was the page of the advocate's letter? Your reply.
Page 12, reply. Notice of appeal.
And in any event, that notice, that the advocate's notice was given with the number of the appeal.
Yes. They had,
So they had
the
notice.
knowledge of the appeal.
Hmm.
11 এখানেও same হয়েছিল না?
All right.
Computation করে।
Very well. Mr. Mukherjee, anything else? One is that this certificate is not a valid marriage certificate under the Hindu Marriage Act.
Lordship.
Secondly, with notice of the appeal, they
Therefore,
contracted.
Lord, I am entitled to Lord section 15 protection.
Very well. Let us hear Mr. Ben. Yes, Mr. Ben.
Dates are very important, or rather 4 dates. 22nd March
Decree
2024, Malad, is the decree of dissolution of marriage.
Yes.
But they say Malad, they filed the appeal on 30th April.
Yes.
And we had written a letter because we were caveat. Malad, we had written a letter on 2nd May 2024 Malad, to ask for copy of the appeal and the stay application.
Quoting the number of the appeal.
Quoting the number.
Yes.
But the stay application was filed only on 30th August 2020. Very important.
Filing of stay application, is it relevant?
Otherwise,
Because
they're not asking for stay. Malad, I'll show a judgment. Malad,
notice of appeal, isn't it sufficient? Mr. Banerjee, you had notice of an appeal having been preferred.
Appeal has been served on us.
Even then, you had the
Has
number.
asked for copies of the appeal.
You had the number, you could take
I
make
had
inquiry.
copy of I had only the number because Malad, it is now Malad, available Malad, on the net.
Yes.
Malad, Excel Malad, with regard to filing.
So you had notice of the appeal.
No, but Malad, very important because they did not move because to get a benefit of
Even
Malad,
without a stay, Mr. Banerjee, if you contract a marriage, you are putting it yourself to jeopardy. I mean,
I have Malad, waited for that period. My marriage is 2nd July 2024, registered on 3rd July 2020, and that's Malad, the certificate.
yes.
So if you choose not to file a stay application or serve me a copy of the appeal, because stay application only filed on 30th August, that's why I just wanted to give the dates, Malad. 30th August, and Malad, the appeal and the stay is actually served on 5th of November 2024. There is also Malad, letter to that effect. Malad, can
But even without a stay, Mr. Banerjee, if you have knowledge of the appeal, if you contract a marriage, it's subject to
Malad,
that.
unless Malad, there's a stay,
You don't have that edge which you would have had if you did not have knowledge of
it's
it.
not void. And Malad, there's a judgment to that.
It's a irregular marriage.
No, Malad. That is Malad, also Malad, the judgment. I'll show that by saying Malad, if the period, because you don't take any steps. You can't
Period.
file an appeal.
Yes, if the period that cannot be taken in isolation. Not even if you waited for the period, but you had knowledge of the appeal. If the appeal is
but
filed,
period. So what I'm
you
saying
wait
is,
for the period and prefer a marriage.
What I'm
But
saying-
take out contract a marriage.
Malad, otherwise, what do I do?
Wait for
In
the appeal
law-
to be decided.
Malad, if he doesn't take any steps with regard to the appeal,
You take steps. You could have taken out application, whatever. But Mr. Banerjee,
I can't Malad, take out a step Malad, in his appeal.
yes, absolutely, you can.
appeal.
You can ask for paper books. You can ask for lower court records to
Malad,
be
in
called
his
for
appeal.
appeal.
Malad, I
In his
will
appeal, you
expedite
can.
his appeal.
Yes,
Malad,
to
perhaps-
marry early.
Malad,
You could
perhaps-
expedite. You have a provision in law.
Malad,
It's done regularly.
Malad,
Respondents are directed to expedite.
Let us understand, my lord, if he has an appeal, he has an appeal. My lord,
Could
if
not
the
have
appeal is
married
decided-
without. You knew about the appeal. You quoted about the appeal in your advocates letter.
I asked for it. That's one second.
You
mail.
know that the appeal is
I've not
pending.
been given a copy of, my lord, any appeal.
Copy is immaterial. You know the number of the appeal. You could have taken out a copy. You could have taken information from the office.
If he doesn't take any steps, my lord, I am sorry, my lord, with the greatest respect, my lord, that would be my argument. As my lord, a respondent, as my lord, a decree, my lord, which has been passed for dissolution, my lord, of marriage, which is, my lord, a decree in rem.
But that the decree is in jeopardy in appeal, even though no stay order is passed.
Yes,
Justice SBC has language in that
First day,
section 5.
First day, my lord said that this has to be now subject to, my lord, the appeal, my lord, being there. My lord, I did not, my lord, I said yes. That law I can't get away from. But there's no question about, I said, my lord, the application has become infructuous. You can't have an order of injunction. Because, my lord, the marriage has already been contracted. You have taken also the chance of not filing the stay application and also not serving me. My lord, if you are so sure, you should have, as soon as you file the appeal, the defects only, my lord, were cleared, my lord, in, I think, my lord, in August.
What about this marriage not being a marriage at all? I mean,
don't know why my understanding
the
is saying that,
certificate is not under Hindu Marriage Act.
in,
Yes.
my lord, section 2 of, my lord, the my lord, kindly look at
ওই দেবো
দিন।
my lord, kindly look at the Hindu Marriage Act, the first, my lord, section 21A. This act applies to any person who is a Hindu by religion.
Yes, Arya Samaj.
Yes, in any of its forms or developments, including a Sansan Sana Arya Samaj.
That is an admitted.
Yes, and my lord, in the certificate, my lord, kindly look at, my lord, the lady, my lord, resides in, my lord, Delhi.
Yes.
And my lord, the certificate says specifically.
No, what is this certificate of marriage under compulsory marriage order? We fail to understand. It has to be under the Hindu Marriage Act.
Yes, but my lord, this is how, my lord, they registered, my lord, in that, my lord, it's before the district magistrate. Kindly see.
It is before the
It's, my lord, the local, my lord, registration there.
marriage officer, office of
Yes,
the marriage
yes.
officer.
Correct. Certified marriage between Sansach having been solemnized at Arya Samaj Mandir Vidya Bhavan Trust. Well, that's only the venue. The Sansach, according to the custom practiced by the parties duly witnessed.
But
By
this
such
is
and
Mr. Banerjee, this is based on record. This is not the marriage certificate at all. The magistrate says it was registered before a marriage register.
Yes, well, that's
But
what-
where is that marriage officer's certificate? That is the marriage certificate.
This is one of the one having been duly registered on 3rd July 2024 at the Office of Marriage Officers, Shahadara District, Shahadara at the Sansach office.
No, Mr. Banerjee, subject to correction. This is office of the district magistrate Shahadara. District magistrate is not the marriage officer. He cannot be the marriage officer, he or she. District magistrate is certifying that there has been a marriage before the marriage officer, which is 2 grades beyond the actual registration. This is not the marriage registration certificate at all.
On basis of particulars furnished in this office.
Yes, therefore those particulars were furnished. This is hearsay or based on record. Magistrate does not have locus standi. Magistrate gives several certificates. We take all certificates from magistrates. Understood.
Yes.
But this is a certificate by the
But
local
this is not-
magistrate.
Find out, my lord, but
This
is
is not a
what
marriage
my lord
certificate.
issued, my lord, as
You want to see the marriage certificate, actual marriage certificate issued by the marriage officer.
That is section 8 of the Hindu Marriage Act.
No, my lord,
that is
I am, my lord, this is, my lord, what my instruction. I can, my lord, again find out, my lord, on this issue. But, my lord, this is the marriage certificate. This is issued under, my lord, that particular, my lord, the local laws, my lord, there.
That it cannot be because
Local
of
law
the
cannot
section 8.
override Hindu marriage.
Yes, my lord, kindly look at it. It says certificate number. And it also says, my lord, where you can find this certificate also. My lord, the website is also there. Kindly look at, my lord, there's no other certificate, my lord, which is issued. It says has been duly registered on 3rd July at the Office of Marriage Officer.
Mr. Banerjee, can you please show us, not right now, maybe, please find out the rules under which, because
I can
section
find
8
it.
says for the purpose of facilitating whatever, state government, here Delhi,
Yes.
the Union Territory, may make rules providing that the parties to any such marriage may have the particulars relating to their marriage entered in the manner. That manner and prescription we want to see.
Very well.
If
my
you
lord.
can satisfy us that that is the procedure in Delhi,
Very
we will be satisfied.
Very Very good. I'll get that. But this is a certificate. Otherwise, there's no other certificate.
But in the meantime, you won't create any third party interest in the matter.
There's a
I don't know how
registration
a third party.
subject to correction. There's a registration rules of Hindu marriage even at Delhi.
No, maybe,
Yes,
but
we-
this
we-
particular
what is-
certificate which is issued by that particular area.
Could
or
be,
at
but
the
whether-
office.
if that permits
But
the
district magistrate, my lord, is not a person who can issue a notice, my lord, of a certificate of marriage.
prima facie, no.
It appears that it is in the office of marriage officers and such, and he's the one who can issue us. It appears that from the certificate, but I'll check. Since it's fallen from court, I'll check myself and come back on the next day. Because the marriage has happened in accordance to Hindu rights quite naturally, otherwise can't be registered.
Except Mukherjee, there is no scope of an interim order.
I'll tell you, lordship, there's only one thing.
The,
Lord,
the,
let
the,
them
the
not
fate of their
regularize-
marriage may be decided in the appeal, whether there is
Very
a
well,
valid marriage.
but let them not formalize the alleged marriage. Otherwise, my lord, what they will say, formalize means my lord, legalize. I mean to say, according to me,
it is legal.
It is not legal because
we cannot direct the only formalization which can take place after this. We cannot restrain that.
Lord, it is
And we
not-
won't.
As I have pointed out, Lord,
There is
the
no other question of
registration-
formalization because as per this, if this is accepted, then marriage has taken place. If we accept it,
Then your lordship will, my lord, restrain him from contracting further marriage.
status
Why
quo
I
regarding
say-
marriage as of today.
Contracting further marriage.
Lord, your lordship knows
I don't know
the
what kind.
injunction hoy sadharo.
Further marriage.
Yes.
I'm not very familiar with I'm sure not.
Matrimonial আমাদের তাই।
আর এখানে ডিভোর্স করে আবার ম্যারেজ করতে হবে।
Divorce তো হবে না এখানে।
তাহলে
No, need not. Mr. Mukherjee says you don't require a
You need not have a divorce. You cannot have a divorce here. Lord, with
we can't say that my marriage is not. It's illegal.
I
Not
can
yet.
say.
Or
I
not
can
yet.
say.
Unless the appeal is heard in his favor.
Whatever happens in the meantime shall abide by the result.
That is what I.
Lord, there might be something more happening, my lord, that is never, my lord, subject matter of an appeal, my lord.
We cannot implement the injunction. Learned senior counsel appearing for the petitioner argues that the purported marriage registration certificate, which has been annexed to the affidavit in opposition at page 72 thereof, by which allegedly the respondent husband has remarried, is not valid in the eye of law. First up, it is submitted that the respondent has allegedly contracted such further marriage under the provisions of the Arjo Samaj rules. First up, it is submitted that the Arjo Samaj comes within the purview of Hindus, and as such, the provisions of the
We have contracted Hindu marriage.
no, is there some.
Oh, there's. I'm sorry.
কোনখানটা ছাড়লাম একটু? Hindu Marriage Act are applicable. Push up next para. Learned senior counsel points out that the divorce decree impugned here in the present appeal was passed on March 22, 2024, and the present appeal was preferred on April 30, 2024. Full stop. Learned senior counsel places reliance on a letter written by an advocate who had lodged caveat on behalf of the respondent, dated May 2, 2024, where the number of the present appeal has been quoted, thereby clearly indicating that the respondent was fully aware of the pendency of the present appeal when the purported subsequent marriage took place on July 2, 2024, allegedly registered on July 3, 2024. Full stop. Hence, apart from the said marriage having been allegedly contracted with full knowledge of the present appeal, it is also argued that the registration is not a valid registration under Section 8 of the Hindu Marriage Act 1955. Pushap Learned Senior Counsel points out that the purported certificate of marriage was under compulsory marriage order and not the Hindu Marriage Act, and was issued by the district magistrate at Shahadara, Shahadara district, Delhi. First up, it is argued that as such, it is not the marriage registration certificate issued by the marriage officer. First up, as such, the petitioner insists on an order of stay of operation of the impugned decree, alternatively, an order of injunction restraining the respondent from contracting further marriage. First up, next para, Learned Senior Counsel appearing for the respondent argues that as per the extant provisions and rules formulated under Section 8 of the Hindu Marriage Act in Delhi, the certificate of marriage annexed at page 72 of the affidavit in opposition is the format in which such marriage certificates are issued. So it is pointed out that the marriage was contracted under the Hindu Marriage Act on July 2, 2024. At that juncture, it is submitted that the stay application had not yet been filed. The said application was filed subsequently on August 30, 2024, and copies thereof were served on the respondent only in the month of November 2024. As such, it is argued that there was no fetter at the time when the second marriage was contracted. Next para, upon hearing learned counsel for the parties, we are prima facie of some doubt as to whether the certificate annexed at page 72 of the affidavit in opposition has been is a valid and proper certificate of marriage. Next para, first the said certificate was issued apparently not by the marriage officer but a district magistrate who issued the said certificate to the effect that a marriage had taken place and was registered at the office of the concerned marriage officer. Secondly, there is no indication that the marriage was that the marriage certificate was issued under the Hindu Marriage Act, but the certificate reflects that it was under the compulsory marriage order. Next para. At the same time, we are aware that it may very well be that the rules framed in for the Union Territory of Delhi under the purview of Section 8 of the Hindu Marriage Act might permit such certificates to be issued, which is for the respondent to satisfy us by relying on relevant rules provisions in that regard. In order for the respondent to produce relevant documents in that regard, leave is granted to the respondent to file a supplementary affidavit annexing all relevant documents by January 10, 2025 with an advance copy to the learned advocate on record for the appellant. The the appellant shall be at liberty to file rejoinder, if any, to the supplementary affidavit within January 17, 2025. The application shall be listed next on January 20, 2024. Next para. The marriage, the subsequent marriage, if any, contracted by the respondent after filing of the appeal shall abide by the outcome of the appeal. Grateful. Thank you. Because these adjudications, these are tentative, but this will also have a bearing in the final hearing of the appeal also.
Yes, my lord, I'm aware, my lord. I'll show the law on this.
Yes.
My lord, what is falling from, my lord?
We have to.
2000 Calcutta, my lord, which my learned friend, my lord, relied upon.
Yes.
But I seen, my lord, that's one of the parties challenging it. One of the parties to the marriage challenging it, the daughter.
Yes. Yes,
but who had knowledge with regard to saying that no, it was not contracted according to the Hindu.
Mr. Banerjee, but the law was laid down there also. I mean, that it has to be.
He has to have knowledge. He's a third party to this to the marriage. He can't come and
There's
say
a
that no marriage.
he has a vested interest. His marriage, subsistence of his marriage, her marriage depends on this.
He can't give any evidence with regard to whether the marriage was there. That's
No, this is on law only. This is on law. Mr. Banerjee, let us not be. This is not merely on fact. You have to show the law that this is permissible.
Correct.
If this is a valid marriage, then we accept it and pass order.
Yes.
In any event, there is little scope of injunction at this stage, but even then, if there is no subsequent marriage, then they are entitled.
And section 15(2), my lord, I am entitled to an order. Because, my lord, I have shown before your lord.
Yes.
My lord, we'll show on 15 as well, my lord.
Yes, we have not
I've
decided
looked
on
at the law of these branches.
Yes. We'll take up the next matter, this matter.
Okay.
Please call the case. Yes, what is the matter? What is the appeal against?
Appeal against the preliminary decree of a partition.
Right.
The appellants are the added respondent number 5 and 6. The preliminary decree has been passed.
Added defendants number 5. Preliminary has been passed. You dispute the share.
Think for a moment, one of the plot
Hmm.
which has been transferred long back. That in the written statement filed by the defendant number 1, it has been reflected. Thereafter, the name of the defendant number 5 to 7 has been added. Now, the things for a moment, one plot, other than things otherwise, only one plot, number 25. This plot has been transferred by way of favor in favor of the defendant number 1. And thereafter, defendant number 1 transfer the share to the respondent number 5, 6, 7. That has been held when the order has been passed, including the plot number 25. That is contention.
No, if it has been done including that, but you have also been implemented. Oh, you are not a party to the. You say you are added defendants. So you had been added as parties to the suit.
That's true, but not the original partition suit. In the suit, not the
No, we don't understand. See, if you have purchased a share in the property, you could
property of from the defendant number 1.
whoever. So then you become a co-sharer also. So if you become a co-sharer, you are added to the suit, and that property is also within the hotspot because you could not have purchased a demarcated portion. So it's a joint property. You are one of the co-sharers now. So now shares have been declared. What is your difficulty with that?
My share has not been given at all.
Great. So you want we'll pass an usual order. The final degree proceedings will continue. No final degree will be drawn up, as we do in all cases. We'll do that. The present appeal arises out of a preliminary decree of partition. Full stop. Upon hearing learned counsel for the parties, can 1 of 2024 is disposed of by directing the trial court to proceed with the final degree proceedings. Full stop. However, no final degree shall be drawn up till disposal of the present appeal. Full stop. You are for the plaintiff respondent.
I am for the plaintiff respondent.
What about service on the others?
Service has been done.
Acha, till disposal of the appeal na till disposal of the application. Full stop. What is this on them? Affidavit of service filed. Affidavit of service filed to be kept on record. Full stop. Although the caveator stroke respondent number 1 has been served, the petitioner shall serve copies of the application on respondent numbers 2 to 5, indicating that the application shall be listed on January 13, 2025, when a further affidavit of service to that effect shall be filed. We have granted stay till disposal, this order till disposal of the application because it's a partition suit. They also have to be served. Serve and come back. We'll take it up on 13th and dispose of this step.
Only one electing this position. Position is in favor of the.
You have asked for only stay. This is an application for stay only. No injunction has been sought. You have to ask for injunction. You can file an injunction application in the meantime. Position you have to satisfy the court because you are a stranger purchaser. So therefore you have to file an application for injunction and make the pleadings. We won't advise you further. You are sufficiently senior. Yes. Thank you. 28.
I am for the plaintiff respondent.
Plaintiff respondent. Very good. What is the suit for? What is the?
Mr. Mahato is appearing.
Mr. Mahato is appearing. Till he appears, what is the appeal from? What is the appeal from?
Partition suit, my lord.
Well, I am for the defendant, my lord. Defendant in a suit for partition.
Mr. Mahato, this is against preliminary or final degree?
Preliminary degree. My lord, the suit property has been directed to be, my lord, given half share to the plaintiff and half share to the defendant number 1 and 2. So for the defendant, my client is concerned, appellant before it, lordship, my lord, no share has been given to him. Because my lord,
on what ground, Mr. Mahato? Not given on what ground?
The deed which has been produced, my lord, in that deed, 2 names are there.
Acha.
the predecessor of the plaintiffs and the predecessor of the defendant number 1 and 2. But my lord, so far I
Yes.
am the appellant is my lord the one of the son of the defendant number 2, predecessor of therefore my lord the defendant number 1 and 2 and the appellant are two brothers.
Acha.
But my name was not in the deed. Therefore, my lord, court has not given. But in the record of rights, my lord, the 1/3 share has been allotted in respect of all the three brothers.
All right. So
My lord,
all of
three
you are in
brothers
possession.
my
What
lord,
is the finding regarding possession?
yes, my lord.
Any finding
There,
in
there
the
is no
trial court
finding, my
judgment
lord,
regarding your
regarding
possession?
No.
Did you
But
have
they, my lord, they have not prayed for, my lord, the record of rights is erroneous. That prayer is not there. Although in the body, there is, my lord, the prayer that it is erroneous, but in the prayer, there is no
No,
prayer.
record of right records your name also? Or your
My lord,
predecessor?
my name. My lord, I have annexed the records. I have annexed the record. It runs
well.
from page
Yes, so what do you
page
say?
10 of the
Very well, Mr. Mathur, yes. We shall grant status quo regarding possession and no third party interest. We'll pass that order. Third learned counsel for the parties.
Others, my lord, my lord.
Oh, others have to be served. You are for respondent numbers?
My lord, I am
plaintiff's respondent. He is for the plaintiff
Acha, very well,
respondent.
very
I
well.
am to serve the other
Yes,
defendants.
yes, right. Very well. Hard learned counsel for the parties, full stop. Although the plaintiff's respondents are represented through counsel, comma, no service has yet been effected on the other respondents, full stop. Accordingly, the petitioner shall serve copies of the present application on respondent numbers 12 to 19, indicating that the application shall be listed for hearing on January 13, 2025. Full stop. An affidavit of service to that effect shall be filed by the appellant on the next returnable date. Full stop. Next para. The parties shall maintain status quo as regards possession in respect of the suit property, as well as with regard to the nature and character, and shall not create any third party interest and or transfer or encumber the suit property in any manner in favor of third parties, comma, till disposal of the application. Thank you, Mr.
I am
Mathur.
grateful to lords.
I appeal.
Yes.
From I am
Respondent.
Respondent.
Yes.
So I
Why
just
that smile?
received the brief.
So what?
Your
We
lordship.
have also just received the. Prepare yourself. What is this from?
In fact, so have I. Thanks to Mr. Gorai.
No, this is an appeal against what?
Appeal against the refusal of an ex parte order of injunction in a suit where I have said that you can't have CCTV cameras prying into my house. So, if your lordship will just consider,
what sort of litigations are coming?
This is a sorry. This is a joint family property where it actually belongs to the trust. Your lordship will imagine this as the house and the corridor of this court as the corridor of the house. So what has happened is he's gone ahead, and this particular erring brother has gone ahead and put CCTV cameras which are right on top of my room and cameras that look almost inside my room. The only difficulty is that
close your door.
No, Mullah, there's a that's an option, but there is a bathroom which is at the end of the corridor. Now these CCTV cameras even
You have to
feed the-
litigate for this. There is no mediation.
Well,
You two are there. Please try resolving the matter between you. What sort of litigation is this? The CCTV cameras in the bathroom and
the family
nonsensical
issues, these won't
litigation.
get resolved. From what I'm given to understand by Mr. Gorai, these are family issues. It won't get resolved. These CCTV cameras can't be there. I'll probably indicate why.
I'll compel Mr. Gorai to look at the footage for 24 hours.
No, I don't even have
continuously.
access to, so I don't know what's
If he's
being recorded.
satisfied that this is all right, then he'll. Otherwise, he'll convince his client. No, Mr. Gorai, these litigations, both of you. I mean, what sort of a litigation is this? To come to court for this?
I don't. One of the CCTV camera installation.
It's all in the family, must be. Yes.
Yes. All within the
Brothers.
family. Installation of CCTV camera is the issue. I don't have control of the CCTV camera. I don't have control of what's being recorded.
Obviously.
My wife, my mother, whoever gets out of my
No,
room.
definitely.
And it goes to
Privacy issues are there.
Privacy is the main concern. Let him.
Yes.
He argues parallelly and gives the full sentence. Your lordship will kindly allow full sentences parallelly.
So Gorai himself argues very well. That's why
That's
it's very difficult for him to restrain himself when somebody else.
But I can understand. him
I identify with him. It
him
was very
prompting-
difficult to assist people.
But full sentences, then I definitely can't.
That I did not do. But 3/4 of the sentences, yes, I went up to that.
No, he starts with your lordship will kindly grant me the full thing. So this one of
Yes.
the injunction that I seek today.
How can you implement the injunction? That is what we are wondering. I mean,
But,
CCTV, then somebody has to be there. As special officer, I'll appoint you as a special officer, Mr. Banerjee. You will be there and ensure that the CCTV is not operated. Do that. Or Mr. Gorai,
No,
he's a good choice.
there
He'll be there.
CCTV cameras have a plug point that will just have to be switched off. So at this level, at
That also
this
we cannot
stage,
implement.
at,
Enforce.
not if they violate, I'll be able to show pictures and come back. Not I understand what your lordship is hinting at, but this can't be where I don't have access to CCTV cameras that are installed. Everything is getting recorded. People are accessing a common.
The suit
loop.
is for that.
Suit is for that.
Great, great. Fantastic.
So at least
So important questions of law will be decided. Let us see the prayers in the suit.
Prayers in the plaint, not page 24 is the plaint. And the prayers are page 29. The suit is for that. My right to enjoy the property, my right of privacy.
This is vague. No, surveillance cameras is there.
Surveillance camera.
Yeah, this can be resolved between the parties. Try to resolve the matter between the parties. In the meantime, what sort of injunction are you expecting?
Let them not operate it till it gets the mediation. They can take 1 week. In the meantime, during the vacations, they
Don't
can
operate the CCTV there.
Your lordship, if I may.
Yes, you want to operate. No,
Your lordship kindly does not pass such order. I will talk to the client.
no, your
Your
talk
lordship,
may not be
I'll-
fruitful.
Your lordship, why I'll tell you.
In these circumstances, when brothers are in arms, very difficult.
Your lordship kindly allows me. It is in the corridor and not in the
The
room.
difficulty is, you know, why
Lordship.
nuclear bombs are so powerful, because the bond in the first place was so tight.
I-
The tighter the bond, when they break up, there is more explosion. So if it's in the family, it's very difficult to resolve. I'm telling you, if it was strangers, then yes. But family CCTV, this context, your talk to your client may not be of any benefit.
Your lordship kindly also
Don't use the
considers-
CCTV cameras in the
Your
meeting.
lordship
week
kindly
also, I'm
also
agreeable to
considers-
that.
Don't die if there
My
is no
learned
CCTV.
friend's only objection is that it's from the CCTV, the room is visible. So if that is not so, then the objection goes.
No, room,
itself.
corridor, access to the
Corridor,
bathroom.
your
everything.
lordship, your corridor is we all
No,
are
it's a privacy issue also.
I completely
I mean, if all of us reside there together, if one of the brothers puts up CCTV cameras without the permission of the others, maybe some issues. Outside the building, yes, for to prevent burglaries and all, yes. But inside, it's very sensitive. Yes.
But I'm agreeable to go into a mediation. We can come back a week after.
I'll do that.
Yes. And in the
We'll do
meantime,
that,
they
yes.
don't operate, we can just.
Your lordship, the only reason is, I'll tell your lordship, the corridor is filled with antiques and life-size statues, and also small antiques, which is why the CCTV is only there.
There can be CCTV cameras outside the
No,
house.
antiques cannot be justification for these antiques.
Your lordship, but
Putting
I can-
CCTV camera with the corridor, we appreciate you. There may not be malafides behind your installing the cameras, but they're feeling threatened as far as the privacy.
Your lordship, I appreciate that what has fallen from your lordship, but your lordship kindly considers
You
this
sit
also.
together, let the brothers sit together, the entire suit will be resolved.
Yes.
Please, your client seems to be a very reasonable man. He appears to me to be if he is reasonable, his brother must be equally reasonable. I mean, they are educated people, they have their senses. Why not sit between yourselves and resolve where the locations will be there? And we'll put it in our order so that it helps them.
That your lordship kindly.
But in the meantime, don't operate. Don't
But
operate.
kindly
No,
consider-
no.
Your lordship gives a very limited period for the resolution for that matter, but kindly
Till
does
10th
not
of
do
January,
that.
we are restraining. We'll put it on 7th of January. The application will appear on 7th. Till 10th, you won't operate the CCTV. If you could live without the CCTV cameras for so long, then you can live till 10th.
But your lordship kindly sees this, kindly appreciates this. Your lordship, the only reason is the antiques. We are not behind what they are
Why didn't you
doing.
take their permission first?
Your lordship,
could
the
have asked
permission
them.
will never come. That is the reason. So
I put the antiques elsewhere where they're more secure.
your lordship, then
Put them in a
the
locker.
house will be filled with
No,
antiques.
there
all
can
the
be
rooms.
CCTV cameras outside.
Because
The security
outside-
guards outside.
Outside, yes. Outside, nobody has any issues.
Nobody has an issue.
Outside, immediately outside, on all sides, maybe. There are 360-degree cameras also.
These are only the common
Inside
passages
the-
which we all use are under
Correct.
CCTV.
So the
That's
artifacts
within the house.
outside the house.
Yes, your lordship, within the house, but outside the personal spaces.
And if 7
including my
days,
personal spaces.
We'll look
7
into
days
that.
don't use and just finish
Including
it
my
off.
person, yes, absolutely. But the order, your lordship kindly says that it's only in the common areas which we are using, which they are
No,
using.
there's a doubt regarding that. So if there's a doubt, there's a tribal issue.
Then in
We'll
your
understand it.
lordship, if your lordship so feels, I will, although I haven't taken instruction from my client, may I only propose this? I'll take instructions if your lordship so feels that let the footage of the CCTV camera be at,
I will check that footage. Sorry.
no,
Enough.
not your lordship, but where they can-
Ultimately, we'll have to check.
But-
Ultimately, they'll dispute and you will dispute and we'll have to check. Sorry.
But your lordship,
If your
kindly
CCTV footage
appreciate
with yourself,
else I won't have
inside the corridor, inside the corridor is inside the
corridor
house.
is the open space, your lordship, because
can-
one side is the wall where there are rooms, and the other side it's towards the courtyard. It's completely open.
You keep somebody, he will keep a vigil throughout the day. But no CCTV cameras.
Your lordship,
Keep
right-
somebody,
right
maintain a person, he will be there.
outsiders
Security
for the-
guards outside.
Security guards, put a security guard will from outside he'll look inside, but no
Your
CCTV
lordship,
cameras.
instead of
CCTV
the
camera
family
records.
members, the security guards will look.
No, they'll look and
They-
forget, but the CCTV camera will not.
That
It will be
money-
on footage. That footage will be preserved. No. Their privacy there is sufficient reason for them to feel threatened insofar as the privacy is concerned. If some if on an inside corridor a CCTV camera is put in,
Your lordship kindly also takes this into
it's a
consideration.
common
from when-
property. You cannot do this. You cannot do this in a common property. No, put it somewhere. Yes.
Outside is absolutely fine.
Outside or put the artifact somewhere which is exclusively in your possession.
Your lordship.
Put the antiques
lordship,
in your room.
If I may, I apologize.
No,
for
no,
your
why?
lordship.
Yeah.
What I am told by my client, your lordship, there are 16 CCTV cameras all throughout the corridor, including our rooms. But
That does
outside
not
our
give.
room, only there are 2 cameras only, which is outside in or around their area. Only
No,
2
but
cameras.
if I'm walking
But-
around my own house, someone
Very
will
well.
let
I'll direct a special officer. I'll appoint special officers. Your advocate on record, their advocate on record. They'll go and give me a report. Give us a report.
Very well, your lordship.
We'll do that.
Yes.
Who is the advocate on record?
Very well, your lordship.
Kindly appoint neutral. Mr. Gorai's friend is involved. He doesn't want to be.
Then he should not be in the litigation in the first place.
No, he doesn't want to become
No,
a
no.
special.
Advocates on record for both parties. That will only. No, then he should not have taken the case in the first place, Mr. Banerjee.
Very well. Advocate record.
Should not have taken the case. Let him go there, have a cup of tea, ensure that the other side also has a
They
cup
can
of tea.
sit and negotiate and finish this off. Not that you also your lordship will provide for.
Yes.
Otherwise, it's pointless.
You don't have to go. The advocate record will go.
The present litigation arises over a.
He injuncts them from using it for these few days.
Yes.
But your lordship kindly.
The present litigation arises out of a furor, apparently over a cup of tea. Full stop. The plaintiffs stroke appellants allege that the plaintiff stroke appellant alleges that the defendant stroke respondents in the suit have. One second. This is City Civil Code.
Yes,
your lordship.
That
Well,
the
one more thing. Sorry, there
not
is a
admitted.
No. There's a 7 days delay.
Then
Condemnation. For that,
what is that can?
Can too.
What is the reason?
7 days delay.
Reason. Time is the length of delay is not important.
I'll just say.
If the reason is some previous advocate, then you're gone.
No, reason is not. Paragraph 4. In fact, that has
Elements,
been
para
praised.
7, para 7. In view of sufficient reasons having been given for the delay in preferring the appeal, Can 2 of 2024 is allowed on contest, thereby condoning the delay in preferring FMET 172 of 2024. Full stop. In view of questions of law and fact being involved in the appeal, the appeal will be heard on the grounds taken in the memorandum. Full stop. Next para. The present litigation arises out of a furor over a cup of tea. Full stop. The plaintiff stroke appellant alleges that the defendant stroke respondents have installed CCTV cameras within an internal corridor in the house which is jointly owned by the parties, full stop. Such installations, comma, it is alleged, comma, are creating serious privacy issues for the plaintiff and his family members. Full stop, it is alleged that some of the CCTV cameras are directed not only towards the rooms of the plaintiff and his family members, but also towards a washroom at the end of the corridor. Full stop, such allegations are denied by learned counsel for the respondents. Full stop. However, comma, we are prima facie satisfied that the that in the event the CCTV cameras are operated in the meantime, comma, there may be certain privacy issues, privacy risk for the family of the plaintiff, comma, at least on a prima facie footing. Full stop. Next para. Accordingly, the respondent shall remain restrained by an order of injunction from operating the CCTV cameras installed by the respondents within the suit premises till January 10, 2025 or until further order, whichever is earlier, full stop. The application shall next be listed on January 7, 2025 for the purpose of exploring options of amicable settlement between the parties in the meantime. Full stop. It is expected that learned counsel for the parties shall use their good offices in that regard, and the court sincerely hopes that since the dispute is over trivial issues and between family members, comma, the same will be resolved when the matter is next taken up by this court.
Your lordship is would be kind enough to appoint any special officer for taking inventory, because your lordship will file a report. Since your
Do this. Your clients, both your clients, you may go there. Both your clients sit together and just locate the points where there can be installations without invading their privacy.
No, your lordship, what
Do
I
that
was,
in the meantime.
What I
The
was
brothers have
only
to-
beseeching your lordship, if the money, if anyone, money, if the your lordship appoints any special officer who will go there, may inventorize the antiques in the corridor, and thereafter the
Antiques won't do, no. Antiques you can put in your own portion.
No, the CCTV will help me.
That is not justification.
39.7
If you
will
put
be-
your ornaments on an open place, which is a common place, and then install CCTVs, no. You keep your antiques in your private space.
That possibly cannot.
You rent a godown and keep your antiques there. Who prevents you? But you cannot install CCTV cameras in a common passage. No, not without the permission of your co-owners. Definitely not. And we are telling you, we are giving you sufficient indication. If there is no settlement, we may make this order absolute on the next date. We are being very clear on that. If you have your antiques, you put it in a private space and install whatever you like there.
In your lordship, all the members also have to agree, because those are not my own and my own things. Those are joint family property.
They don't want it. They don't want it.
Your lordship, then the fight will go a notch higher. Then immediately the fight will go a notch higher. That is the difficulty, your lordship.
Not?
A notch higher it will go. If we
Not notch higher regarding what?
If we try putting it somewhere in a safer zone, then the fight will start where to keep it. Because nobody will agree. Nobody will agree.
On 7th, if you fail to arrive at a reconciliation, then we'll look into that. No. Next.
The affidavit of service be kept on.
Affidavit of service filed to be kept on. কনসেন্ট ছাড়া কখনো হয় না আর সবসময় this appeal is from
Partition suit, preliminary degree.
Preliminary.
9 days delay.
Oh, this is the content. Have you served on the other side? First time. Serve copies of both the applications and the memo. Which is the can for condonation? Can 2.
Can 2 condolence.
Very well. Can 2 of 2024 has been filed. Sorry. Can 2 of 2024 has been filed for condonation of delay in preferring the appeal. Full stop. The petitioners shall serve copies of Can 1 of 2024 as well as Can 2 of 2024 along with a copy of the memorandum of the appeal on the respondents, indicating that the applications shall be listed next on January 13, 2025, when the appellant stroke petitioners shall file an affidavit of service to that effect.
Item 31 was right for the respondent.
Right.
You have filed an application, my lord, praying for whether maintenance.
See.
That application, my lord, first initially, my lord, came up for getting on, my lord.
This is that application.
That application.
No, my lord, so far I am concerned.
Yes.
So, my lord, there was a direction by your lordships that affidavit of assets should be filed.
Yes, both sides have to file their affidavit.
And I am filing this one.
My lord,
I've served copy.
May I indicate one thing? On the last year, my lord, I filed the affidavit of asset on behalf of the wife. My lord's order, may I file the affidavit in reply?
Copy there.
My lord, to the affidavit in opposition to the application. Is my lord my lord, the last day's order I have annexed, my lord, at annexure R2, my lord. My lord had directed to file the husband, the appellant husband, to file the opposition to the application and also file the affidavit of assets. So, my lord, peculiarly, my lord, on Saturday, my lord, after affirming this instant affidavit in reply, I have been served with the my lord, affidavit of assets. I have the email copy, my lord.
We find there are two, the back sheets say there are two affidavits in opposition filed. Do you, একই copy দুজনকে দিন?
এখন দিল?
Earlier assets on the last occasion.
That is, well, recorded in the order dated 9th of.
And what about a reply?
Reply, my lord, I have just handed over to them. Reply to the application. Opposition, affidavit or
কত কপি আছে ওখানে দেখুন reply you have handed over 2 copies.
একটা দিলি তো
দেখুন একসঙ্গে বাঁধা আছে কিনা দুটো
তোমাকেও এখন দিল
রিপ্লাই ওটা
ওটা একটার উপর দিয়ে পেয়েছি তার উপর দিয়ে
এটা শুধু স্ট্যাম্প করাটা দিয়ে দিন একটা জায়গায় স্ট্যাম্প করতে হবে এটা হচ্ছে অ্যাফিডেভিট অফ অ্যাসেটসটা
thing.
Yes, Mr. Banerjee.
And one thing I must finally confess.
What?
Confession is like this. Actually, in the affidavit of assets, I found it is written that well regarding bank account. Right now it is available. I'll file. Now today we have collected all these things in details. I'll hand over to him. No problem. He can inquire about this. I reply to you.
So that has to be a part of your affidavit.
That's why, my lord,
You cannot hand over just like that.
Very well, no.
That is the purpose of the.
Very well, I'll file. Because otherwise, my lord, after all, it is an affidavit of assets that includes the bank account.
Are you having any alimony at the present? Then we'll direct you to pay and make an ad hoc payment, Mr. Banerjee.
Well, what
You
I'm
cannot wait for your affidavit of asset. The bank accounts you have not disclosed.
Well, that is why, my lord, just in course of this day, but tomorrow we'll file it, might.
No, then when do you hear it? Then she goes without alimony, no?
Month of June, my lord.
Yes, yes. You cannot wait indefinitely for you to file your bank, disclose your bank accounts.
May I just, may I make one pair, my lord? Make one
Yes,
pair?
Mr. Banerjee, absolutely.
Where is this, my lord? That well, document is here. Anywhere affidavit to be filed. And salary certificate also there. The question is my lord.
No, unless those are supported by an on oath.
No, apart from this,
we cannot look into that.
Apart from lordship need not take trouble, my lord. I'll file affidavit. Another supplementary affidavit including these two documents.
Yes.
Now, question is, my lord, she claimed initially she was paid 35,000.
Mr. Banerjee, give us half a second. Opposition কোনো wife এর and reply, obviously.
And reply to the opposition against the application. Affidavit of asset of the husband has been served upon me, my lord, on my Saturday. I have the email copy, my lord, to show that.
So you could not get time.
No, hard copy now I am giving, my lord.
You were enjoying some alimony in the court below. In the court below.
Court below, my lord, I used to, my lord, 1 lakh rupees per month. my
You have
lord.
obtained a decree of divorce.
No, no, no. Yes, they are. That is.
What is the challenge against?
My lord, they have filed.
I
Your
filed-
divorce should dismiss.
Yes, yes. I filed the.
You are enjoying some alimony in the court below. Take instruction on that.
My lord,
How much?
1 lakh per month, my lord. I have annexed that order, my lord, in my application.
Go on making that payment, Mr. Banerjee, in the meantime, and you file your
Lord,
further
kindly appreciate
affidavit.
one aspect. I couldn't understood really first thing bona fide, one of the main factor. The document which is annexed in this affidavit of assets, if you logically check it up, all the documents which are filed after passing of the order of the trial court, not that any documents are filed earlier. So my lord, I spent these, and these are all regarding his treatment. And that is not more than some.
No, the current affidavit of assets has to be filed by her. She has done that. Well, it is only to be the current affidavit of asset, not previous.
No, absolutely correct. But whatever she has spent, because he's claiming on that basis, I will have to spend this amount for my treatment.
We'll deal with that. But for the timing, ad hoc basis, 1 lakh you were paying in the trial court. That was there was an adjudication to that.
Because that I preferred an appeal, my lord. That is before losses, my lord. Kindly consider one aspect, my lord.
Preferred an appeal against what?
Well, revisions, my lord.
You has been filed, but that has not been yet filed.
Kindly appreciate one aspect, my lord. I could understood because I fairly considered my others at the time of.
No, there is no fairness in your concession, Mr. Banerjee. You have not you have not disclosed your bank accounts. There is no fairness in individual level. Mr. Banerjee may be fair. Mr. Banerjee may be fair, but your client was not at all fair. You suppressed your bank accounts and you are just brandishing that document and saying that my client has given to me.
Salary receipts also annexed. Everything is annexed.
No, Mr. Banerjee. Bank accounts are the affidavits of assets which we want to look into. The bank accounts you have not disclosed. And you are saying you are bona fide.
I admit nothing.
1 lakh you have to pay in the meantime.
One thing, my lord.
Yes, Mr. Banerjee.
My lord, kindly appreciate this amount is really hefty. Amount.
Yes.
Since the childhood, she never bothered for her son. And
childhood of the son.
Sons. Actually, my lord, mother's childhood cannot come.
Maybe.
So, my lord,
did not bother for others' sons.
Vital aspect. For their
that is your allegation, Mr. Banerjee.
No, it's on record.
Even if she's a bad mother, she is entitled to alimony.
But I'm not saying for a moment that
we are on alimony only. Not
only good mother will be paid for that. Can't you appreciate 1 lakh?
She did not
1 lakh. And I paid. But why I stopped?
Must earn equally.
No, but why she misbehaved with my mother like anything. Coming to my house. Well, there's enough is enough. Basically, appreciate.
That is a good ground for divorce, maybe. But for alimony, no.
No, kindly consider this aspect. Initially, 35,000 was paid. I agreed to pay 56,000. And I paid it. Now, in spite of that 1 lakh, on what basis? I agreed to pay 56,000. I could understood. She is alone. And she is residing at her own house.
And she is alone does not give you any extra right. She is alone, that does not mean she requires less money.
No,
if she was living with someone
I'm not saying for a moment she will be deprived. But from 35,000 to 1 lakh.
What does your client do, Mr. Banerjee?
She is working, my lord.
He is working, obviously. Where?
Yes.
As what?
Well, as a chartered accountant. And only 3 years are late for, there's no other thing.
Where is he working now? Is he engaged in some...
Unless and Young audit firm. So, my lord, I agreed to pay 56,000.
What is your monthly salary, Mr. Banerjee?
That managed?
Page
number 31.
Tell us.
Page number 31. 1 lakh is too much. Well, I paid. But now it is impossible. I have to liquidate my liabilities. I borrowed the entire money for the education of my son.
Your son is living with you?
Of course, right from the beginning. When their mother left their both sons, their twin sons. And
twin sons are with you?
Yes. And even education loan, I'm sorry.
No, not. I asked him to stop. You are arguing. Yes, Mr. Banerjee.
My lord, even the education loan, which I borrowed from the bank, still it has not been liquidated finally. So within 3 years, I have to do everything. Because after 3 years, no pension, nothing, and no pension, other things. The private company, my lord. 1,40,000 per month, I am paying the loan. 2 sons. I agreed to pay 56,000.
1 lakh is 1/3 of that. The rule of thumb is 1/3 to 1/5. You want
Kindly
3 lakh.
appreciate one thing, my lord, one third,
One third is in any event, Mr. Banerjee,
my lord, it all depends.
permissible in law.
My lord, kindly appreciate, my lord.
Why should you reduce it unless it is set aside by the revision?
My lord, lordship need not set aside now. For the time being, kindly.
But pay something for that.
Yes, I agree to pay 56,000. I paid.
56,000 is.
Yes, my lord.
Why 56,000? Why not one third of your income, admitted income? 3
My
lakh
lord,
is your admitted income.
My lord,
Pay her 1 lakh.
one third, my lord, because my liabilities are all.
Is she also working according to you?
No, I'm not. I don't have any other allegation. Not working. But in the name of alimony, she cannot expect
one third.
But it is
one third is rule of thumb.
My lord, kindly see, my lord. It all depends. It all depends because I've got 5 children, and my lord, then one third question will not come. But it all depends. Kindly consider, my lord, I have to show my bona fide from 35,000 to 50,000. I on my own agreed to pay. I never did pay, but it's a misbehavior. Home loan.
But that, Mr. Banerjee, you know that cannot be a consideration in alimony pendent related.
No, my lord,
even if you have a home loan.
My lord, kindly
You have taken the loan, you have to flip it.
No, I appreciate. My lord, for the timing, 56,000 per one person.
So the only consideration we were thinking it over is because of you are maintaining 2 sons. So not below 75,000 by any stretch of
Kindly
imagination.
56,000.
No question.
I agree to that, my lord.
No, your agreement is immaterial, Mr. Banerjee.
No, when it was only 35,000. At that time, I say very well on my own. She never claimed. Court never says. Very well, after all, she's my wife because of her misbehavior. Not that any other allegation against him. This is not my allegation that well his involvement or any other.
Yes,
no.
what do you say? 75,000. Yes.
From which I used to receive 1 lakh rupees.
There is nothing. No explanation.
Page number 19,
No explanation, proper explanation. I'll come to that when appeal will be had.
19, yes.
19, second paragraph.
Right.
On the other hand, the petitioner has revealed in his affidavit of assets and liabilities that he has a monthly income of 11,85,730. He has only an aged mother who is dependent.
11,85,000 per month.
And my lord, from that one,
So he admitted before the trial court.
Who admitted? I never admitted.
recorded into order.
That is why I challenge. I never admitted that. How can it be?
Is it borne out from his affidavit in opposition in the court below or written objection to the that finding may be faulty? Do you have a copy of his written objection to your section 24 in the court below?
No, my lord, I am not having that right now. My lord, from that one, kindly come to the ordering portion, my lord.
But this is under challenge before a revisional court.
That has not been heard out, my lord, yet. My lord, the amount, my lord, that I used to, my lord, receive at that, my lord.
My lord, kindly come to page 14 once, my lord. It is my humble prayer, my lord. Kindly come to page 14.
No, you will get a reply, Mr. Banerjee. Let him finish.
I'm sorry.
Yes.
I'm sorry.
Yes.
My lord, kindly come to the ordering portion, my lord, at the same page.
On the basis of 11 lakh. On the basis of 11 lakh.
My lord, the affidavit of asset, my lord, that has been filed by the appellant husband hearing, my lord. The observation.
But he has filed his affidavit of asset, current affidavit of asset, saying that he has a current income of 3 lakh.
On Saturday, I my lord, could not.
So Mr. Banerjee also wants to use a further supplemented affidavit. So further supplemented affidavit, and he will give a copy to you by tomorrow. That will be filed on the next date. And
yes, I'll do that.
You will use a composite.
That is my fault. Our fault.
Composite rejoinder to that supplementary and their affidavit of asset. Yes, Mr. Banerjee, what do you
Finally come to page 14, my lord.
Page 14, yes.
Of affidavit of assets.
Affidavit of asset.
Yes.
Your affidavit of asset, obviously.
Yes, my lord, deeply obliged. Okay. I ought to mention that.
Affidavit of asset. Page 14, yes.
Details of any EMIs being paid.
But you forget to disclose your bank account.
Well, I just told them, you are absolutely correct. That's why today, before taking the matter, I said, this is our fault.
by your term. And I've collected the latest positions. I'll file it by tomorrow. Deposit is only 11,36,000.
No, no, even as per your current disclosure, you are earning 3 lakh per month. Even if it is not 11
Yes,
lakh.
but per month, what about the other liabilities? Kindly see to be balanced. Kindly see the page 14.
Yes.
Kindly consider this, my lord.
The affidavits of assets of the applicant stroke wife, as well as her affidavit in reply, along with the affidavits of assets and affidavit in opposition of the husband filed today are kept are taken on record. Full stop. Next para. Learned senior counsel appearing for the appellant husband submits that due to bona fide inadvertence, comma, the disclosures regarding the bank accounts and the balances therein of the appellant husband have not been made a part of the affidavit of asset of the husband. Full stop. Learned senior counsel submits that the said documents shall be produced by way of a supplementary affidavit by tomorrow.
I'm grateful, man.
Full stop. Next para. Learned counsel appearing for the respondent wife submits that the respondent wife did not get an opportunity to file any rejoinder to the affidavit of asset of the husband, since the same was filed at same was served on the wife only very recently. On the learned advocate for the wife only recently. Full stop. Next para. How, be that as it may, comma, the appellant stroke opposite party stroke husband shall file his supplementary affidavit to the affidavit of assets disclosing the balance, the bank statements stroke accounts, bank statements stroke details of bank accounts of the husband by tomorrow, and serve a copy thereof on the learned advocate for the respondent wife also by tomorrow. Full stop. Next para. Composite affidavit, composite rejoinder, comma, if any, to the affidavit of asset of the husband as well as the supplementary affidavit of the husband shall be filed by the wife within January 10, 2025. Full stop. The application shall be listed for hearing on January 13, 2025. Full stop. In the meantime, comma, the appellant husband shall make a lump sum payment of an ad hoc alimony. One lump sum payment, Mr. Banerjee, 1 lakh of rupees 1 lakh to the respondent wife within a fortnight from date. Full stop. It is made clear that the said amount is directed merely on a tentative basis and shall not be to the prejudice of the contentions of either of the parties at the final hearing of the application. This much.
My lord, I should send it directly to the bank account of the wife.
Yes, give your bank account.
Yes, that will better my.
We hope you have shown your bank account in the. So there is no risk in disclosing that. The for such payment, comma, the learned advocate for the respondent wife shall disclose the particulars of the bank account of the respondent wife to his counterpart appearing for the appellant husband by tomorrow. Full stop. The payment of rupees 1 lakh as directed above shall be made by direct transfer to the said account. He is in court. Yes, give his name.
That was the fight between two brothers, Kuruketto. And my lord, ওদিক থেকে বলছে এদিক থেকে দয়া করে বলবেন না ছেলেপুলেরা খাবে কি একই অবস্থা অবস্থা খুব খারাপ.
No, Mr. Banerjee, if there is early disposal, civil avostha will become better. We can assure you that. Civil avostha will become better soon. We can assure you that. Just let some matters be disposed of. See, litigants will come rushing in. Thank you. Yes, Mr. Banerjee.
আমার আশা করার কিছু আর নেই.
No, but the way the juniors are being encouraged, you may be in jeopardy. People like you.
May I leave my lord?
Yes, Mr. Banerjee. 32, yes.
I appeal from a decree of eviction. Lordship, on the last day when it directed me to serve the plaintiff, who is the respondent, but the plaintiff himself had refused service, but the advocate has been served. But,
So you're ready with the affidavit of service?
Yes, yes, yes.
You're appearing.
We had 27 days delay. Out of.
Delay application.
Yes, Manoj, there's a
27
delay of
days.
327 days.
On what ground?
On the ground that Manoj, paragraph 28 of my application for condonation of delay, Manoj, before Manoj, addressing your lordship on that, Manoj, between the same parties, there was another suit where your lordship has considered my grounds for delay and Manoj allowed the application for condonation of delay, Manoj, on 3rd December 2024.
Same ground was there.
Same ground. Between the same parties, even the date of the decree was the room was separate from the other suit. The grounds were similar. But may I hand up a copy of that order?
Yes. Have you got a copy for him, your learned friend? Otherwise,
But
you are
I'll-
relying on this. You are present on that date also.
Yes, Manoj, it was present. We don't even have a copy for ourselves.
There are 12, 13 এর এজটা অ্যাডভান্সড এজটা দেখেছি আর রাজনীশকে ডিসটিংগুইশ করেছি। হ্যাঁ, ওই অন্য কেসগুলো পেন্ডিং লিটিগেশন ছিল, সেখানে ঠিক মতো নজর রাখেন। এখানে জাজমেন্ট logic applies. Age remains the same. Why two appeals then?
But there are the two premises, two
Different
separate
premises.
Separate suits, not separate appeals.
Applied person is the constituted attorney. He never appeared before the court.
No, after the judgment was passed, because it is his decision to prefer an appeal. That is the line of distinction. Our second line of distinction, as we find from the judgment, previous judgment, that litigant is to inquire about his case, either himself or through his constituted attorney during the pendency of the litigation. But once the judgment is reserved, every day if the litigant comes to us and inquires about the what happened, whether judgment has been passed, that would be disturbing for us also, advocates, us as an advocates.
Judgment should have relied on this particular matter.
Supreme Court judgment, Justice.
See, this is an ex-parte, or in spite of that, Supreme Court affirmed the finding.
Yes, but while affirming, Supreme Court made certain guidelines. I mean, malafides still remain. You have to show their malafides. One. Secondly, they could not have derived any benefit from this. These factors also go in their favor. Even in that judgment, previous view has not been changed, but not as a matter of right. Vigilant litigant, and you cited those judgments also. Those were considered, and this is the ground. 327 days.
327 days.
Heard learned counsel for the parties. Upon a careful consideration of the arguments of the parties, we find that the delay occasioned in the present in the filing of the present appeal might not be entirely attributed to the negligence of the appellant stroke petitioner. Full stop. Apart from the appellant being a septuagenarian, suffering from various ailments, we also find that the negligence, if any, could have occurred in the event the appellant did not take regular information about his case during the pendency of the suit in the code below. Full stop. As opposed to that, the delay here was occasioned because the appellant was not informed about the outcome of the suit after the judgment and decree was passed therein finally. Full stop. Undoubtedly, a litigant has to be vigilant throughout the pendency of a litigation. Full stop. However, once a suit is reserved for judgment, the litigant is not supposed to inquire from his learned advocate every day as to the outcome or fate of the said suit. Full stop. After hearing is concluded, we find some substance in the submission of the appellant that it is for the learned advocate who had been conducting the matter and should be in the know of the fate of the suit when judgment is delivered, to inform the said outcome to the litigant. Full stop. Keeping in view such mitigating factors, we do not find that any malefides could be attributed to the appellant in preferring the appeal late. Full stop. Furthermore, in the facts of the present case, delay in preferring the appeal could not have inured to the benefit of the appellant, since the appellant is under the guillotine of being evicted due to the impugned eviction decree. Full stop. Next para. Accordingly, we are of the opinion that the reasons shown in the application are sufficient to condone the delay in preferring the appeal. Full stop. Furthermore, under similar circumstances between the same two litigants but in a different appeal in respect of a different premises, a delay of almost equivalent number of days was condoned on the logic as given therein. Full stop. The said order dated December 3, 2024, passed in FAT 228 of 2024, within bracket can 1 of 2024 bracket closed, also operates as a precedent in the above regard. Full stop. Hence, can 2 of 2024 is allowed, thereby allowed on contest, thereby condoning the delay in preferring FAT number 282 of 2024. Full stop. Next para. Stay now. What is the stay application of can 1?
Yes, can 1.
Can 1 of 2024 is now taken up for hearing. Full stop. Yes.
It's a decree for eviction.
Decree for eviction.
18th October 2023 is the date of
Have you did you direct affidavits in this matter?
No, madam. But in the other matter, Lordship had, but not in this matter. Lordship has not.
Only late and written statement because order 12 rule 6 has been allowed. Judgment on this.
Oh, no. Opposition for the purpose of this occupation charges.
Yes.
Use the occupation charges is required. But against order 7, rule 11.
Order 12 rule 6.
Order 12, rule 6.
Yes.
We have fixed the other appeal along with the application.
This has been a contested judgment.
Yes, but that your Lordship has.
Oh, that was a contested judgment. This we can fix along with the application.
Yes.
We'll direct affidavits to be filed in the meantime.
Also, Lordship,
Order 12, rule 6 means he's right. You filed your written statement.
But I was a defendant.
Oh, sorry, 12.6 has to be.
I filed my written.
You had to file it. Otherwise, so no evidence was laid, obviously.
But some evidence was laid. During the cross-examination of our witness was going on.
Oh.
And at that juncture, this order 12 rule 6 application was filed.
Can you take out certified copies of this?
I have annexed. I've pleaded. But I shall.
The evidence also you have annexed.
No, not the evidence, but my affidavit of evidence has been annexed in this.
So that was the stage up to which it went. There was no cross-examination.
But during the cross-examination, there was also an admission that I had.
But then you have to.
I shall have to bring on record.
Very well. In view of the appeal itself having been taken out against a judgment on admission under Order 12, Rule 6 of the Code of Civil Procedure, we are of the opinion that the trial court records need not be called for at this juncture. Full stop. Next para, in view of appearance of the respondents through their learned advocates, service of notice of the appeal is also dispensed with on the respondents. Full stop. It is deemed that all other formalities are complied with. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within January 17. We are giving you 3 weeks after, 2 weeks after. January.
Yes, madam. 3 weeks, madam, if you like.
Very well. January 24, 2025. and serve advance copies of the same to the learned advocate for the respondent. Full stop. Affidavit in opposition to the present application shall be filed within January 10, 2025. Full stop. Reply, if any, shall be filed by January 24, 2025. Full stop. The appeal along with Can 1 of 2024 shall be listed for hearing on January 28, 2025. January 20. There shall be stay of the execution has been levied.
No, my lord, execution 17 or 28.
There shall be stay of operation of the impugned eviction decree as well as connected execution proceedings till February 15, 2025 or until further order, whichever is early. We have granted limited stay.
Well, only one correction, my lord. It is my fault, my lord. The laws in our department had indicated delay of 297 days. Well, we had indicated 327 days. The
We
laws-
did not mention the period of delay.
Perhaps in the first paragraph, lordship may have, my lord.
Oh,
I may have.
এই প্রথম
If lordship
প্যারাগ্রাফে
has not
যেখানে
noted-
ডিলে অফ অ্যাবাউট কত ডেজ 300 কত দিয়েছি অফ অ্যাবাউট সংখ্যাটা বাদ দিয়ে দাও কি বলেছি যে সেন্টেন্স একটু পড়ে দাও না বাবু। প্রথম দুটো সেন্টেন্সের মধ্যেই হবে হ্যাঁ সংখ্যাটা দিয়ে দেখো 300 সামথিং প্রথম দুটো লাইনের মধ্যে হবে
337 days.
কি কথাটা বলেছি ডিলে অফ অ্যাবাউট
Item number 33.
Yes. Yes, sir.
So the affidavit of service may be kept with the record.
আগেরটা লিখে affidavit of service file to be kept on. Yes, Mr. Manager.
Ex-parte degree I am challenging. I have filed order 9 rule 13 and as well as appeal. In appeal, there was a 157 days delay from the date of the decree.
Right.
Lordship, we have come to the knowledge of the degree is only from 4th of August.
You filed the order 9 rule 13 and the appeal simultaneously.
Lordship, why the enter
Honorable Secretary has a copy of the affidavit in opposition.
You filed it? Have you?
One copy, my lord, just say, Honorable Secretary, this copy is wrong. I was out of my system, mother had made that accident.
Let us see the copies.
I've given mine. The issue here was that here was if it is from my date of knowledge, my date of knowledge is after obtaining the degree, he served me the degree at my matrimonial, at my
This is a matrimonial suit
yes. So
against divorce decree.
against divorce. Now, Lordship, what happened?
Yes.
After obtaining the degree, my husband has issued the letter to my parental home. So from there, I have come to know. In the cause title, when
You never contested the suit.
I am not aware, I am living with my father-in-law.
Not that you filed written statement and thereafter did not. All right.
I am staying with my
So for the first time, you came to know from their communication. That is your case.
my brother.
All right.
When the plaint was drawn, plaint has given 2 addresses. One is my matrimonial address where I'm staying. I'm staying at my matrimonial place. Husband has shifted to a house just nearby. Filed a suit. I'm staying with my in-laws also. Filed a suit against me. Belief came to my house. Belief report says that no one is there and refused to accept. He goes back. The postal receipt comes there. It says goes back. The other address is my maternal home. There no service is being made. Service there is made after obtaining the degree. So, Lordship, what happened in this matter? Now, Lordship, I will take your Lordship to the plaint once. If your Lordship,
We are hearing the condemnation application first.
yes, but
So
I
let
have
us
to
say the
take-
condemnation application first. Let us get that
only-
over with.
Yes, Lordship. Only one annexure is there in Can 2. I would like to place that annexure once, and then I will take you to Can.
For the purpose of delay.
For the
Let us have the delay application first out of our way. Yes, so, Mr. Boral, what do you say to the delay? Yes.
Summons were served by two ways.
Hmm.
One by credit and one by postal receipt. The postal receipt was received, the postal document was received.
Mr. Ball, there is a distinction between having knowledge of a suit, even if they fail to succeed in the appeal or ordinance rule 13, and a knowledge of the ex-parte decree.
He has the knowledge of the suit.
For this section 5, she has to establish, you have to establish she had a knowledge of the ex-parte decree. Because even if I have knowledge of the suit, there are a line of judgments. Even if I have knowledge of the suit, pendency of the suit, I have to have knowledge of the ex-parte decree being passed for the purpose of section 5 in the appeal. For ordinance rule 13, you may have a point, but there also ordinance rule 13 also that is applicable, that principle. Mere knowledge of the suit may not suffice for, may not be a substitute for knowledge of the decree. So why section 5? Summons were served for the time being, it's arguable because that is the subject matter of the ordinance rule 13. So even if it proceed on that premise, then also there is nothing to attribute that they had knowledge of the ex-parte decree prior to your intimation. So why shouldn't the section 5 application be allowed at least? Of his own house. But your parents are there, she lived with them. So you have been thrown out by your parents also. Everybody else in the world is an enemy now. That speaks a lot about you. Section 5 has to be allowed. We are allowed in section 5, then hearing Mr. Banerjee on the other application. Can 1 of 2024 is an application for condonation of delay in preferring the present appeal. Full stop, next para. The appeal has been preferred against an ex-parte divorce decree obtained by the respondent husband against the appellant wife. Full stop, next para. Learned counsel for the appellant stroke petitioner submits that the knowledge of the ex-parte decree was derived by the appellant stroke petitioner for the first time from her brother, at whose address a notice had been sent by the learned advocate for the respondent intimating about the ex-parte decree. Full stop. Immediately thereafter, the appellant took steps and preferred the present appeal, and simultaneously, an application under Order 9, Rule 13 of the Code of Civil Procedure for setting aside the ex-parte decree. Full stop. It is submitted that despite the appellant wife having all along lived in her matrimonial home with her in-laws, whereas the respondent husband lived elsewhere, the notice of the ex-parte decree was not sent to the appellant. Full stop, next para. Learned counsel for the respondent husband submits by placing reliance on the annexure to his affidavit in opposition, that the appellant wife was served with a summons of the suit. Full stop, next para. Such contention is disputed by the learned advocate for the appellant. Full stop, be that as it may, even if we proceed on the premise for argument's sake, without accepting that summons of the suit were to have been served on the appellant wife, it is well settled that mere knowledge of pendency of the suit cannot be a substitute of the knowledge of the ex-parte decree having been passed. Full stop. In the absence of the latter, the knowledge of the ex-parte decree cannot be attributed to the appellant wife, and as such, in the absence of anything else to attribute knowledge of the appellant wife regarding the ex-parte decree prior to the intimation being given to her brother by the learned advocate for the respondent, we accept the contention of the wife that there was sufficient reason for the delay in preferring the present appeal. Full stop. Accordingly, can 1 of 2024 is allowed on contest, thereby condoning the delay in preferring FAT 324 of 2024. No arrest to cost. Now, the second application is your stay. Can 2.
They have not so far used any opposition to it.
Can 2 stay application? What opposition? I mean,
I don't know.
don't remarry in the meantime. Mr. Banerjee, we won't grant an order of stay since it's a judgment in rem. I mean, it may have other repercussions, but we'll injunct him from contracting remarriage during pendency of the appeal. Can 2 of 2024 is an application for stay of operation of the impugned ex-parte divorce decree. Full stop. Since the divorce decree is in the nature of a judgment in rem, we are not inclined at this juncture to stay operation of the same. Full stop. However, it would suffice for the ends of justice if the husband is restrained from contracting a remarriage during pendency of the appeal. Full stop. Accordingly, can 2 of 2024 is allowed on is disposed of on contest, restraining the respondent husband from contracting any contracting remarriage during pendency of the appeal. Full stop. The should you put in the special messenger cost, Mr. Banerjee?
Yes.
In view of appearance of the husband respondent through his learned advocate, service of notice of appeal on the respondent is dispensed with. Full stop. The trial court records be brought by special messenger at the cost of the appellant, which shall be deposited within January 10, 2025. Full stop. The learned advocate for the appellant shall prepare and file the requisite number of paper books within, we'll make it 6 weeks or 8 weeks.
You can give me a direction of an informal paper book.
We'll do that, but even then that has to be after the record. Some things, because we give it to the people who ultimately go through the records, although informal. If you want, how soon can you prepare it? But you have to annex all documents, all exhibits, everything.
Certified copy.
Everything. আচ্ছা, very well. আচ্ছা, তাহলে লার্নার্ড অ্যাডভোকেট যে লাস্ট সেন্টেন্সটা শুরু করলাম, ওটা কেটে দিয়ে লাস্ট স্পেশাল মেশিনের কস্ট ফাস্ট ওগুলো হয়ে গেছে।
We have annexed everything with the stay
ও
application.
আচ্ছা,
Lordship can keep it and can hear it.
very well. On the prayer of the learned advocate for the appellant, since all the materials relevant for the disposal of the appeal, including certified copies of the pleadings, evidence, as well as exhibits are with the appellant, the learned advocate for the appellants shall prepare and file the requisite number of informal paper books without comparing with the records by annexing all relevant documents within then January 10th, January 15, 2025. Full stop. Advance copies thereof shall be served on the learned advocate appearing for the respondent. Full stop. The appeal shall be listed for hearing on January 20, 2025. Yes.
But the matter where Mr. Mukherjee appeared, I was not there. He has wrongly stated that I am there. May kindly not report by name.
You are now here. Where were you?
I was engaged in courtroom number 35.
No. I asked him whether you were in the court premises.
I am there, but this is something I very strictly follow. Doesn't matter.
Thank you very much. Then, which is the item number? 31. তুমি নিয়েছো? 31 এ বিল্লদল ভট্টাচার্যের নামটা কেটে দেবে। হ্যাঁ।
Extremely grateful to you.
Thank you. Thank you, Mr. Bhattacharya. Fair enough. Oh, এত Yes,
Partition suit
right.
filed by sister against brother, brother and mother. Both brother and mother died. Now brother's wife and son is there.
Preliminary degree?
No, suit dismissed.
You're the plaintiff.
A suit dismissed on the ground that I am not the blood brother of my blood sister of my brother.
Now you want usual directions for expeditious.
And injunction, my lord, now suit dismissed. So
Injunction application is also there.
yes.
And one is for appropriate order.
Appropriate order for injunction. It's a family dwelling house.
Appearing for the first time.
First time. No caveat.
The present appeal has been preferred by the plaintiff in a partition suit against a judgment and degree whereby the said suit was dismissed. Full stop. Being satisfied of a prima facie case for hearing of the appeal on merits having been made out, and in view of the balance of convenience and inconvenience, and the factor of irreparable injury lying in favor of grant of injunction, the parties are directed to maintain status quo as regards possession, as well as regarding creating any third party interest and or from selling, transferring, alienating the suit property, or parting with possession in favor of third parties in any manner till disposal of the application. Stop. The petitioner shall serve copies of the application on the respondents, indicating that the application shall be listed for hearing on January 20, 2025. Full stop. Affidavit in opposition, if any, shall be filed by January 10, 2025, and reply thereto, if any, shall be filed on the next returnable date. The petitioner shall file an affidavit of service on the next returnable date.
Right.
Thank you.
Item number 35.
Please, your lordships, my lord.
Yes, please.
Section 5 application, my lord. Pursuant to lordship's directions, I have served.
You are appearing for the What is the delay?
But according to the department, it is 28 days, recorded in the order of the Lozima court.
Sorry. What is your explanation?
But affidavit is
What is your explanation?
trust. A trust is the plaintiff.
Right.
3 trustees were
This is against a dismissal of a suit for declaration. Then
3 trustees had represented the plaintiff trust.
Yes.
But during the pendency of the suit, one of the trustees died. The application was taken out. A new trustee was inducted. Application was taken out under Order 22, Rule 10. That was dismissed. Even the name of the deceased trustee was not deleted from the cost title. Decree was passed with the name of the deceased person in the cost title. But after the decree, I had made an application under Section 152 for correction. That was also rejected. That took some time. The delay as has been calculated by the department shows that the period expired within the vacation. And on the returnable, I mean the reopening date, I could not file the appeal. After 1 day, I had filed. So that effectively 1 day of delay.
Allowing the present appeal has been preferred against the dismissal of a suit, also setting up as a ground of challenge the dismissal of the plaintiff's appellant's application under Order 22, Rule 10 of the Code of Civil Procedure. Next para. Since, according to the plaintiff's appellants, the decree was passed inter alia in the name of one of the deceased trustees, the plaintiff appellant took out an application under Section 152 of the Code of Civil Procedure, which also met with dismissal. Subsequently. First up, the pendency of the said application is the primary reason for the delay. First up, apart from the fact that the limitation period for preferring the appeal expired during the subsistence during the continuance of a vacation, push up due to certain unforeseen circumstances as explained in the application, comma, the appeal could not be preferred on the reopening date, but one day thereafter. Push up, upon hearing learned counsel for the parties, comma, we are satisfied that sufficient ground for the delay has been made out. Accordingly, can 1 of 2024 is allowed, thereby allowed on contest, thereby condoning the delay in preferring the present appeal. Push up. What is the other application? Usual directions then will pass. Very well. Can 2 of 2024 is an application primarily for expeditious hearing of the appeal. Pushed up. Upon hearing learned counsel for the parties, can 2 of 2024 is disposed of by recording that in view of the appearance of the respondent through its learned advocate, comma, service of notice of the appeal on the respondent is dispensed with. Pushed up. The trial court records shall be brought by special messenger at the cost of the appellants, comma, to be deposited by January 10, 2025. Pushed up. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Pushed up. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing. Thank you. Thank you. No orders to cost check. প্রথমেই একটা affidavit of service file করে দিতে। Please give both your names, his name also.
Section 5 application appearing for the first time.
So Banerjee, what is the delay about?
29 days.
What is the other application?
Injunction application, my lord, arising out of an rejection of a probate application, my lord.
Very well. The appellants shall serve copies of can 1 of 2024 as well as can 2 of 2024 on the respondent, comma, along with a copy of the memorandum of the appeal, and file an affidavit of service on the returnable date. Full stop. The applications shall be listed next on January 7, 2025 for hearing. 7 January.
Milord, I am for the petition.
Yes,
It is my affidavit of service, Milord.
Good service affected?
Yes.
You're appealing, right. What are the applications for?
Milord, grant 2 is for section 5. There is inordinate delay of 19 days as per the
19 days.
Only in the 19 days.
They're not inordinate.
Milord, it is as per
Inordinate.
Inordinate, Milord.
So what is the appeal against?
Milord, it is a partition suit against the 2 legal hire. One Nepal.
No, partition suit was dismissed.
No, Milord. Primary degree has been.
Preliminary degree has been passed against that.
Milord, here the Nepal Paramanik is the father of the appellant and the respondent.
We'll pass the usual order.
Milord,
yes.
a stay application has been filed in CRAN number 1.
Yes, we are speaking about the stay only. After the condonation, subject to hearing your learned friend, we'll pass the usual order regarding the final degree not being drawn up. Yes.
Well, kindly take up the condonation of delay.
Condonation of delay application. Yes.
Well, see, my lord, there is no ground.
No ground.
No ground, my lord. And my lord, so far,
oh, yes,
it's an order of April.
Yes, you have disclosed no ground whatsoever. Why?
No ground.
You could have given one paragraph.
No sufficient cause, and lordship knows.
Where is the substantial? Where is the cause shown? You have stated there is a delay of about 19 days and such and such. Not a single line of ground. No, this application should be rejected then. Upon a perusal of the application for condonation of delay bearing can 2 of 2024, comma, we find that, comma, as rightly pointed out by learned counsel for the respondent, comma, there is not a single line of explanation. Pushed up, next para. Learned, on the prayer of learned counsel for the petitioner is directed to file a supplementary affidavit disclosing sufficient reasons for the delay with an advance copy to the learned advocate for the respondent. Such supplementary affidavit shall be filed within January 10, 2025. The application shall next be listed on January 15, 2025, along with Can 1 of 2025. The Can 1 of 2024. Please furnish some reason. If you can't find out any reason, ask your learned friend, he will give you reasons.
No, my lord. Obliged.
19 days delay, you have to give one or he's absolutely correct.
Lord,
Theoretically, we should have dismissed this application.
certified copy has came.
Give a reason, not a single
Yes,
line
Lord,
of
I'll
reason.
file
It cannot
the-
be so mechanical.
No, my lord.
He's absolutely right otherwise.
Yes.
Justice TVD's Bela TVD's judgment lordship have already.
Justice Bela Tripathi's judgment is there, yes. But Justice Bela Tripati says if he is not a vigilant, he has not even disclosed whether he is vigilant or not. Worse than that.
Yes.
Anyway, do this. Now this time if you fail, then you're gone.
Yes.
And pay half of your fees to him. Yes. Yes, 38. Yes, Mr. Aditya.
Application. Lord.
Pardon?
Section 5.
Section 5. Delay?
Delay of 51 days.
First time.
First time.
What is the other application? Stay. This is from preliminary.
No, my lord, this is out of my lord, suit decreed, my lord, of restitution of conjugal rights. Ex-parte.
Acha, very well. Very well. The appellant shall serve copies of Can 1 of 2024, Can 2 of 2024, and a copy of the memorandum of appeal on the respondent, indicating that the applications shall be listed on January 13, 2025 for hearing. Affidavit of service shall be filed on the next returnable date.
Lord, only one thing, Lord, allow me to use a supplementary affidavit to section 5. Lord, I have stated the ground that I have been notified of the decree on a later date by the my lord husband.
Not given the date.
No, my lord, I have not annexed the my lord letter by which it was in.
Very well. On the prayer of the learned advocate for the petitioner, leave is granted to the petitioner to file a supplementary affidavit to the application for condonation of delay on the next returnable date. A copy, an advance copy thereof shall also be served along with the copies of the applications and the memo on the respondent. The affidavit, this much.
My lord, I am for the
copy served. Where is the
appellant
affidavit of
plaintiff.
service?
I'm for the respondent.
Yes, my lord. May I file my affidavit of service?
Please. You are appearing for both the respondents?
Yes.
Right. Mr. Lakhmani, what is the matter?
My lord, first is a delay condonation application. Delay, my lord, is of
Which can is that?
Can 2. And delay is of 17 days.
What is the reason?
My lord, in between were the Diwali holidays, the Puja holidays. For nearly a month, I was unable to engage an advocate. And the impugned order was passed just a few days prior to
Yes,
the
what do you say to this?
vacation.
Condonation. Upon hearing learned counsel for the parties, we are satisfied that sufficient cause for the delay in preferring the appeal has been made out. Accordingly, Can 2 of 2024 is allowed on contest, thereby condoning the delay in preferring the appeal. Can 1 of 2024 is now taken up for hearing. The decree is one for eviction.
No, my lord, there was an MOU. This is effectively for enforcing the MOU. The defendant number 1 is the constituted attorney of defendant number 2, and the defendant number 2 is a tenant of a premises which comprises one flat combined into 2, flat number 15 and 16, small portions. So under the MOU, the tenant had given me possession of one portion of the suit property.
You are a licensee of the tenant.
Yes. And so I've been given possession of flat 15, and the adjoining flat 16 is still with the tenant. In terms of the MOU, within 6 months, I was to also be given possession of the other portion. And at the time of execution of the MOU, I had been given possession of my portion, which I'm in possession
15.
of today.
Yes.
And I have paid a sum of 3 lakhs.
For getting the other one also.
For everything. In terms of the MOU.
It's virtually for specific performance of that MOU.
In a way. Though the word specific performance is not used in the press. But my lord, in the meantime, and I've also been paying 2,250 rupees per month to the defendants on account of rent, which the understanding says as and when
I fully get the property, I will then start paying rent to the landlord directly.
Landlord was a party to your MOU.
No, landlord was not a party to the MOU.
Bad agreement.
Landlord is it's the estate of somebody. One of those cases, my lord, where you can't ascertain who the landlord is.
Even there.
And in the name of estate of somebody, somebody has been collecting rent
Why
for,
was it dismissed?
for years.
For non-joiner of the landlord?
No, my lord. So no dismissal at all. My lord, only, my lord, we sought a limited protection because
This is a
now the defendants are taking a U-turn. After having got into the MOU and taken money from us, now they're taking a U-turn. So they are not giving us their part of, my lord, the property which is in their possession, and they are hindering, my lord, with our ingress and egress. So the only prayer was
injunction?
Only prayer was, my lord, restraining them from interfering with my free ingress and egress in respect of the portion which has already been given to me. That is the limited prayer which I wanted.
Ad interim was refused.
Ad interim was refused. Now, my lord, in the meantime, my lord, we preferred this appeal. Before the court below, they filed an objection. In their objection in paragraph 6, I will show your lordship, they themselves have said that we are not disturbing ingress and egress. But the stance being taken on affidavit, my lord, is completely contrary to, my lord, the reality.
That's very well. If you take that stand, why don't we dispose of the entire appeal and the application, grant injunction restraining you from disturbing? We'll record
Lordship,
that.
there is no disturbance created on our part.
If you say that, then it cannot affect you even if you grant the injunction.
Yeah,
We'll record your objection that you are not disturbing.
We are not.
We'll
we are
grant
not.
that
There is
injunction.
nothing on record that we are disturbing.
If you consent, we can dispose of the main injunction in the court below and direct the suit to be expedited.
Lordship.
Should we do that?
Lordship.
But for that, we'll require your consent.
Lordship, I am not.
You are saying
disturbing,
that you are
but
not disturbing.
If the order is being sought for in this, I have nothing to.
Very.
Then, my lord, the injunction application itself.
Injunction application, the trial court will dispose of from here, and the appeal will expire.
No,
The
this
suit
would,
will
in a
expire.
way, be, my lord, admission upon judgment upon
Order on admission.
order on admission.
And steps are also being taken.
This is not an order of admission because they are saying they are not disturbing. Therefore, there is no cause of action for your injunction.
Your lordship will see
But
page,
anyway.
page 113 of the stay petition, page 113, paragraph 6, the last four.
But this we should not go before page 1. After page 1.
Right.
This is Calcutta City Civil Court.
Yes, my lord.
Thank God. Yes. Otherwise, the appeal would have to. Acha. Ja bolam tarpor.
Sixth bench.
The present appeal has been preferred against an order whereby ad interim injunction has been refused to the plaintiff stroke appellant. Push up the case of the plaintiff appellant, comma, in a nutshell, comma, is that there was a memorandum of understanding between the plaintiff appellant and the respondent number 2 stroke tenant in respect of the suit premises, comma, of whom the respondent number 1 is a constituted attorney. Push up in terms of the MOU, comma, it is argued that flat number 15 was handed over in the suit building to the appellant, whereas in terms of the agreement, comma, the adjacent flat number 16 was also to be handed over later on.
Lordship, kindly record that they are in possession.
My lord, adjoining.
Of 15.
Of 15. Adjoining flat, my lord.
Yes, that is
Both
what.
lordship. Both lordship.
Next para. Learned counsel for the appellant submits that although flat number 15 has been in possession of the appellant, comma, flat number 16 has not yet been handed over by the respondent. Pushed up. It is submitted that the appellant prayed for an injunction before the court restraining the respondents from disturbing the appellant's ingress and egress to flat number 16. So next para. Learned counsel for the respondents submits that the respondents do not have not created any hindrance to the ingress and egress of the appellant to the suit premises. So it is further submitted by the respondents that possession of flat number 16 as well as flat number 15 has already been handed over to the appellant, comma, which is disputed. So next para, in view of the above, comma, the short conspectus of the appeal boils down to the ingress and egress to the existing to the flat of which the appellant is at present in possession. Next para, in view of such questions of law and fact being involved, the appeal is required to be heard. The appeal will be heard on the grounds as taken in the memorandum. Next para. After the appeal is admitted, comma, on consent of the parties, comma, the appeal itself is taken up for hearing. In view of the short conspectus of the appeal being the ingress and egress, comma, as indicated above, and since the respondents are not disputing such ingress and egress rights, comma, we put a question to the learned advocate for the respondent as to whether we should dispose of the injunction application itself pending in the court below, comma, although the present appeal arises out of the ad interim refusal of injunction, comma, in order to expedite the suit itself, full stop. To such question, comma, learned counsel for the respondent submits on instruction that the appeal may be disposed of along with the injunction application pending in the court below, and necessary directions be passed for the suit to be expedited. Full stop. Next para, in such view of the matter, comma, formal calling for the records and other formalities are dispensed with, and the appeal is taken up for hearing. Full stop. In the light of the above observations, comma, FMAT 445 of 2024 along with Can 1 of 2024 are disposed of by restraining the respondents from disturbing the ingress and egress of the appellant to the suit property in any manner till disposal of the suit bearing title suit number 1669 of 2024 pending before the learned judge, 6th bench, City Civil Court at Calcutta, comma, District, Calcutta. Push up next para. The learned trial judge is requested to expedite the hearing of the suit. Full stop. It is expected that the suit itself shall be disposed of by the end of December 31, 2025. We are giving 1 year to the.
Milord, for the first time they've admitted today that they are not in possession of flat 16 either. The fact is that they are, has your lordship, but if that is the submission today.
But you have disputed that.
No, I'm disputing that. But when they themselves are contending that there's nobody, then there's nobody.
You have recorded
16.
whatever you have.
My lord, kindly appoint somebody to my lord, ensure that there's indeed nobody, and then I can get the place altogether.
Leave something for the trial courts also. They also are appointed. They are getting the salaries also. Why us only? Yes.
Your lordship will, my lord, then in view of the submission made, your lordship will grant me liberty to press for that relief before the.
Whatever liberty you have in law, you have.
Item number 40.
I respondent opposite.
Yes. So, could you please take a seat? We'll just.
I am appearing for the appellants.
Yes.
In this matter, the learned court.
This is also a city civil court matter.
City civil court matter, bench 6.
The appeal has not yet been admitted.
No, appeal has not yet been admitted, and application is there.
What is the matter?
It is from refusal of ad interim order of injunction.
What is the suit for?
The suit is for restraining the bank and DVC from encashing a bank guarantee, Your Honor. The trial court below has held that it is a very good case for going into trial, but has not passed the ad interim order of injunction, Your Honor.
Bank guarantee injunctions are not readily granted.
Your Honor, this is the equity is in my favor, and here, Your Honor, this is very much necessary because why the bank guarantee was granted. Your Honor, the bank guarantee was given for securing the future. The bank guarantee was given in September 2023. September 2020.
Bank guarantee given to DVC by you.
DVC by me. Yeah.
What was the transaction on
it was for payment of future bills raised by DVC. And average estimated bill was they have taken. It is written in the bank guarantee itself that average 3 months bill estimated bill they will take the bank guarantee. It is written in the bank guarantee itself.
Yes.
Now on that estimate.
For what? You are taking electricity from DVC?
Electricity from DVC.
Very well.
Electricity from DVC. And at that point of time, my business, I estimated that my business will go up very much. And as such, I gave the bank guarantee. One is
for because you were appealing for the bank.
For the
DVC. Bank has been served.
But I have served both DVC and the bank also.
What is the affidavit of service?
You know, I do not have a video of service. I have served both of them.
There was a scope of serving because this is the appeal has not yet been.
There is no scope. But
anyway, let us hear you. Yes, yes.
Or on 3 months estimation.
Then what happened?
For 3 months, there were whatever bills were there. I have regularly paid. In December 2023, my business went down, and from total 13 months period from October 23 till October 24, there are 13 months. Out of 13 months, 5 months there was no electricity, and for 5 months, because it was discontinued, and for 5 months there was no consumption because there was no production at all.
And for first 3 months, so, October, November, December 23, I have paid the full amount. And there was a clause, if the regular bill is taken, Your Honor, then it will not come more than 1 lakh or 2 lakh of rupees. But they have a clause that whether you consume electricity or not, you have to pay a minimum charge of 3,50,000, 3,25,000 or something. So that they started raising, and I have paid also. This is for the 5 months. Out of 5 months, I have paid for 3 months. Last 2 months, it is due. I am willing to pay that. I have offered that also. In the meantime, what happened? I told them,
Last 2 months, what is due? The minimum guaranteed amount.
Minimum guaranteed amount. Minimum guaranteed.
But the bills, what about the bills?
Bills I have paid.
There is no pending, pending bill now.
No, only 2
months.
2 months bill pending, and I am willing to pay that immediately. So what has happened on last occasion when the disconnection was there? I told them, since I do not require the electricity, you release my bank guarantee. So they said, you first restore your electricity, then I will consider returning your bank guarantee. I paid the money. I gave them letter to restore it. They restored it, and again they started raising me bills for minimum amount. And thereafter, they are not returning my bank guarantee. And thereafter, on 4th of November, they have again disconnected the electricity on 4th November 2024. So
have
they
you
will
surrendered the electricity connection? Formally, you have to apply for that in a particular format.
Your
you have
Lordship,
not surrendered the electricity, then
what they follow, if the electricity is disconnected, I surrender or not, they will not raise any bill. I am willing to surrender also. If I can give undertaking right now that I will give.
Unless you have applied for surrender and that has been allowed, till then you are liable to pay.
No, I am liable to. I am paying, but
so what is the apprehension of their invoking the bank guarantee?
They have already invoked. When I have filed the suit and the appeal, the invocation was not there.
So now this has become infractuous, then injunction. If it has been invoked and that is the injunction is sought, it has become infractuous.
Invoked, but the money has not been paid as yet.
Bank guarantee is an independent contract. We generally don't grant injunctions unless you show some fraud in the underlying contract, which there isn't.
The fraud is there,
and you have not yet applied for surrender. So where is the question of their, or injuncting the bank, because that's an independent contract between the bank and you.
Bank and contract is there, but the invocation is much more. They are going to make unjust enrichment of themselves.
No, you will
because
be entitled to
because the amount due is 6 lakhs and they are invoking bank guarantee of 2.34 crores, 35 crores.
What is the upper limit of the bank guarantee?
2.35.
That must have been commensurate with your 3 months minimum charges.
No, it is not. It is not. That is what.
Why did you give the bank guarantee in the first place then?
Because at that time it was like that. But in the beginning, when I gave the bank guarantee.
But at your whim, it cannot be reduced. The minimum charges cannot be reduced just like that. They can reduce that in the next circle. But that's a question which has to be gone into. But bank guarantee invocation is there is no scope of restriction.
If bank guarantee is not, if they take the money, then how will I recover my money? Because they are taking it. I will show from the papers, Your Honor. They themselves are showing the security deposit is only 83 lakhs required security deposit, but they have.
You have not yet applied for surrender, sir. Have you applied for reduction of the minimum charges?
Your Lordship, I have already paid whatever minimum charges they have charged. I have already paid.
You have a particular minimum charge. You gave the bank guarantee commensurate with 3 months, the coming 3 months minimum assured charges. Now, if you have not asked for reduction of that by making a formal application, nor have you surrendered the electricity, then they are entitled to that cover of bank guarantee. Why should
if the electricity supply continues, if the electricity supply does not continue, then there is no.
How can we apprehend it not continue? You have not asked for surrender, not asked for reduction even. At your whim, you cannot do that.
Your Honor, the electricity is already disconnected. Electricity is already disconnected, and I have paid up to date. No,
it has been restored again.
No, it has not been restored. It has not been. I am giving undertaking. Well, I will seek restoration. I will give fresh bank guarantee if required. Whatever security deposit is there.
Then why should, in the first place, why should this bank guarantee go? Let this continue then. If you give fresh bank guarantee instead of that, let this continue.
Your Honor, my business is not running well, and I am not going to continue with the business anymore.
say that definitely you are entitled to ask for a reduction in the minimum charges, or you could have asked for surrender. You have done neither till date. So there cannot be any reason for us restraining the bank from restraining the DVC from invoking the bank guarantee. That's an independent contract. Why should you interfere?
You know what, but the circumstances is like that. They are not the my bank guarantee amount.
You
They
should
are
have
not
applied for
entitled to that amount.
You should have applied formally under the contract if there is a provision for reduction of that minimum assured charges or whatever it's called. Let us hear Mr. Mukherjee on that. Yes, Mr. Mukherjee.
Kindly have a look at the Supreme Court order. I do not know why my learned friend says this. But the second figure of not 6 crore 82 lakhs is what not the Supreme Court directs them to pay to my client.
And the bank guarantee?
Bank guarantee is much lesser than this amount. And not they have not disclosed in the plain.
What is this challenge against? I mean, this context of
This is against an appellate order, the appellate order, the tribunal. Sorry. Fixing not the electricity.
They are not a party here.
They are. The MP is Lord one, and Lord Stilex, the petitioner before your lordship, is the second one. That's the reason I said that 6 crore 82 is what I have covered. There are two civil appeal ID numbers. Kindly disregard the first one, 48209 is not the petitioner. That corresponds to not 6 crore 82 lakhs.
Yes.
But this is in areas, it was directed to be paid 50%. Even the 50% is not covered by the bank guarantee. When I invoke the bank guarantee, they give a letter to the bank not to invoke, not to release the payment, and the bank is not happily in hand in gloves with them. But the letter
No, I am referring to the bank guarantee itself. My learned friend is saying, okay, with due respect, I am referring to the bank guarantee itself. What does this bank guarantee covers? What my learned friend is showing, whether this bank guarantee covers that or not. It is not covering that.
But if their claim as per this decrees, it exceeds your bank guarantee, I mean, why should you restrain them from invoking this? And this bank guarantee, let us see the language of the bank guarantee once.
But your lordship will kindly have a look into the regulation, Lord 4.2.7. I cannot invoke in view of the regulation. There is statutory regulation.
For any area.
Any from any deposit. If there is an area
4.2.7.
There is an admitted area.
I've got an extra copy for him. 4.2.7.
The distribution licensee may at any time appropriate such deposit in whole or in part in satisfaction of any sum legally due or owing by the consumer to the licensee, whether the supply of license energy. So, it is due and owing is 6 crore 82.
No, Mr. Balodia, no scope of interference. Sorry.
Not paid. Goes and file a suit, absolutely speculative suit without not disclosing anything about the Supreme Court or the appellate orders.
This claim of theirs is beyond the bank guarantee. Let them, they have
precisely, they are saying that also. They are also saying that this claim of theirs is beyond the bank guarantee. So the bank guarantee plus. You have filed an application for stay also. Yes. Both will go. FMAT 472 of 2024 is taken up for admission hearing. Full stop. Learned counsel for the appellant, plaintiff stroke appellant contents that the appellant has been regularly paying electricity charges to the respondent number 1, Damodar Valley Corporation, within bracket DVC, full stop, of late, due to a lull, LULL, in the business of the appellant, the electricity consumption was reduced. Full stop. Next para, the electricity connection was accordingly disconnected for non-payment of dues. Full stop. Next para, learned counsel for the appellant submits that the appellant is willing to surrender the electricity and to pay the dues. Full stop. However, since the DVC is threatening to invoke the bank guarantee, which was given in lieu of the coming 3 months minimum assured electricity charges, the said bank guarantee ought not to be invoked. Full stop. Next para, learned senior counsel appearing for the respondent submits that in terms of an order passed by the Supreme Court on October 24, 2024, in connection with the special petition bearing diary number 48209 of 2024, preferred by the appellant, the appellant had been directed to deposit 50% of an amount of rupees 6,82, 45, 973 in lieu of arrears of payment of electricity charges. Full stop next para, learned senior counsel places reliance on clause 4.2.7 of West Bengal Electricity Regulatory Commission notification number 52/WBERC dated April 2, 2013, where it is provided that the distribution licensee may, at any time, appropriate such deposit in whole or in part in satisfaction of any sum legally due or owing by the consumer to the licensee, whether the supply of electric energy to the consumer continues or has ceased, without prejudice to any other remedy to which the licensee may be entitled for recovery of such sum due or owed by the owed by the consumer under any other provisions of the Act, within bracket Electricity Act, bracket closed, or any other law. Full stop next para. Upon hearing learned counsel for the parties, we find that in terms of clause 4.2.7, the respondent number 1 DVC is well within its rights to appropriate the amount covered by the bank guarantee in question in lieu of arrears as well, although initially the same was furnished for the purpose of securing future payments. Full stop next para. That apart, a bank guarantee is an independent contract between the bank and the executant of the bank guarantee, and unless some palpable fraud or illegality patent on the face of the record in the underlying contract is made out, courts are loath to grant injunctions regarding invocation of bank guarantees. Full stop. Such a high case having not been made out by the appellant here, we are not inclined to interfere with the impugned order, whereby ad interim injunction to that effect was refused to the appellant. Full stop. Accordingly, FMAT 472 of 2024 is dismissed. Full stop. Consequentially, Can 1 of 2024 is also disposed of. Full stop. It is, however, expected that the learned trial judge shall expedite the hearing of the main injunction application and thereafter the suit, from which the present appeal arises. No rest.
Subject to my rights and contentions here, Your Honor.
What?
Because the Supreme Court order they are showing.
It is further clarified that none of the above observations shall be prejudicial to the rights and contentions of the parties in the court below at any stage of the suit or the injunction application, and the above findings are tentative, arrived at only for the purpose of the disposal of the present appeal. Thank you.
Mr. Rajashri Datta is there online.
I'm sorry, Marat. I was appearing virtually.
Yes, yes.
Great.
Item number 41.
On behalf of the appellant, my lord, am I audible?
Yes, Mr. Ghoshal.
My lord, I will be permitted to consume 10 minutes time to try to assist your lordship in the confusion created on the last occasion. The suit is for original suit is for eviction of under provisions and filed in 1990 on the ground of default on the government. Suit decreed ex-parte. And the ex-parte decree, no appeal was referred, but section 47 was filed. Section 47 was converted into 121 rule 101. That was dismissed by the executive court. Then appeal dismissed. Then before that, after that, we have come before a lordship. Now, the 3 points have been raised by my clients that so far as the tenancy is concerned, that is there is some discrepancy about the actual tenancy. Second point is that the original defendant, the suit was filed. My lord, kindly permit me to invite my lord's attention to page 13 of the stay petition.
Yes.
The suit is filed in the personal capacity of Ajit Kumar,
Ajay.
Ajay Samanto.
Ajay died. Ajit was only implicated. You say that apart from Ajit, you are also heirs, co-tenants.
Because our case is that actually it is the tenancy stood in the name of a partnership firm of Kumar and Ajay Samanto and others on the so that there is the basic wrong in the notice. Secondly, even if this is taken for granted that Ajay was added as a person in his personal capacity, on his death it was a suit under 2H of the 1956 Act. So all the years are necessary parties to be substituted. Instead of 9 sub years, only Okil was substituted to the exclusion of the other 8 years. That's the main point.
If the heirs were, if the tenancy was in the name of a partnership firm, Mr. Ghoshal, why should all the heirs of the individual heirs of the person be impleted?
That is
Or
my
the
another
partners
question.
represented the state.
I'm grateful, Violet, for posing me this question. That is another point on our part which was not specifically taken by my friends in the court below. That the very notice is bad. Kindly see the paragraph 2 of the
Mr.
page 30.
Ghoshal, you are trying to take the court, executing court behind the degree, which is not permissible in execution.
Violet, the question is that
This is not a new tenancy. You are new right. You are claiming. You are claiming to the original tenant.
The suit is not filed.
Sorry. Yes, please continue. Yes.
My correlative question is that issue is that the suit, had it been the fact that the suit is filed in the name of the partnership firm, situation could have been otherwise. But here the suit is filed in the individual name, not in the partnership name. So kindly appreciate, Lordship, which in this way I may be wrong and subject to correction by your Lordship. Whether
yes.
Whether the original tenancy was properly determined, which tenancy was determined, whether because the one room is the subject matter of the suit. Subject matter of the suit is 37A College Street. One room, 2 rooms converted into 1 room. It is nobody's case. Though there are references of this partnership firm. Bunch of challans are there. Showing deposit with the firm name. Now, because this question is obscure, whether the earlier tenant left the premises or vacated.
Mr. Ghoshal, in your section 47 application, there is not a single sentence whereby you say that partnership firm was the tenant. Not a single sentence. You say original defendant was Ajay. After demise of Ajay, apart from Akhil, others were also heirs, but only Akhil was impleted, substituted. Therefore, the decree is bad. Therefore, section 47, it is inexecutable. This is your only case. We have the section 47 before us, page 34, 35 of your stay application. This is the only case. So no case has been made out, no third party case has been made out. You claim solely through the judgment data. And not only that, you say that yes, you claim solely through the original defendant, and you say you are the other co-tenants or joint tenants or whatever you say, you are not implicated. So if your claim is through the main defendant, you claim through the judgment debtor. So basically, you don't have a third party case.
No, that is why it was converted. 47 was converted into 101.
Section 47, there is no case. Even you don't have a case under section 47, Mr. Ghoshal, because if Akhil was on record, even one of the heirs was on record, the estate of the joint tenancy was represented. The decree could not have been a nullity. If none were there, then suit would be a nullity. If it was in the name of a dead person, the decree could not have been a nullity. Therefore, no question of section 47 also. Neither 47 nor. You could have preferred an appeal against the main decree, which was your relief. You failed to take that, so you are gone.
I bow down to what has fallen from your Lordship. I cannot change the record. But the question is whether the matter which is a pure question of law can be raised at any second at this stage.
No, you are not even entitled to raise any question of fact, Mr.
I'm raising only this question.
No proof of partnership has been submitted by you. That was one of the findings of the trial court.
Kindly permit me to refer to page 4 of the petition.
There was a concurrent finding of the courts that you could not produce to furnish any proof of partnership.
My lord, kindly see the page 4 for a moment.
Page 4 of?
Of this stay application.
That is your pleading.
Yes, of course.
You are pleading in this appeal. That is
one thing
neither-
only, I follow my lord too.
Yes.
Kindly allow me to take back your lordship to again page 13. Not page 13,
Yes.
continuing page 14.
Yes, please. 14.
Kindly see paragraph 2. The aforesaid tenancy of the defendant was duly terminated by an ejectment notice dated 16 July 1989. That is there. So the purpose of notice is to terminate the contractual tenancy and the threat of suit. But which property or which contract was terminated by the original tenancy of the partnership firm was not touched even. Tenancy of an individual, a third case was person was notified instead of the original tenant.
No. No, Mr. Ghoshal, sorry. Nothing.
Because it goes to the root of the valid combined notice and is valid service is a partition precedent. Now, if the what tenancy was determined, tenancy of the partnership firm or of Ajay Samant in his
Partnership firm is not even in your section 47. Partnership firm story you are bringing for the first time here, and you sought to adduce certain evidence before the executing court, which was beyond the pleadings in the section 47 even. And the executing court held categorically that prima facie proof of relationship of landlord and tenant is the rent bill. There is no rent bill in the name of you, nor is there anything apart from the telephone bill in the name of Messrs. Kumar Samanto.
Chalans are exhibit 7.
There is no rent receipt in the name of the partnership firm, Mr. Ghoshal. The rent receipts produced by the petitioner stands in the name of Sukumar and Ajay Kumar Samanto.
That is the partnership firm name. That is exhibit 7.
No, farm name is Messrs. Kumar Samanto and Company. The rent receipts were in the name of individuals, Sukumar and Ajay Kumar Samanto. That is the finding of both the courts. Messrs. Kumar Samanto and Company was the partnership name, not Sukumar and Ajay Kumar Samanto. That was the finding.
But that is so, my lord. The question is that the rent challans have been marked exhibit 7. And the Akhil was taken to be the tenant because the trade license is standing in his name. That is the only logic given by the executing court.
That is plausible, one of the possible views.
So as the trade license is in his name, therefore he alone is the tenant.
Yes. No, Mr.
Kindly place page 21, paragraph 9. It is fixed of the other partner.
Other names and the original record kindly see.
Page 21, paragraph 9. Written statement filed by the defendant.
Yes, but then we are going behind the decree, Mr. Gupta. That is a part of the written statement. We cannot go behind the decree. You cannot challenge the decree in execution case. That is well settled. Very well. The present second
Lastly,
Mr. Let us pass our judgment now. The present second miscellaneous appeal has been preferred against.
Just a moment, finally come to page 24 of the application.
Yes.
Not here that this case was disposed of this order, my lord.
Yes.
None takes any step as
Yes.
per resolution passed by the local bar not to take up any paid.
Date is fixed for further cross-examination.
It was fixed 22nd May 2017. Thereafter it has been crossed. It was fixed on 24th April 2017. Kindly come to the next page, my lord. None takes steps.
Yes.
On 5th April, none appears on repeated calls for rent of justice case is heard on with cost ₹1,000 to be paid by the petitioner.
So why are you placing this?
My lord, I am coming.
Mr. Gupta, you cannot go on and on. Please end it here. Why are you placing this?
Because, my lord, I'll see the order passed by.
We have seen everything. There is no substantial question of law involved.
These orders are, my lord, without getting any party, this order has been passed by. That's why I'm placing.
You choose not to appear, then what can be done?
No order.
Then, my lord,
The present second miscellaneous appeal has been preferred against a judgment of concurrence by the executing court as well as the first miscellaneous appellate court. Full stop. The matter arises out of an application filed by the present appellants under section 47 of the Code of Civil Procedure, comma, in which the appellants had claimed that although this eviction suit had been filed against one Ajay Kumar Samanto, comma, on his demise, comma, only Akhil Samanto, comma, one of his heirs was impleaded, whereas the other applicants were also the heirs of Ajay Kumar Samanto, but were left out from the array of parties. Full stop. Next para. Now, during pendency of the matter, comma, the said application was converted to one under Order 21, Rules 97 to 101 of the Code of Civil Procedure, and accordingly adjudicated. Full stop. Next para. During arguments before the executing court, comma, the appellants took a plea that the tenancy stood in the name of a partnership firm, whereas the decree was passed in favor of an individual. Full stop. Next para. It is argued by learned senior counsel for the appellant that both the courts below overlooked the fact that the partnership stood in the name of the partnership, that the tenancy stood, sorry, in the name of the partnership firm, and that all the heirs of the partner Ajay Kumar Samanto were not impleaded. Full stop. Next para. However, comma, we are unable to impress ourselves to the effect that any substantial question of law is involved. Full stop. Next para. First, comma, the arguments regarding the decree being bad, comma, since it was the partnership firm which was the actual tenant as opposed to Ajay Kumar Samanto in his individual capacity, comma, is a case which is beyond the pleadings made in the section 47 application. Secondly, comma, in the event such question is sought to be reopened, comma, it would tantamount to the executing court going behind the decree, which is barred by all notions of prevalent jurisprudence in India. Next para. That apart, comma, the executing court came to categorical findings that the petitioners failed to produce any rent receipts in their name. Full stop. Documents of possession, comma, including certificate of enlistment, was found only in the name of Akhil Kumar Samanto, and as such, comma, it was accepted by the executing court that Akhil Kumar Samanto was the tenant in whose name the decree was passed. Full stop. Next para. That apart, comma, the pleadings of the appellants in the section 47 application and their arguments are mutually contradictory, comma, insofar as the former pleads only the non-impleadment of the original defendant Ajay Kumar Samanto without a whisper of any partnership firm being the tenant, whereas the contrary is argued during the application under section 47, comma, converted to one under section Order 21, Rules 97 to 101 of the Code of Civil Procedure. Which of next para. That apart, comma, even if one heir, one of the heirs of the original judgment debtor, comma, being joint tenants, comma, was impleaded in the suit, comma, the estate of the joint tenancy was sufficiently represented. Full stop. In such circumstance, comma, it cannot be said that the decree was a nullity, comma, and as such inexecutable within the purview of section 47 of the Code of Civil Procedure. Full stop. Next para. The appellants having failed to claim any independent title, comma, but having claimed through the non-impleadment of the heirs of the original defendant, comma, stand in the step into the shoes of the judgment debtor, and as such, comma, do not come within the ambit of Order 21 Rules 97 to 101. Push up next para. Insofar as section 47 is concerned, comma, as discussed earlier, comma, there is no case made out of inexecutability on the decree on the ground of nullity. Full stop. The grounds on which the present challenge is sought to be preferred could have been fit in an appeal against the original decree, which, comma, not having been filed till date, comma, the decree has attained finality. Full stop. Next para, that apart, comma, the appellants also seek to argue that the trial court had no jurisdiction to invoke Order 17, Rule 2 of the Code of Civil Procedure, comma, as reflected from the judgments of the executing court and the first appellate court, comma, which also goes to the root of the decree, and as such, it is beyond the jurisdiction of the executing court to go behind the decree to decide such issues. Push up next para. That apart, comma, there are concurrent findings of fact to the effect that trade license and telephone bill were in the name of one Messrs. Kumar Samanta and Company, but the certificate of enlistment stood in the name of Akhil Kumar Samanto, the judgment debtor, and previously electricity bill stood in the name of Ajay Kumar Samanto, the original defendant. Full stop. There were no rent receipts or any proof of possession in favor of the present appellants to have justified their claiming an independent title to the property. Full stop. Next para. In such view of the matter, comma, we find that no question of law, no pure question of law, comma, let alone any substantial question of law have been made out in the present appeal for the purpose of admission of the appeal. Full stop. Accordingly, SMAT 12 of 2019 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, Can 2 of 2019, bracket old Can 12768 of 2019 is also dismissed without an order to cost. Sorry, Mr. Yes, next.
I'm applying for the respondent. In the last day, you have directed to serve a copy on me. That is, I've laid by Shiv Shankar Banerjee.
Order 41, yes.
Yes, Your Lordship.
The appeal is against what?
Your Lordship, against refusal of an ad interim temporary injunction, Your Lordship.
In a suit for?
In a suit for declaration and injunction, my lord.
Declaration of a title.
No, Your Lordship, declaration that the show cause notice and the memorandum of charges that has been issued against me is non-est in the eyes of law, Your Lordship. Now, there are 3 suits that had been filed between the parties. I am an employee. I have filed suits against my employer. The first suit, Your Lordship, and there are other employees also who have also filed similar suits against the employer, my lord. The first suit was against an order.
Other employers also?
Other employees. Other employees.
They have filed similar suits?
Similar suits, Your Lordship.
Right.
Now, my lord, what had happened in the first suit, Your Lordship, we had filed against the order wherein we had been demoted, my lord. A major penalty.
You
was
filed
issued.
only one suit?
I filed 3 suits, my lord. This is my 3rd suit. This is my 3rd suit.
Why 3 suits? We don't understand. Same employer?
Same employer, same employee, my lord. I'm explaining, Your Lordship. Brief facts is required. Why? Because, Your Lordship, in the first matter, what had happened is a disciplinary proceeding was initiated against me.
Yes.
Ultimately, major penalty was imposed. I was demoted. I had filed a suit against that, my lord. There was refusal of temporary injunction before the lower court. Thereafter, my lord, we preferred an appeal. In the appeal, Your Lordship, there was an order which has been granted until further orders that no further coercive action shall be taken against me. Now, my lord, thereafter.
That means that you cannot be terminated.
I cannot.
Basically boils down to that.
Yes, my lord. Now, what happened after that? They had issued a letter.
Yes.
Which is, my lord, also part of the stay application pursuant to that, wherein they had said that I am going to continue to be there in the institution, my lord, without any designation. And I have been given opportunities to work in the way they have directed me, but I was not holding any designation, my lord.
But you are being paid your salary as
I'm
per the
being
last
paid.
rate.
I'm being
As per the demoted rate.
that I have to perhaps, my lord.
Very well.
take
Let
instruction.
us continue. Yes.
In the second, my lord, now this termination or this penalty that has been granted, my lord, is by the Director General, who also is the disciplinary authority.
This penalty means this withholding designation.
The first one, Your Lordship.
Yes.
That has been. Now, my lord, so we have, there is another cause of action later on, my lord. The second suit that we had filed, we challenged the appointment of this Director General's appointment in the institution, my lord. No injunction there also has been granted, my lord, but it is the lower court is in the session of the matter. It is
Appointment of
pending.
Director General was what locus standi do you have?
Your lordship, at that point of time, I, along with other employees and the current Director General, had applied, my lord. At that point of time, we had pointed out that his appointment,
The current Director General is
current Director General, we had challenged that by way of a second suit.
no, you had challenged the appointment of whom? A previous Director General.
This current Director General, your lordship.
All right.
This current Director General, my lord. Now, after filing that suit, your lordship, the court has directed them show cause notice against them, but no injunction has been granted, my lord. Why I bring these facts before your lordship? It is only after all these things have already happened, I receive another show cause notice. That is 1st November 2024. That is at page 28, my lord. Thereafter, my lord,
1st November
2024.
24.
Thereafter, my lord, I reply to the show cause notice, your lordship, and I take all the points. And
Show cause regarding a fresh disciplinary proceeding.
disciplinary proceedings
Right.
against him.
Right.
After that, my lord, on 28th November 2024, considering that my reply to the show cause notice is not satisfactory, a memorandum of charges, like a charge sheet, has been issued against me, my lord. Now, my lord, the primary prejudicial part of it, may I show your lordship, which is my major apprehension. In the human resources manual that is followed by the institution, there is provision of minor penalties and major penalties, your lordship. Now, if your lordship takes up paragraph 5 of the memorandum dated 28th November 2024 at page 55. Sri Ashim Kumar Shamanto, that is myself, is further informed that if he does not submit his written statement of defense on or before the date specified in para 2 above, or does not appear in person before the inquiry authority, or otherwise fails or refuses to comply with the provisions of major penalties of the INSDAC's Conduct, Discipline and Appeal Rules 2022, or the orders or directions issued in pursuance of the said rules, the inquiring authority may hold the inquiry against him ex parte. So already the intention that a major penalty, your lordship, I'm already demoted. I'm holding no designation. Now the only thing that can come forth is my termination. Now, therefore, I had no other option but to come up before the Honorable Court, your lordship, file a suit challenging the show cause notice and the memorandum of charges, my lord. Now, the impugned order.
But isn't it premature at this stage? I mean, because they have given only a charge sheet, a show cause, you have given a reply to that. Charge sheet has been filed.
Yes, your
They'll
lordship.
continue with the disciplinary proceedings.
Yes, your lordship, but they've already decided it is a major penalty. So my apprehension is this is going to be termination, because considering the facts of the case, when previous suits have already been filed, I had already been demoted, which is already in Honorable Court is in session of the matter, my lord. That
All right.
division, that appeal matter is not yet disposed of. That is my apprehension, your lordship. And the impugned order is at page 124. Your lordship, the second last paragraph, that is the operational part of the order. On perusal of the documents annexed with the petition, it appears that the Honorable Court in FM 89 of 2024 has been pleased to pass an order on 11 January 2024 directing not to take any coercive action pursuant to the notice dated 5th January 2024. And subsequently, vide order dated 5th March 2024, the Honorable Court has been pleased to direct the interim order passed on 11 January 2024 shall continue until further orders. And it is clear that the said order of the Honorable Court is against the notice dated 5th January 2024. And this is a fresh show cause notice which was issued on 3rd November 2024. And charge sheet has been filed pursuant to the said notice. And at this stage, no ad interim order can be passed without hearing adversary. Hence, the prayer for ad interim order of temporary injunction stands refused accordingly. So the only reasoning was that this is a fresh show cause.
Can you show us the two show cause notices? The first, which was coercive action, was stayed on which, and the present?
Your lordship, perhaps the first one is.
Next, second show cause notice is at page 20.
Is that she said?
And the reply is at page 60. Can you see the reply?
False show cause notice is
Not there. Because unless the charges are same, this does not come within the purview of the previous non-coercive order.
Yes, your lordship. Perhaps.
If it's a fresh show cause notice, the court is right, rather.
Your lordship, what has happened is, because of that, my lord, today my apprehension, my lord, kindly understands in the equity and the prima facie, my lord, I'm in a situation where the first thing that comes to my mind is there is going to be a termination. And inquiry, and I had challenged the appointment of the inquiry officer
Yes.
also in the previous matter, my lord. That
Right.
was also under challenge. And
But
also,
there you failed to obtain an interim order also.
yes, your lordship. And thereafter, my lord, I had preferred an appeal. And your lordship kindly sees, my lord, the memorandum and
What
the
happened to that appeal, second suit? Appointment of DG as what? The inquiry officer.
your lordship.
You challenged the appointment of
the director general. In
the appointment itself.
Appointment itself. That is
So
pending.
there you failed to obtain anything and you preferred an appeal. That appeal is pending.
There I have not preferred an appeal. No, there I have.
But ad interim was refused there also.
There we have not taken any further steps.
So you have nothing to show. I mean, to before the court to there is a handle before the court because you have been challenging the appointment of the DG as well as that major penalty granted regarding that show cause notice. You have a non-coercive, no coercive action order. That we can understand. But this is the fresh show cause notice. Yes, we cannot rule out maybe a vendetta because of that thing. That is the only thing which we have.
And also paragraph 5 of the memorandum of charges, my lord. There is no mention of minor or major penalties. It is directly major penalties. The memorandum itself expresses the intention, and my lord kindly sees the show cause notice and the charge sheet. Both are by the Director General and Disciplinary Authority.
Yes, all by that we have seen.
The General Disciplinary Authority, and he is the final authority. If your lordship also sees the HR manual, my lord. It starts from the conduct, discipline and appeal rules starts from page 42, your lordship. And at page 44, my lord, there is the provision of penalties where, my lord, minor penalties is also there. And on the next page at 45, major penalties. And major penalties is reduction and, your lordship, termination, removal, dismissal from service. And I'm already reduced, my lord.
But is there any provision that which there is in some of these manuals that if you have already suffered a minor penalty, then it has to be only a major penalty? There is nothing of that sort.
And I had suffered a major penalty on the last occasion because I had been demoted, my lord, under this.
Oh, right.
Yes.
So if on a second occasion you have a similar allegation against you, it has to be major penalty only then. So why are they wrong on that?
That is perhaps not there. That is
not there.
That is not there, my lord. The only the next paragraph is, your lordship, the procedure for imposing major penalties. That is the only procedure that is there for imposing major penalties in the manual, your lordship.
But you have already suffered a major reduction to a lower stage.
Yes, your lordship. And now I'm in service without any designation.
Is this a new allegation in this new show cause or the old allegations in a new bottle? Because that is one of the considerations before us, which is not clear from your application.
Yes, your lordship. That is one aspect, your lordship. But
you have not taken that point anyway. Have you taken that point in your injunction? Have you taken that point that on the self-same allegations?
No, my lord.
They seem to be new allegations.
That I have not.
Failing to repeatedly failing to. What was the date of the previous show cause? Let us just look into that. 5th of something. 5th of
the first show cause.
First show cause was January 5th, 2024.
This year.
So now, oh, they give a period after that. It's for a subsequent period.
Sir.
At best, no coercive action problem. I mean, subject to hearing, Mr. Banerjee. Yes, Mr. Banerjee, why shouldn't you dispose of the appeal if you say so? No coercive till that injunction is decided.
Have been a very good order that we will not give effect to. We will continue with my DP. Departmental proceeding will continue.
Yes, exactly.
Not give a effect. Now, see conduct. I will explain that. Let's come back to first this suit. Then I will go to other two.
Yes, Miss Singh, please take your seat. Yes.
Lordship, kindly come to page 64 first. The very allegation against me is vendetta. So 64 is 1st of March, 31st of March and 1st of April. When I set everyone's target for the year. So I fixed that target. In the entire petition, there is no whisper that the target was given beyond a human capacity or something. So kindly come to page 64. Lordship, kindly come to page 60.
Yes, we are there.
Lordship, now kindly see month-wise target report he has to submit. Then page 65 is the month-wise target that he has given. Now he failed in the target. Then when he failed in the target, then I have no other alternative but to issue him a show cause. After looking for 5-6 months, mid of the year. So in the November, I have given him a show cause. Now kindly see the show cause.
Where is that?
Show cause is at page 28, which my learned friend has shown.
Yes.
Lordship, show cause clearly states that what are the things he has not been done. 1, 2, 3, 4, 5. 4. Lordship has done.
Yes.
Lordship, I have clearly said that I have given you target on that time. That time you did not oppose. If you have got any issue with the target, you can always come back to me. Ki I am ill health. Maybe capacity is high, but I am not running a good health. I won't be able to achieve that target. There is no whisper on that. So, Lordship, now in the show cause notice, I have given him a direct attack to him that these are the things you have failed. Now, Lordship, kindly turn to reply, page 60. I will show two replies. First reply.
What is this? As per CCTV footage, you have been found talking to Mr. Someone
Yes.
who is sitting behind
Yes.
you for prolonged
Yes.
periods.
Yes. Lordship, what we do is, we try to assess whether the particular person is given his best of the time to the institute and he could not fulfill the job. Then we will amend ourselves, we will reduce the job.
So he has been gossiping. Right?
Lordship, he constantly, he keeps on fighting cases against different, I will show that. And then
So must have been talking against you with Mr. PD.
let him, we don't mind. Let him do the job and talk rubbish about it. I don't mind. Now all the times from the CCTV footage, I try to find out, maybe I am wrong. What I have assigned is incorrect. So I try to.
You remind us of 1984. Orwellian 1984, not calendar year. Big Brother is watching and people are talking to their co-employees.
If I fail to argue today,
failing
my
to
man maybe observing me today on the online.
You have a different job. His job is not to argue for his client before the office.
Lordship,
He can gossip.
Also
If you gossip,
supervise.
if you talk with your colleagues when you are sitting waiting for the matter, then why not?
In the lunch break, or he can for a while. But if a person constantly finds that he is only talking with two more brothers who are litigating against the institute only and giving no production to the institute, Lordship, then we have to take. It's not a law.
That is vindictive.
Look, let's understand how vindictive it is. But you kindly see another 2-3 documents.
Meeting targets is one thing, not being able to meet targets.
I have to see a man is working or not working.
But speaking with people who also are litigating against him.
Lordship, we have to see how he is spending. Let him chat the same thing after evening. Let him go out of my office and file 30 more cases. We don't mind. Now, Lordship, kindly turn to his reply, page 60. Lordship, kindly see, did he deal with, I put this question to myself, did he deal with any of the allegation there?
Let us see.
Lordship, kindly see. He is only talking about the man with who he is talking and he is filing the cases. Lordship, I will place the entire.
This is the reply to page 28.
Yes, 28. In December, an advertisement of Director General and Institute, such and such, surprisingly, any graduate was made eligible, though it was written technical graduate due to well preferred. However, surprisingly, a graduate of arts was selected at the post of this, such and 25 years. Means he is exactly, these are the words of that suit where he failed and where he chose not to file an appeal. Now, Lordship, unfortunately, myself, Mr. P.L. Rao, in the civil engineer, were among the unsuitable applicants. So, Lordship, the issue starts there. When the post of Director General was selected, they also applied. They thought that they are into the institution for a longer time, they will be given preference. Now, if they were not given...
They applied for the same post.
Yes. The entire story starts from there. Then he said that an arts graduate is given a preference than over this technical graduates. Now, Lordship, kindly see, it's a management prerogative to appoint the Director General. On 1st December, you have been assumed the post of Director General. By March 2022, it was clear to me that you have no intention to develop this institute. Your all direction was indicate that you wanted to stay with the Instack for a longer time. Obviously, performance of the institute would be diminishing naturally. My assume has been proved to be correct in 2024 when the management has decided to reduce funding of this by 25% because of lack of this. So he could not fulfill his target and then he is saying...
Like employer, like employee.
So someone has to.
Match each other. You should be placed with each other for long. That is one of the reasons why we should stay your hands. Let him be there with you. You match each other very well.
No, not when you see, interestingly, when you retain a person on a contract service, though if any of my PL Rao were punished, you were to stay there in a longer time without any hindrance. He said that we two are given out, so you will be. He is definitely working for the nation, not for his job. There is no reply in his job. Then, Lordship, kindly, I will skip one. You have targeted PL Rao first at his return to the management, highlighting your recruitment through misdemeanor and has faced the consequence of writing against you. You asked a seat permanent such and such. You have targeted me next. You have issued show cause notice in August 2023 being against me false charges. Then you brought for your
No,
own
that is a
friend and
prelude.
inquiry officer.
That is a prelude, Mr. Banerjee. Page 62, he gives a reply also to the pinpointed allegations.
I do not find any
These are also-
designation now.
Skip that. Just come to those where
I was in a charge of administration from this to this. You were revealed me from the assignment of administration without consulting with me. Even you did not feel it proper to let me know the reasons for this. So this cannot be a reply. You have conducted several meetings with employees, but you have not called me for any meeting. Reasons not known to me. So this cannot be a reply. Similarly, all employees got the message from you to avoid me from the official purpose. This cannot be a reply. A number of times I have shown interest to deliver lecture on different topics. You such and such organize such and such. You have delivered 4 lectures. Where I have delivered, you have not instructed me to give any lecture in any of the program organized by this since January 23. So I have not invited him for the lecture. That is different. I have submitted progress report of few projects where I am involved for the monthly activity, but you have excluded it purposefully. With notwithstanding the above mentioned, I have done job to the best of my ability to support many way of construction common facilities such and such Behrampur project under trust of such and such program government of West Bengal. I have new targets such and such with not publication because review is being made instant. I give you. These are not the charges against him. He had to approach the members to procure fund. He is more on the marketing.
let us come to the show cause once, Mr.
Now, Lordship, can you turn to the so-called?
Yes, please.
Very precise. Lordship, may I skip the paragraph 1 and then?
Yes, come to A.
A. The revenue generation is almost important target for the institution for his work. The area you carried maximum weightage among your tasks of the year. Please refer to our letter dated 4th April. Every month we have given a letter assigning you the tasks and target for the year 24-25.
What are the nature of the targets? Marketing.
Mostly, I approach to all still. Like Balaji is a small, so I will try to fetch Balaji.
What is his nature of job? This person.
His nature of job I am describing.
Achha. He has to approach.
He has to, on behalf of my organization, he has to approach to different steel manufacturing units.
Procure orders or something like that?
No, nothing. Only their membership. We are a cooperative society where different big steel industries are there. We are planning, we are into planning, we are into modernization, we are into formation. So now, Lordship, kindly come to this. During the period of June 2024, you were requested to collect 1 lakh and 3 lakh by September 2024. Though your individual initiative, you could not collect any amount of revenue against your target of 3 lakh for the April and September this year. Even no effort on your part in this regard has been reported to us. You have neither intimated there was any bundle realizing this target. Pause here for a moment. Lordship, a man, it's not in his hand to procure. So he will supply me in his show cause notice. I approach sale, whale, HCL, non-existing this. I issued them letter. I visited them. He has to leave his AC room and he has to travel to their company. He has to wait outside to meet his managing director to convince him. So in the reply, it should come that, sir, what you are talking about? See, these are the places I visited. I tried, but your organization is not that good, so they are not willing to come back and join. That could be a good satisfactory explanation. But here what he is saying is, no, his effort is not there. He did not issue an email. He did not issue a letter. He did not send his subordinates even. He is holding a post. He has a subordinate, his hands. So he can always say that what you expect at my position, I will not personally go. I tried with one meeting, but other meeting my team member has gone, tried to meet him, but they are refusing. That is also not the line of his reply. Now kindly come to the next. please refer to your letter dated, please refer letter where the fact that the target of this were assigned to you such and such financial year. Consider consultation with the founder member. At least one project has to be identified, taken up in during such and such. You have failed and no effort on this. So now the second part is the project. He has to take up some project in his hand. He has to give us a plan that I am projecting this. Like we do literacy campaign somewhere or something. So he has to say that I am organizing a seminar with these 5 parties. Even with my existing, he has not.
This is the only part probably which he has answered in at page 62.
No,
I have submitted progress reports of few projects, monthly activity.
Project report of the project which of my company. He himself could not procure a single one.
No, this is please.
Lordship, I will come. I will come.
At least one project was to be identified and taken up during Q1.
He
Whatever.
said, yeah, I identified this project. No, in the existing project which were going on 2020, 2019, he put his finger and said, no, I have contributed in that project. No, that was not his duty. Lordship, kindly turn to. Please refer to your later dated search. Assign this client month in context getting assignment for revenue generation. No visit or meeting with our regular or any new client has been made by you since April to September. Create such and such. Forget about new. Now he could have gone to my old customers to keep them happy. If I can't add a client to my chamber, I will try to keep happy with my existing client. That also he has.
Yes, we have seen, Mr. Manager. Next one also enroll, obtain 4 institutional members. No answer to that.
So, Lordship, that show us. Now, Lordship, kindly come to page 66.
Yes.
He is talking about my vendor.
66 is the present suit.
No, 66 is the suit where he targeted
Your appointment.
my.
Right.
Now, Lordship, kindly see the paragraphs and the averment that why appointment is bad.
Those have been quoted in the reply.
He could not succeed there.
Reply. In the reply, these have been quoted.
Lordship, what I am saying is what he could not succeed in the second suit.
Understood. Yes.
Then he immediately got to the third suit for stalling my that proceedings. Lordship, he can litigate, but he will not work. Now, Lordship, kindly turn to the order. Now, kindly turn to the order at page 78.
The present impugned order?
No. The order of the trial court in that
previous order we have seen 78 is no urgency to intervene without hearing adverse.
Lordship, kindly see, entire thing should have been happened. Now, show cause notice also not issued to me, only summon received by my client. 15 days show cause. He would have given a show cause to that, and if he would stay, then entire thing he would have enjoyed. So he did not issue the show cause to the injunction. I cannot appear in the injunction, sir, today. I have to wait till February to appear there. Lordship has got it. Now, Lordship, let's come back. Let's come back to order of the first suit, page 79, which my learned friend has relied.
Yes, seen that. No coercive action.
Lordship, now kindly see. Now kindly turn to the page. Page 81 and 82. And 84. Now what I have written. Lordship, what happened? Show cause. Then there was a charge sheet. Then there was a memorandum and the punishment. What he challenged is on 10th. First, I am not aware that he filed this case against me. I was not on caveat. So he could not obtain the order. On 10th, I am not aware. 10th, I wanted to serve him the document by email. 10th of January 2024. So I served him the entire thing. He took it. He did not say me that I am forwarding before the Calcutta High Court. Then he came back on 11th. He moved. When he was moving in 11th, he did not apprise the court that already order has been passed. Now, Lordship, what happened? Now he goes back on February 2022, Lordship, 2024, to amend the suit. And then ultimately, I also filed a vacating application because till that time I was not aware. So I came, I with all my bona fide, I thought that I should inform the court. So I came back to the court with a vacating application saying that, my lord, order cannot be implied because before I was communicated with this, we have passed that order. But still, to honor the court's order, we are depositing the difference of the money in a separate account. I am not giving him a designation because that designation I have removed him. So wherever and when I received his order, immediately I stopped myself there. By that time, whatever I have done, I have done. I have not undone the two, but I have stopped myself there. So I wanted to intimate the court.
And you are paying him the salary at that rate, the demoted rate.
Demoted rate in his hand, difference in the escrow account.
All right.
Now, Lordship, what I am doing is, then I thought that I will inform the court, Honorable High Court. Then before I could come to the Honorable High Court,
yes,
Lordship, they filed an amendment application before
Right.
the court bill. Now they have changed the entire character of the suit. Because now the question of show cause staying is not there in the first suit, Lordship. Now they are challenging the finality of the entire thing. Now, Lordship, they filed an application in the first suit for release of my money which I put into the escrow. On 7th of October this year, the court refused that claim. Because I have argued, my lord, he has preferred an appeal, now he has changed and modified his entire suit. Ex-parte, he changed the suit. I could not contest. So now after changing the suit, I said that I cannot raise that money. The court accepted. That order is also not being challenged. So the first chapter goes. Second chapter, he tried to hit my Director General because he was also a competitor. He failed. And then on the third chapter, he has come on the very same alertness. Now, Lordship, if a man who has really not worked, show cause notice did not contain anything, I could have understood that he has given a show cause notice, but the memorandum charge has been framed, ignoring his statement. I could have understood. What fallen from your Lordship that my client was really vindictive, I could have understood. But this is not. In the show cause who could not give a clear reply, that means he chose not to work. I'm not saying anything against him. It might so happen that he could not get a chance in a higher forum and then he lost his motivation to work. It happens with everyone. It can happen with me, my lord. In my life, it can happen. If I could not succeed in some exam, I might lose my motivation. It happened with him, but then ultimately stands there that he could not work.
Yes, Mr. Banerjee, let us hear her reply now. Yes.
Lordship can.
Ms. Singh, why should you interfere here?
Your
Go
Lordship,
to the injunction court. Your reply is, is a non-reply. You have not addressed the points raised in the show cause notice. How do you expect the court to prevent coercive action?
Your Lordship kindly considers also.
Even setting everything else apart, your reply says nothing, precious nothing. You have repeated your allegations in the suits.
Your
You have to
Lordship,
address those focused way, in a focused manner.
Your Lordship, what has happened here is, if Your Lordship kindly takes up page 81, my lord, over here, I have no designation. I have, and I have,
have no
also
designation.
I have also taken the point where I had been isolated, my lord, where I had not been able to attend or proper tasks.
Miss Singh, you are Miss Singh.
Miss Lala.
Sorry, extremely sorry. I've been. Ms. Lala, repeatedly you have been, the show cause notices have been issued against you. We can appreciate that. But at the same time, we could not find a single line in your reply which addresses the questions raised by them in the show cause notice. You say that you are wrong. Do you have this victim mentality cannot be reflected in a reply to a show cause notice? You may be actually a victim, but it's only your victim mentality all the way throughout your reply, nothing else. And his locus, he should not have been appointed a director. Are these replies? He has given specific bullet points that these targets were given, at least 4 institutionalized
Your Lordship.
orders. Nothing, no reply.
Your Lordship, here we had also challenged his authority, his jurisdiction to also issue that show cause notice. That
Maybe, but that challenge is already sub judice somewhere else, and you have failed to obtain an administrative order in the suit which specifically challenges his locus standi.
we have taken the point that the matter is sub judice, Your Lordship, and we
Sub
also
judice says nothing.
later on, my lord.
But there's a refusal of your identity injunction in there.
Yes,
Till
Your
date, you have failed to obtain. You have failed to satisfy prima facie even any court of law that this appointment is illegal or unlawful or something like that.
Your Lordship.
No order in your favor.
Your Lordship, that is a fact, Your Lordship. But then in this matter,
The least you could do is give a proper reply to the show cause notice, and then come up before the court to show your bona fides. We don't find any reason to interfere at this stage. You canvass your points in the court below, but your reply does not.
Kindly give some limited protection, Your Lordship. Kindly considers the
No.
fact that a mind has already been made up to issue a major penalty on me, my lord.
Not exactly. Let us come back to that once more. That is page 28.
Your Lordship, I have also, if Your Lordship kindly sees the page 62, my lord, and also notwithstanding of the above mentioned constraint imposed on me, I have done jobs to the best of my capability as mentioned below. So the
But these are
limited
extremely
work that
vague. What work have you done?
it takes up page 86 also. my
Yes, 86.
Page 86, Your Lordship, I have annexed electronic mails, my lord, where I have been, my achievements or whatever I could do, my lord, I have annexed those also.
These are your general achievements, but there were pinpointed
With regards
queries
to
to
this
you.
act.
Page 86.
Yes, Your Lordship. These are the papers that I have been,
But in your the body of your reply, there is nothing.
Your Lordship, the technical papers that I have
These
replied.
are pleased to inform you that your paper has been awarded the best paper. You might be a very good academic, but you fail to meet the targets. There is no reply to that. As rightly pointed out by Mr. Banerjee, you could have said that I met these clients and then I failed to procure orders. Nowadays, in modern this corporate world, I mean, you have to meet targets. We have to be aware of that. I mean, otherwise you are not there in the job anymore. But we extend as courts, we also extend our hand to people who are targeted unnecessarily without any basis. But these are pinpointed queries. Challenge to his authority apart. There you have failed to obtain any order. That suit is also pending.
Yes,
So you'll get your order there if you at all get your order. You have failed to obtain any identity order there. He at present he has authority or not authority will be sub judice in that suit. But now a specific show cause has been issued to you. Specific queries.
Your Lordship,
Now no answer to that.
Your Lordship, I could not have considering the work environment after the litigations that has
These
been
are
filed,
bad
Your Lordship.
excuses for a bad employee. Work environment, I am a victim. I have been, you don't have jurisdiction. These are secondary issues. What is your reply to these specific allegations? CCTV footage with Mr. RLPT is the worst possible allegation they could raise against you. We are brushing it aside. What about the others? Letters have been given to you. They have given reference. Q1, at least one project had to be done. At least 4 jobs had to be procured. What did you do to that?
Your Lordship, we have also mentioned in the show cause notice, when we could not participate in the meetings, Your Lordship, it was not possible for us to work in the manner, my Lord, that was expected of the institution. If I am being isolated, my Lord, and if I am not being properly assigned, Your Lordship understands that I am, Your Lordship kindly considers that as much as it may again sound like a victim, but then I'm also pushed from this side, I'm also pushed from that side. I'm being asked to do a task, but I'm not being assigned the task. I'm not being made to participate in the meetings, Your Lordship. I'm not being able to.
To come back to your reply,
Fine.
the reply, the page I forgot. What is the page number?
60, Your Lordship.
60. Please come there.
Yes, Your Lordship.
Just see what you have written there.
My Lord.
Show us one pinpointed answer to their queries.
Your Lordship, page 62, my Lord.
Up to the first 17 paragraphs, there is nothing. Page 62, let us come there.
Lordship, that is with regards to the jurisdiction of them issuing the show cause notice, my Lord, points we have.
Only that.
And then subsequently, page 62, Your Lordship.
And they still have jurisdiction because that you have failed to obtain any favorable order even on an injunction application in your suit regarding his jurisdiction, his authority. I do not have any designation now. You will agree with me that if your designation is withdrawn, you will be persona non grata. I was in charge of administration till such and such. You have relieved me from the assignment. Even you did not feel it proper to let me know the reasons for this unexpected act. Utterly unrelated with the questions. You have conducted several meetings with employees, but you have not called me in any meeting. Might not have. The target was given to you. The contours of the targets were given to you. You could have just did the work and told him. You could have thrown at his face that this is the work I've done. These dates I've met this clients, and this is I failed to procure an order. Nothing. You have not assigned me any specific project, but projects were referred to. And you were a senior employee there. You vied for the job of managing director along with this person, and you say that no specific project. You find out your projects, find out for clients. No interference.
Considers the major penalty issue, Your Lordship, that I have pointed out in the memorandum of charges. Kindly considers that, my
Yes, that was page.
That was, Your Lordship. Page
55.
55.
55, yes. What have they stated? They stated you is further informed that if he does not submit his written statement of defense such and such, or does not appear in person before the inquiry authority, or otherwise fails or refuses to comply with the provisions of major penalties of the such and such conduct discipline rules, or the orders, directions issued in pursuance of the said rules, the inquiring authority may hold the inquiry against him ex-parte.
Yes, my lord, there is no mention of a minor penalty or a question of a minor penalty here, when that is also a part of the manual, your lordship.
You already suffered a major penalty. After
Yes,
that,
your lordship, my lord, and there is no
so
provision
that depends on the allegations against you. If the allegations call for major penalties, then yes, major penalties, they can go directly to major penalty. There is nothing to indicate that they have to.
the disposal of the injunction
No,
application. my lord.
এখানে ইন্টারফারেন্স স্কোপ দেখছি না, আমি তো এমন কিছু নেই যাতে এটা প্রিম্যাচুর হয়ে যাবে এখন কিছুটা। ইনজাংশনটা এক্সপিরিয়েট করে দিতে বলছি। Injunction, to the injunction application, Mr. Banerjee, file a written objection, will fix a time limit, say 10th January, and we are tempted to ask you not to take any coercive action, but we are not doing it. But whatever steps you take will abide by the result of that injunction application. And so, Ms. Lala, no, at this stage, no. The present appeal has been preferred against a refusal of an ad interim injunction in a suit challenging primarily a show cause notice issued by the respondents on November 1, 2024. Push up next para. Learned counsel for the appellant contends that the appellant has been victimized, particularly since the appellant had raised questions regarding respondent number 3, the current Director General and Disciplinary Authority of the respondent number 1 institutes and his authority to issue the show cause notices. First up, in the first stage of litigation, the appellant had challenged imposition of major penalty by demoting the petitioner on the premise of a purported disciplinary action against the petitioner, in which initially ad interim injunction was refused by the trial court. Upon an appeal having been preferred, an ad interim order restraining the respondents from taking any coercive action against the show cause notice dated January 5, 2024, which was the genesis of the first suit, was passed by the appellate court. Next para. Subsequently, as a vindictive action against the appellant, it is alleged that the respondents withdrew designations from the appellant, and as such, the appellant is at present working in the respondent number 1 company, respondent number 1 institute, without any appropriate designation, and is being paid at the rate of the demoted rank. Next para. It is submitted that a second suit was filed challenging the authority and appointment of the respondent number 3, that is the Director General and Disciplinary Authority currently functioning in the respondent number 1 institute. Next para. However, in the said suit as well, the plaintiff stroke appellant failed to obtain any ad interim order of injunction. Next para. As a vendetta was taken up against the appellant by the respondents, in particular respondent number 3, a further show cause notice was issued on November 1, 2024, to which a reply has been given by the respondent, by the appellant. Without considering the contents of the said reply, it is alleged, a charge sheet was framed on November 28, 2024. Next para. Learned counsel takes the court through the said charge sheet dated November 28, 2024, which, in the form of a memorandum, refers to imposition of the provisions of major penalties of the respondent number 1 apostrophe s conduct, discipline and appeal rules, 2022. Next para. The very act of referring to the major penalties by bypassing the minor penalty provisions itself comma, it is argued, comma, is an indicator of the vindictive action of the respondents. Full stop, next para. It is thus submitted that unless a limited protection is given to the appellant, comma, the appellant apprehends that his services would be terminated, comma, since it is the only major penalty which is left to be inflicted upon the appellant. Full stop, next para. It is further contended that in view of the pending challenge to the very authority of the respondent number 3 to initiate such show cause notice and subsequently frame the charge sheet, comma, the respondent number 3 would be in a position, comma, being the judge, jury, executioner for his own cause. Full stop, next para. We are adding to your. But that is the tenor of your argument also. Next para. It is also contended that since the challenge to the authority of the Director General is sub judice before a competent civil court, comma, the further proceedings with regard to penal action against the petitioner on the strength of the impugned show cause notice dated November 1, 2024 ought to be stayed. The next para. Learned counsel appearing for the respondents controverts the very challenge made in the suit from which the present appeal emanates. Full stop. It is contended, comma, by taking the court through the reply to the impugned show cause notice that not a single specific allegation leveled in the show cause notice has been met specifically. Full stop. Next para. It is pointed out that the allegations in the purported reply to the show cause notice all are a repetition of the allegations made by the appellant against the respondent number 3 in the previous suits, comma, which have met with refusals to ad interim prayers of injunction at every stage by the appellant. Full stop. Although an order was passed by the division bench in connection with one of the appeals challenging the previous show cause notice regarding no coercive action being taken in terms thereof, comma, the present suit has arisen in connection with a subsequent cause of action, comma, being the show cause notice dated November 1, 2024, where specific and pinpointed allegations have been objectively made against the appellant. Full stop. However, comma, in the reply, comma, such allegations have not been answered at all. Full stop. Next para. Hence, comma, it is argued that there cannot be any present apprehension of any vindictive action against the appellant, comma, since the charge sheet formulates the specific grounds on which action has been proposed, inquiry has been proposed against the petitioner, against the appellant. Full stop. Next para. Upon hearing learned counsel and perusing the materials on record, comma, we find that at this stage, comma, the restraint order passed by the coordinate bench in a previous matter against the respondents from taking any coercive action was restricted to the previous show cause notice dated January 5, 2024. Pushed up, the present impugned show cause notice dated November 1, 2024 is on subsequent cause of action arising out of alleged breach of duty by the appellant with regard to certain further deadlines stroke projects assigned to the appellant. Full stop. Next para. There is prima facie substance in the contention of the respondents that the reply to the show cause notice rather reflects a victim mentality more than an objective reply to the specific allegations made in the show cause notice. Full stop. Next para. The argument that the respondents have formed a preconceived notion as to the guilt of the appellant is not justified in our view. Full stop. In paragraph number 5 of the memorandum of charges dated November 28, 2024, comma, although a reference has been made to the provisions of the major penalties of the conduct and conduct, comma, discipline and appeal rules, comma, 2022 of the respondent number 1, comma, the same has to be read in proper perspective. Full stop. It is stated in the said paragraph that if the appellant does not appear in person before the inquiry authority or otherwise fails or refuses to comply with the provisions of the said rules, comma, or the orders stroke directions issued in pursuance of the same, comma, the inquiring authority may hold the inquiry against him ex parte. Push up thus, comma, the appellant has not been deprived as yet of an opportunity of hearing as such, comma, semicolon দিয়ে, as such, comma, it cannot be said that the principle of audio alternative partem has yet been violated by the respondents. Full stop. The reference to the major penalties rules might or might not be justified, but it would be premature at this juncture to say that the respondents have wreaked WREAK, a vendetta against the appellant on the basis of such rules. Full stop. Even otherwise, comma, since the appellant has already suffered a major penalty by demotion from his previous rank, comma, it is not entirely unjustified, at least prima facie, for the respondents to refer to the major penalties rules for the purpose of issuing a show cause. Also, comma, it might very well be that in view of the nature of the allegations made against the appellant, comma, it is the major penalties which can now be invoked by the respondents. However, comma, all the above are merely in the realm of conjecture at this point of time, comma, since no coercive action or no inquiry has yet been concluded against the appellant. Thus, comma, in our opinion, comma, it would be premature to admit the appeal or interfere with the learned trial judge's order at this stage. Next para. However, comma, we make it amply clear that we have not entered into the merits of the matter at all, and it will be open to the learned trial judge, comma, while deciding any of the 3 pending suits or the connected interlocutory applications at further stages, comma, to decide all questions independently and in accordance with law without being influenced in any manner unduly by any of our observations made above. Full stop. Next para. Accordingly, FMAT 485 of 2024 and consequentially Can 1 of 2024 are dismissed without interfering with the impugned order. Full stop. However, comma, it is expected that the learned trial judge shall make all endeavor to dispose of the injunction application as expeditiously as possible, comma, positively within February 15, 2025, full stop. To ensure such expeditious hearing, comma, the respondents shall positively file the written objection to the injunction application in the court below by January 10, 2025, full stop. Although no reply is given in the trial court, but will grant you an opportunity. Reply, if any, shall be filed thereto by January 17, 2025. Full stop. No rest of cost.
My right of challenge the jurisdiction. My office is at Baliganj. So they file at City Civil Court.
We have not gone into that. You have raised that only after we pass our order.
Here, if I go back there and talk about the
You
jurisdiction.
did not take that point while we are passing the judge.
No, I said.
We have not entered into the merits at all.
Grateful, Your Lordship.
Item number 43.
And for the appellant led by Mr. Prantik Goswami.
We heard the matter at length. Then we'll cancel the part.
Rahul Karmakar is appearing virtually.
Yes, then what is the use of keeping the matter part heard? I mean, if a respondent has passed away, if you have not taken out, do you have instruction to appear for the heirs of that deceased respondent?
I'm led by Mr. Rahul Karmakar.
Which respondent has passed away?
His name is Ronjit Miller. There is no heirs. All of who are to be substituted, Miller, all are on record.
Why are you not ready today?
We have not obtained any instruction when he died and anything.
Whenever he died, if his heirs are already on record, it's immaterial.
Miller, I will file it.
So we should cancel. Yes, Mr. Karmakar, we can't hear you. Your voice is being broken. You should have pointed out. Yes, Mr. Kormgar, why didn't you point out earlier that one of the respondents have died? We have heard it for 3 days. 4 days, in fact.
No, no, my lord, he has died. Recently, he has expired.
Give us the date.
Recently expired.
When?
Lord,
It is pointed out by learned counsel for the respondents that one of the respondents have died recently. Push up next para, learned counsel for the appellant submits that although the particulars of the date of death are not known to the appellants, comma, the heirs of the said deceased are already on record. Full stop. However, comma, the appellants, the learned advocate for the respondents are directed to furnish the date of demise of the deceased respondent to the learned advocate for the appellant. Mr. Kormukar, furnish the date by tomorrow.
Yes, yes, I shall.
By tomorrow, full stop. Appropriate application in that regard shall be filed by the appellant by January 8, 2025. Full stop. The appeal shall be listed next on January 15, 2025, along with the said application. Full stop. Immediately after filing the proposed application, comma, the same shall be mentioned for being tagged along with the appeal by the learned advocate for the appellant. Furnish name by tomorrow, file application by 5th, by 8th. Immediately thereafter, try to file it before 8th. Immediately mention it so that it can be tagged along with the appeal. We'll dispose it off and continue with the hearing.
Right.
Thank you, Mr. Kormukar. And yes.
44 minute, I'm for the appeal.
শুরু করবো?
The lordship.
No, we were, yes.
The lordship are in 2 minds.
No, we are in 2 minds for some other reason because my learned brother, we have tomorrow.
Yes, yes.
After that vacation, then immediately after the vacation, the first 10 days, my learned brother will again be going to another circuit. So he'll be coming back only on 13th of January. So we are considering whether to start the and considering the size of the appeal and the stature of counsel for the respondent, we are in a quandary whether to start.
I think I need not say anything after the hearing of the other side.
It's so bad for them.
Yes.
Achha.
Your lordship.
Then we'll start
Because
the
I
hearing.
cannot.
Yes, Mr. Van.
Very
start.
short point.
What is that? Yes, it is very amply clear from the. No, very short point. You can see it's a short matter. No, he has changed. No, in my code, Mr. Banerjee does not do that.
Yes.
Ask Mr. Banerjee.
20 years back.
20 years back.
Now totally changed. Man.
And
Already-
I mean, in my code, Mr. Banerjee is very brief. I actually am telling you. And Justice Kumar has not yet got a taste of Mr. Banerjee's. No. Your matter is the next matter. Oh, no release. We'll continue. No. We'll continue hearing. Yes. No, it may flop suddenly. Mr. Banerjee's expression, Mr. Dutiman Banerjee's expression is not very conducive to long argument. Yes, Mr. Banerjee, what is the short point involved?
Well, according to me, not very short, my lord.
No, don't
I'll-
try to discourage us.
No.
We proceed undaunted by such trivial hurdles. We have handled better things.
My lord, on the last occasion, my lord,
What is the suit for? You are the plaintiff.
I'm the defendant.
Suit for?
I'm the defendant, my lord, in a suit for declaration and injunction, my lord.
Why FMAT and FA? Or it is FA?
It is
First
FA.
FMAT, then FA?
Yes. First, my lord, FMAT was.
What, rejection of plaint or what?
No. First, my lord, there was an order of remand, my lord, initially. This is FMAT, my lord, because, my lord, it's arisen from an order of remand.
Present appeal is against order of remand.
Present appeal is no. It was, my lord, originally. First, my lord, I'll just, my lord.
This paper book is regarding the previous matter.
No.
That's a very good. Continue. Yes, what
My
is
lord, I'll just, my lord, give a short indication, my lord, to your lordships. I'm the defendant in a suit, my lord, for declaration and injunction.
Declaration of title?
No. Declaration of, my lord, shares. Shares, my lord, of the plaintiffs which have, my lord, devolved upon the plaintiffs, my lord, allegedly from their predecessor interest. In my name.
No partition sought.
No, kindly, my lord, cease the prayer, my lord, the prayers then, my lord.
You tell us.
No.
No
the
partition sought.
No. No.
Then suit was what? Decreed.
Suit was, my lord, dismissed.
Then
Against
appeal?
that, they preferred an appeal. My lord, the Honorable
Appeal
High
could
Court, my
remand
lord, remanded it back.
On what ground?
That is, my lord, the moot question of law. Because, my lord, according to me, my lord, it's a closed remand. My lord, very limited, my lord, questions are to be involved, my lord, in the remand. And the trial court, my lord, according to me, the trial court, my lord, reopened the entire matter, my lord, and passed a decree.
Limited remand, limited to what?
Limited to, my lord, the schedule. My lord, according to, my lord, the plaint case is, my lord, that there are 5 schedules, A, B, C, and C, D, and E. A and B has been, my lord, devolved, my lord, from the father of the predecessor, my lord, from the father of the, my lord, the plaintiffs.
You are part of the same family.
Yes. And my lord, C, D, E, those are, my lord, shares which are, my lord, devolved upon the predecessor of the defendants. Those are in the name of the predecessor of the defendants. That is according to me. My lord, that is the plaint case. My lord, my case is, my lord, that the Honorable Court, my lord, remanded it back only on the question of A and B, not C, D, E.
Let us see the order of remand.
Yes.
Straight away.
Yes. On the last occasion, my lord, I started placing that, my lord.
Yes. Where is that? This which volume?
Hey, first volume, my lord.
First volume, yes.
Starts at, my lord, page number 153.
153, right.
Page 154, my lord, it effectively starts.
Yes. We can release the other matters. Other matters are released. Yes.
So far as item number 45 is concerned, well, the next matter.
Yes.
We kindly take it up for clarification. It's an ex-parte appeal. I am the appellant.
Your program is to take up Mr. Rai's appeal. That is the only that is the only program we have. Yes, yes, if you can dispose of matters, we'll take up and dispose of. So many matters are being disposed of in one hearing. You ask your juniors, Mr. Basu, what is happening here? So many appeals, frivolous appeals filed by on advice of people like you, which you are deciding within.
Like that.
We have grown like that later on. No.
Used to do this stuff. Then I went
Oh, you learned from me. That's a very good fitting reply, but we'll remember that. No, Mr. Rai, come back tomorrow. If you can take up the matter and decide it, then why not? Last day, so what? Last day also earn another fee.
Tomorrow I will be leaving.
Oh. No, Mr. Rai, keep somebody, ask for adjournment, we'll definitely grant. Just ask any of your learned friends, junior friends, we'll definitely grant. Last day, yes. Yes, Mr. Banerjee, yes.
Well, page number 154, my lord,
we are there.
Starting from, my lord. The first appeal is that the instance of the plaintiffs in a suit for declaration and permanent injunction is directed against the judgment and decree dated 31st of May 2004, passed by the learned judge, third bench, Civil Court at Calcutta, entitled suit number such and such, thereby dismissing the suit. The plaintiffs filed the aforesaid suit for declaration that they are joint lawful owners to the extent of 5/6 shares, having 1/6 undivided share of the total shares and securities left by one Swarup Bikas Sheth, who is the father. The predecessor interest of the defendants, and for further declaration that the defendants had no right to have those shares and securities as absolute owners thereof on strength of the extended succession certificate granted on granted by Act 39 case number such and such, arising out of such and such. The plaintiffs further prayed for permanent injunction restraining the defendants number 1 and 2, their main agents, from giving effect to or further effect to or from acting upon the extended succession certificate, case number such and such. Now, my lord, the case made out by the plaintiff appellant may be summarized thus.
These are shares in companies.
Yes.
All right.
One Sushil Kumar Sheth, the undisputed predecessor in interest of the parties, died on 20th September 1964, leaving one son and 2 daughters through his predeceased first wife, the second wife, and one son and 1 daughter through the said second wife. The only son through the first wife, namely Swarup Bikas Sheth, subsequently died on 22nd March 1971, my lord, the defendants are the heirs and representative of the Swarup Bikash Sheth, my lord, leaving his widow and one daughter. The plaintiffs are all the other heirs of Sushil Kumar Sheth, then his eldest son, that is Swarup Bikash Sheth, and the widow and the daughter of Swarup Bikash Sheth are the defendants in the suit. On the death of Sushil Kumar Sheth, Swarup Bikash Sheth, being the eldest son in the family through his first wife, was the Korta, and accordingly he took over the charge of all the assets left by Sushil Kumar Sheth and used to look after, manage, control and supervise all the assets of the estate of Sushil Kumar Sheth in his capacity as Korta of the Hindu undivided joint
So
family.
your father was the Korta. Your predecessor was the Korta.
That is what they claim.
Yes.
On the death of Sushil Kumar Sheth, an application was filed for grant of succession certificate for the purpose of receiving the debts and securities payable to the estate of Sushil Kumar Sheth. And the learned court, with the consent of other heirs, granted succession certificate in favor of Swarup Bikash Sheth to receive those debts and securities. Swarup Bikash Sheth got those debts and securities of different companies standing in the name of Sushil Kumar Sheth and subsequently transferred those shares in his personal name with the understanding that Swarup Bikash Sheth would hold those shares and securities and other shares left by Sushil Kumar Sheth, not for his personal benefit, but for the benefit of all the others, of all the other heirs, including himself. Having obtained succession certificate in Act 39, case number 212 of 1966, Swarup Bikash Sheth reinvested the entire amount so realized by him from different companies, bank accounts, life insurance corporation, etc., in his own name, and also used to collect monthly rental from different tenants from the estate of Sushil Kumar Sheth, and out of such total accumulation made various investment in different money growing scheme of different companies in his personal name for the benefit of himself and also for the benefit of other heirs of Sushil Kumar Sheth. Subsequently, Swarup Bikash Sheth died in 1971, leaving the defendants as his sole heirs and legal representatives, and after such death, the defendant number 1, being his widow, duly filed an application under section 372 of the Indian Succession Act for grant of succession certificate for receiving the debts and securities payable to Swarup Bikash Sheth in his favor, which was registered as Act 39 case number such and such. And in paragraph 4 of the said application, she categorically stated that the deceased left other near relations, namely his stepmother, stepbrother, 2 sisters, 1 stepsister, being the daughter of late Sushil Kumar Sheth through his second wife. Prior to filing of the said application for grant of such succession certificate, the defendant number 1 wrote a letter to the income tax authority informing her that her husband, Swarup Bikash Sheth, had only 1/6 share of the total dividend income out of the share and securities so left by him, and accordingly the appellate commissioner, assistant commissioner of income tax range AA, Calcutta, was pleased to pass an order holding inter alia that her husband had only 1/6 share in the dividend income. It further appears from the annexure appended to the application for succession certificate filed by defendant number 1 that the total debts and securities were divided into 5 categories. So far, item number, this is what I was pointing out. So far, item number A and B were concerned. Those were shares and securities of various companies inherited from Sushil Kumar Sheth. And so far, item number C, D, and E were concerned. Those were money lying in the personal name of Swarup Bikash Sheth in 2 different life insurance policies. Money lying with Excel India Limited in his personal name. It further appears that the defendant number 1 and 2 claimed only 1/6 share in item number A and B. Therefore, my lord, nothing as regards to C, D, E. Upon receipt of notice of succession case number such and such, 227 of 1975, the plaintiffs entered appearance therein and filed their written objection and categorically stated that the said application for succession certificate was not maintainable in its form, and this is Swarup Bikash Sheth, being the eldest member of the family of Sushil Kumar Sheth, duly invested huge amount out of the asset left by Sushil Kumar Sheth, and all the shares and securities standing in his name were so invested for the benefit of the heirs of Sushil Kumar Sheth. After filing of such written objection in the said succession certificate case being number such and such, the defendant number 1 found it difficult to succeed in the said case, and in such a situation filed an application definitely stating therein that she was inclined to obtain succession certificate only in respect of item number C, D, E, and accordingly the court granted such succession certificate in respect of those items.
This succession certificate has attained finality.
Attained finality. Afterwards, my lord, I filed an application for extension of succession certificate.
And this was on consent, my lord.
Yes.
We gave consent.
CDE, there was no difficulty.
There was no difficulty.
AB, my lord, 1/6. declaration in the earlier appeal was already
Yes,
passed.
yes, yes. Yes, please continue, Mr. Vani.
In the month of February 1996, the plaintiffs for the first time came to learn from searching of the court record that the defendant number 1 subsequently had obtained, this is what my lord, and extended the succession certificate in respect of the shares and securities, which were mentioned in the schedule of the share and securities on basis of further application under section 376 of the Indian Succession Act, which was registered as Act 39, case number 234 of 1995. This is one of the extension case. By praying for grant of extended succession certificate of all the shares and securities for which she had earlier abandoned her claim, and the learned court granted such succession certificate without giving any notice to the plaintiffs. The plaintiff therefore filed an application.
Yes, yes, you continue, Mr.
The plaintiff therefore
made a part.
Shivaji, let him finish. Yes, we understand. Yes.
The plaintiff therefore filed an application for revocation of the grant of extended certificate before the court below, but the learned court did not allow such application. A revocation case was filed and disallowed on the ground, my lord, that the order is annexed on the ground that the question of title, my lord, cannot be looked into. But the aforesaid action on part of the defendant number 1 is a cloud upon the 5/6 share of the plaintiffs in the assets left by late Sushil Kumar Shet, and as such the said suit was filed. The aforesaid suit was contested by defendants by filing written statement, thereby denying the material allegations made in the plaint, and the defense taken by the defendants may be summarized thus. Swarup Vikas Shet was never the Karta of the undivided family as alleged by the plaintiffs. Swarup Vikas Shet during the lifetime of Sushil Kumar Shet had been living in separate mess because his stepmother formed a separate unit along with other children, and Swarup Vikas Shet at that time left under the care of relatives till his marriage. All the share and securities standing in his name had been accumulated in his name from his personal earnings. Swarup Vikas Shet was a partner of Messrs. Sushil Kumar Shet and brothers, and he used to receive his remuneration. But there was a family business, a partnership family business, where this Swarup Vikas Shet was also a partner. That is what is coming out. Swarup Vikas Shet was a partner of Messrs. Sushil Kumar Shet and brothers, and he used to receive his remuneration therefrom and invested his savings to purchase the share and securities. The defendant number 1, being an innocent lady, put her signature on the application in succession certificate in case number 227 of 1975 without understanding the contents of the same.
It was your application.
My application, yes. My
So
case
you innocently put your signature.
My case was, my lord, that at that point of time, since my lord, this lady was, she was, my lord, being guided by the defendant, by my lord, the other plaintiffs.
By the plaintiffs.
By the plaintiffs. Swarup Vikas Shet got 1/6 share on the death of Sushil Kumar Shet, and after obtaining succession certificate, paid the 5/6 share of assets of his father realized by him on the strength of succession certificate to the plaintiffs, and got receipt in the presence of Anil Kumar Shet, his uncle. But subsequently, the plaintiff number 1 broke open the almirah of the defendant number 1 and has stolen away the said receipt.
No, we don't understand this. After obtaining succession certificate, she got the succession certificate regarding 1/6 of CDE. Paid the sorry, AB.
Talking about AB.
Now, after obtaining that, she paid 5/6 share of assets regarding AB must be
AB
to them.
To them.
Very good.
And a receipt was obtained, that was kept, my lord, that was safely kept. Subsequently, it was stolen, that receipt. At the time of hearing of the suit, the plaintiff.
CD you never claimed, right?
CD is entirely mine. That is what I claim.
Okay, all right.
At the time of hearing of the suit, the plaintiff number 2 alone gave evidence on behalf of the plaintiffs, while the defendant number 1 deposed on behalf of the defendants for the purpose. As indicated earlier, the learned trial judge by judgment and decree impugned herein has dismissed the said suit, holding that the plaintiffs failed to prove the shares standing in the name of Swarup Vikas Shet were really purchased from the money received from the estate of Sushil, by accepting the defendant's case that the death of Sushil Kumar Shet, his 5/6 share of money realized by Swarup Vikas was given to the plaintiffs on taking receipt, but subsequently the plaintiff number 2 has stolen such receipt. And this was disbelieved. This case was. Being dissatisfied, the plaintiffs have come up with the present first appeal. Mr. Dasgupta, learned senior advocate appearing on behalf of the appellants at the first instance, contended that there is no dispute that on the death of Sushil Kumar Shet, the succession certificate was granted in favor of Swarup Vikas Shet, the predecessor interest of the defendants. Mr. Dasgupta contends that there is no dispute that huge amount of share and securities lying in the name of Sushil Kumar Sheth were handled by Swarup Vikas Sheth on the basis of succession certificate. And as such, it is the duty of the defendants to show that the said 5/6 share arising out of those shares and securities were paid to the plaintiffs. Mr. Dasgupta contends that in this case, no prudent person will believe the defense of the defendant number 1 that such receipt was stolen from our Almira, although not a single complaint has been lodged before the police in this connection. Mr. Dasgupta thus submits that in absence of any evidence showing that either Swarup or the defendants paid the 5/6 share to the plaintiffs out of the total assets left by Sushil Kumar Sheth, the learned trial judge ought to have decreed the suit. The aforesaid contentions of Mr. Dasgupta were seriously disputed by Mr. Banerjee, the learned senior advocate appearing on behalf of the defendant numbers 1 and 2. Mr. Banerjee practically supported the judgment and decree passed by the learned trial judge and contended that the defendant number 1, being half-educated lady, was not aware of the contents of the application of succession certificate where so far as the share and securities mentioned therein are concerned, the defendants were shown to have 1/6 share. He therefore prays for dismissal of the appeal. After hearing the learned counsel of the parties and after going through the materials on record, we find that on the date of Sushil Kumar Sheth, all his properties devolved upon his 6 shares, including predecessor in interest of the defendants, each having 1/6 share. Subsequently, Swarup Vikas Sheth, the eldest son of and Shormishta, one of the daughters, through his first wife, died, and his heirs have been brought on record. There is no dispute on the death of Sushil Kumar Sheth. It was Swarup Vikas Sheth, predecessor in interest of the defendants, who got the succession certificate and was authorized to realize all the shares and securities and debts payable to Sushil Kumar Sheth. Therefore, as the holder of succession certificate, it was the duty of the heirs of Swarup Vikas Sheth to show that he had discharged such duty by handing over the actual amount received by him to the heirs of Sushil according to their respective shares. In this case, specific defense taken by the defendants was that such 5/6 share was given to the plaintiffs on the basis of receipt granted by them in presence of Anil Kumar Sheth, advocate, but subsequently the plaintiff number 2 had stolen the said receipt from the Almira of the defendant number 1 and after death of her husband. In cross-examination, she had, however, admitted that she could not remember at the date of the incident and no such incident was ever reported to the police. It is needless to mention that plaintiff number 2 has specifically denied such allegation in his evidence. But in spite of such denial, the learned trial judge proceeded as if Shamol, the plaintiff number 2, had not denied such event. Therefore, the findings of the learned trial judge that the 5/6 share of the plaintiffs realized by Swarup was paid after granting a receipt is perverse finding of fact, and no reasonable man would come to such conclusion from the materials on record. Well, the fact that my giving away the 5/6 share, that was as regards the A and B portion, that is disbelieved this far. The fact that such shares were not given to the plaintiffs would appear also from the conduct of the defendant number 1. It appears that after the death of her husband,
the schedule of the suit also includes CDE.
Yes.
Well,
it appears after the death of her husband, she applied for fresh succession certificate for receiving the debts and securities standing in his name. And in that application, the schedule A and B properties were the share and securities which were subject matter of the present suit. In the said application, she specifically claimed 1/6 share in respect of A and B schedule, and so far as schedule C, D, E and concern, she claimed to be full owner along with her daughter. In view of objection raised by the plaintiff, she abandoned her claim in the shares and securities mentioned in schedule A, B, and was satisfied with items mentioned in the schedule C, D, E. Subsequently, long 20 years thereafter, in the year 1995, she prayed for an extension of the certificate by claiming absolute right over those self-same securities and shares over which she abandoned her claim earlier, and such certificate was granted in her favor without giving notice to the plaintiffs. It is now settled law that mere grant of succession certificate in favor of a co-sharer does not vest such co-sharer with the title of the property, and it is duty of the certificate holder to distribute the assets to the heirs in accordance to the shares. Once we hold that the plaintiffs did not receive their 5/6 share in the property, it is the duty of the defendants, being the heirs of Swarup Vikas Sheth, to account for the assets dealt with him by virtue of the succession certificate granted in his favor on the death of Sushil. Although the learned advocate for the parties argued considerably on the question whether original shares held by Sushil were really transferred in the name of Swarup Vikas Sheth, we find from the record that sufficient evidence has not been adduced at the time of hearing as to the exact number of shares and securities held either in the name of Sushil or Swarup, and the learned trial judge did not come to a definite conclusion whether those shares were really transferred in the name of Swarup Vikas Sheth or are still appearing in the name of Sushil. This is what, my lord, the gamut of the dispute. Even the actual amount of money realized by Swarup by virtue of succession certificate is not brought to the notice of the court. In such a situation, we hold that the plaintiffs are entitled to get 56 share of money already realized by Swarup Vikas Sheth by virtue of the succession certificate granted in his favor, as nothing has been paid to them. In this proceeding, as the original shares could not be produced by either of the parties, indicating whether those have really been changed in the name of Swarup Vikas Sheth or not, we are of the view that the matter should be remanded back to the trial judge for the purpose of giving opportunity to the parties to lead further evidence on the aforesaid question. Therefore, my lord, the question of remand, my lord, is very limited. The scope has been kept very limited. Whether, my lord, those shares which were originally, my lord, whether those have devolved upon Sushil, what money has been realized till now, whether at all any money has been realized till now, only on this aspect. Parties are free to summon the concerned companies where those shares are lying for the purpose of showing the strength of the disputed shares as it stands today. If it appears to the court on the basis of such evidence that the original shares of Sushil are still continuing in his name and that those were not transferred in the name of Swarup Vikas Sheth pursuant to the succession certificate granted in his favor, the court will declare 56 share of the plaintiffs and 1/6 of the defendants in those shares. If at all, my lord, those are, my lord, it has not been, my lord, realized till now, then only. It appears that any new share was purchased, if it appears that any new share was purchased in the name of Swarup Vikas Sheth and the same is not the continuation of the original one standing in the name of Sushil, nor is such share a bonus share or right arising or right issue arising out of the share standing in the name of Sushil, nor was such share even purchased at a premium on the basis of the benefit conferred in the share standing in the name of Sushil, the plaintiffs will not have right in those shares. Very specific, my lord, this part. However, the plaintiffs will be entitled to get 56 share of the amount of money already realized by Swarup, if at all any, my lord, by virtue of succession certificate, and so long such amount is not paid to the plaintiffs, the said amount will remain charged over the assets of Swarup. The learned trial judge will further grant interest in favor of the plaintiffs over the 56 share of Sushil that will be found to be due from the date of realization of the amount by Swarup Vikas Sheth till the date of actual payment at a rate so fixed by him, after taking into consideration the then bank rate as well as the present existing bank rate of interest on which the parties will be entitled to lead evidence. The parties will also be entitled to lead further evidence on the question as to the amount of money actually realized by Swarup by virtue of succession certificate granted in his favor. Since the matter is pending from 1997, the trial court is directed to hear out the suit for the purpose of deciding those questions and for passing decree accordingly on the basis of evidence already on record and also on basis of further evidence that will be adduced by the parties on the basis of the order. We make it clear that we have decided the issue as regards the share of the plaintiffs in kindly, my lord, looks into this part. We make it clear that we have decided the issue as regards the share of the plaintiff in Sushil's property to the extent of 56, and we further hold that neither Swarup Vikas Sheth had nor his heirs have paid anything to the plaintiffs after realization of the amount, if any, on the basis of succession certificate granted in his favor, and the court will proceed on basis of such finding. The appeal is thus allowed to the extent as indicated above.
Now, Lord, after the remand, they did not adduce any evidence.
Yes, I did not.
In order to show that these are the particulars. Rather, we adduce the evidence, and Lord, on the basis of the succession certificate, Lord, he has withdrawn the entire money, and that has been, my Lord, reinvested in his own account, Sushil's account. Based on that, my Lord, decree has been passed. And those documents, my Lord, is paper book too. Marked exhibit.
No, my lord, may I take your lordship to the
Lord, 5-6 year
went after
declaration is already made.
Starts at, my lord, page 174. Now, my lord, what the learned trial court, my lord, so far, my lord, My humble submission be, my lord, the issue was very specific.
There is a decree from which this remand appeal arose.
Yes,
What is
that
that?
is,
The
my lord,
first
at
decree? Your suit was just dismissed.
109, page 109.
Page 109. Need not place it. You can start with yes.
Now, my lord, may I place, my lord, page 174 onwards, my lord, the judgment starts after remand. So the case has been narrated till 174S. From 174S, my lord, the decision starts.
One 174, yes. 174A actually.
Yes, my lord.
Yes, actually.
Yes. From A's, the decision starts.
All right.
From A, the judgment starts.
All right.
It is a number. No.
Put in later, that's right. The entire thing was put in later. 174S, yes. This is the impugned degree here. The judgment here.
Impugned judgment.
Yes.
Internal page 19, my lord.
Right.
But I'm starting, my lord, from page 20 onwards, my lord. Internal page 20, my lord. For the sake of convenience and to avoid repetition, all the issues are taken up together. It is admitted that earlier upon hearing, the aforesaid suit was dismissed by the learned court. The plaintiff preferred an appeal in the Honorable High Court at Calcutta, being FA number such and such. Upon contested hearing, the first appeal was allowed by the Honorable High Court at Calcutta by his judgment delivered on 9/12/2005, whereby the judgment and decree passed by the learned court on such and such was set aside, and the instant suit was sent back on remand, directing the learned court to hear the suit for the purpose of deciding some question which have been raised by the learned court on the basis of evidence already on record, and also on the basis of further evidence that will be adduced by the parties in terms of the order passed by the learned court. How my lord, the learned court has dealt with it. The issue was very specific, my lord. Thereafter, the plaintiffs again examined PW1 Shamol Bikas Shet in chief, and he has been cross-examined also, and the plaintiffs have produced some more documents marked as exhibit 20 to 31 collectively after objection and 32 respectively. But the defendants have not adduced any further evidence but have produced documents marked as exhibit A. In this case, the plaintiffs in total have examined 4 PWs and produced papers marked as exhibit 1 to 32 to prove their case on the other hand. Defendants are such and such. Now, my lord, page 21 I'm going. It is admitted that the plaintiffs, including what
These plaintiffs in total have examined 4 PWs, including the previous ones.
Including previous ones.
Now,
after remand, my lord, only one.
Only one. Right.
It is admitted that the plaintiffs, including one Sharup Bikas Shet, the predecessor in interest and title of the defendant, were or are heir, heirs, and legal representatives of one Sushil Kumar Shet, who died intestate on 20th September 1964, leaving behind him the plaintiff and the said predecessor in interest and title of the defendants, who jointly inherited the estate of the said deceased in equal share. Now, PW1 Shamol Bikas Shet is deposing for all the plaintiffs. He says that Sushil Kumar Shet was their father and he died on 20th September 1964, and he was a businessman. It is admitted PW1 further says that the time of his death, his father left his mother, 2 sons and 3 daughters, and the name of his brother is Sharup Bikas Shet, and he died on 22nd of March 1971. And all the legal heirs of his father were made parties in this suit. It is also admitted that PW1 further says that he left LIC policy, money deposited in bank shares of various companies, etc. It is not denied in cross. PW1 further says that after demise of their father, each of the legal heirs have 1/6 share with respect to the movable assets of the father. It is admitted that the Honorable Court has decided the issues as regards the share of the plaintiff in Sushil's property to get the extent of 5/6, and it was further held that neither Sharup Bikas Shet had nor his heirs have paid anything to the plaintiffs after realization of the amount if any, on the basis of succession certificate granted in his favor. PW1 says that he was aged 15 years when his father died in 1964. It is not denied. PW1 further says that excepting his elder brother, Sharup Vikas Sheth, there was no adult member to look after their family. And after demise of their father, Sharup Vikas Sheth used to look after the estate of their father on behalf of all the legal heirs. It is admitted. PW1 categorically states that Sharup was the Korta after demise of their father. It is not denied in cross-examination. I can take your lordship to the cross-examination.
You denied?
Yes. I'll just indicate, my lord. My lord kindly comes to page 96 once. This is, my lord, the evidence of PW2. The cross-examination of PW2, my lord, in commission. '96, my lord, page number 20, my lord, point number 25. This is what, my lord, has come out in cross-examination. Page 25, আইনের ভাষায় কর্তা কথার অর্থ কি আপনি জানেন? না, ও বড় ছেলে ছিল বলে ওকে কর্তা বলা হয়।
But that is before remand. Distinction is, my lord, before remand.
Yes, my lord. Since, my lord, the learned trial court
is showing before remand.
Yes, certainly. My lord.
After remand, my lord, is specific evidence given, no cross-examination. That he wanted to mean that.
My lord, since, my lord, the learned trial court as well as specific. Well, since the learned trial court as well as specifically stated, my lord, it is admitted the Sharup was the Korta, this is admitted. This is not denied in cross-examination.
Immaterial.
All right.
No Korta, 5-6 has been declared.
PW1 further says that his brother Sharup Vikas Sheth filed the succession certificate before the district delegate at Shialda court with respect to the movable assets of his father. It is admitted. He further says that in the schedule of the said application, the details of the movable assets of his father were duly mentioned. It is also admitted. He further says that they were made party as near relation in the said application and they have filed no objection certificate in granting succession certificate. Page 22. Succession certificate in favor of the said Dada. It is admitted. He further says that on his basis of the said succession certificate issued in favor of his Dada, it is also admitted. PW1 categorically says that he also received money from LIC and his Dada was collecting rent. Well, kindly, my lord, marks this portion. PW1 categorically says that he also received money from LIC and his Dada was collecting rent from the tenants who were inducted thereby by their father with respect to the residential house, and he used to grant receipt to the tenants by putting his signature. No suggestion denying the same has been put to him. He further says that they filed the said counterfoils of the rent receipt and the money so collected by his Dada was deposited in his own name in Chartered Bank at NS Bose Road and UBI branch and at NS Bose Road. He further says categorically that the transfer of shares were also done by his brother from the above named banks from his personal account, and he has filed the statements of account of those banks and the matured value of the LIC policies of his father which were collected by Sharup Vikas Sheth were deposited in his personal account of Chartered Bank. He has filed the purchased vouchers of the shares and those were purchased by Sharup Vikas Sheth. PW1 further says that the shares transfer were made on basis of the money received from the estate of Sushil Kumar Sheth and Sharup Vikas Sheth never invested any amount from his personal account regarding purchase of and transfer of share of his father. PW1 categorically says that Sharup Vikas Sheth has no substantial source of income. PW1 further says that after demise of Sharup Vikas Sheth, the legal heirs, that is the defendants, claim succession certificate with respect to movable assets left by him. It is admitted. PW1 further says that it was numbered as it was numbered as succession certificate case number 227 of 1975, and the same was filed before the Chief Judge Civil Court, Calcutta, and they were also made parties in this case. They filed the application along with succession certificate, and they have received notice in that case and filed objection in that case. It is admitted. It is admitted.
Let us
PW1
stop here. We'll continue after tomorrow. Let it be part. We'll continue tomorrow.
tomorrow, my lord.
Difficulty. Yes, Mr. Banerjee, then after the.
My lord, immediately on the reopening day, my lord.
No, we cannot do that because Justice Kumar will come back on 13th.
Yes.
It has to be on 13th. So your portion is almost over. What is left?
Nothing, my lord.
Some bit of thing, my lord.
Come back tomorrow. What is the difficulty?
My lord, I'm
Let him come, my lord. It is short
following my
matter.
senior, my lord.
Will not be here. Heard in part for further hearing. Heard in part for further hearing on January 13, 2025.
Senior কি আছে?